on the Towel YouTube. It is great to see so many of you this morning. Good morning. It's a big day. It is a big day. There have even been developments somehow before the day started. It is 8 in the morning. I just am starting, and there's already a new document that dropped related to Kate Peter discovery. So before we go any further, hello, I'm a towel. Play the intro, please.
Hold on. Wait a second. That's it.
That's it?
Yeah, that's the melody of the funky town.
You heard the towel. Hey, that's me. Oh, goodness. I'm a little towel. Now, good morning. We were going to start at 9 today. I figured, we'll just go into the old Brian Walshe trial coverage and I'll be a little towel. But no, ladies and gentlemen, we are not going to do that because we have a few things. First of all, I have to be up way past my bedtime today. You're going to get double towel today. We're going to end this stream after the Aidan Kearney hearing. Then we're going to start again because Social Change Warrior and I are going to be having a very interesting discussion. Amiable and respectful, that's going to be broadcast on this channel and Social Change Warriors channel, and that's going to be at 8 p.m. Eastern. All right, so whatever happens today, and I also think Social Change Warrior wants to put it in papers, mister. Good morning, 3 Clerk Monty. I think Social Change Warrior wants to discuss a lot of interesting facts, and I'm very interested in just the facts. I don't care what you believe about the facts. You can believe whatever the hell you want to believe. I want to hear why you think certain things connect together, and then I want to tell you I think certain things connect together, and then I want both of us to say that's interesting. We may disagree on the conclusion, but where does our overlapping perspective lead to new insight? You see what I'm saying? Discursive legitimacy made manifest. Good morning, Jay and Nancy. How are you all doing? You ready for the big day today? Just so folks know, I had a motion go up on the docket, and it was approved, ladies and gentlemen, allowing Little Towel to broadcast today's 2:15 p.m. Aidan TurtleBoy Kearney hearing. Now, before we dive into all that, first of all, the Walshe trial doesn't start till 9. We will be watching the Walshe trial all morning. It ends at 1 p.m. unless, as Judge has told us, there will be some kind of issue requiring the court to go past 1 p.m. But let's look at a few things today. One, I want to show you this wonderful image that I made, and then we'll talk about the new discovery that just went up, the discovery notice that Dee Dee just posted. Dee Dee's part of Team Rocket Stars. Dee Dee and Kyle Sharkey. Kyle is also a very nice person, and I'm grateful to have his input on a lot of these dockets as well. What Kyle does is Kyle and I are similar. I don't know Kyle that well. I talked to him. He's a nice guy. But Kyle monitors the docket, and Kyle and I just have public mass courts access. So, but I don't think Kyle is around here, so he can't just drive to the courthouse. I can drive to the courthouse. So sometimes we have to call in Team Rocket Stars, and I have to go down there and get the document. Other times, Dee Dee, who's probably the most efficient member of Team Rocket Stars, she goes and just posts the documents, all right? And I don't ask questions. I'm just pleased she posts them. So what I want to show you is a few things. One, the new document that just went up. And also, look at this wonderful, amazing, ladies and gentlemen, image that I made. Now, you might be saying to yourself, Towel, you've outdone yourself this time. Yes, I have. Yes, I have. I'm an artist of the highest caliber, ladies and gentlemen. You may call me Towel Michelangelo. All right? Let me paint the Sistine Chapel. Pete Bunny Towel, I by accidentally potentially slept on him as a pillow last night. It was not on purpose. I put him somewhere other than his regular place. I put him on the bed, and I put a pillow over him and didn't realize, and then I slept on Pete Bunny Towel. I feel terrible for him. He was a little cranky this morning. He does not like that. He's not necessarily a fan of that at all. And I must say I understand. I was very uncomfortable. He's not a pillow. He's a stuffed Pete Bunny. Yes, exactly, 3 Clerk Monty. But now take a look at this image. What do you all think? Should we put it in the Sistine Chapel? You can clearly see this is Towel, although the hearing will be on Zoom, this is Towel's artistic rendering of what's going to happen at 2:15 p.m. Eastern today. So first of all, you got little Towel sitting up there. You see me? I'm just sitting up there like a little towel. Then you got Lindsay jumping over this fray, and we'll circle back to that in a second. And then you got TurtleBoy there. You see him. He's got some documents. And you got Bradle, Betterow combined combined into one guy who's in a suit. Then on the other side, it was supposed to be Cosgrove and Tully and Proctor, but it somehow turned into Jen McCabe, Tully and Proctor, with Kate above them all holding a set of green strings, like puppeteering and also creating a web. And then her eyes are green, and then some of the people she has under her spell, their eyes are green. Isn't that wonderful, little towels? I'm a little towel. And then you have Lindsay jumping in there. This is why this becomes very relevant, because Lindsay has released on social media and through other mechanisms into the court record documents indicating that one of the central elements of today's Aidan TurtleBoy Kearney hearing, whether or not the state fully released discovery related to Kate Peter, who's a PI, who's a longtime nemesis of Aidan Kearney. Kate used to work with Aidan. They had a falling out. If you take Aidan's story, just explaining both stories, not passing judgment on what actually happened. Aidan says Kate took money and got fired. Kate says she wanted to go out on her own or something, and Aidan didn't like it. And I don't know. The point is, they both used to work together. Clearly know a lot of the same tactics. It involves like being involved with police and like I don't know. They do their thing. Like I don't know. It's complicated. I don't want to go into the whole history. So when Kate went out on her own, she started covering like First Amendment auditors, who of course target police. They like go up to police and record them to induce a reaction out of the police. And then Kate would meta troll the First Amendment auditors. A famous example is Chili DeCastro. Then Kate would also cover like the weird guy like Cyrax, who's like kind of weird. And then Kate would like expose him, and then he would like have a meltdown, and then Kate would laugh at his meltdown. Okay, it was like all. That was like Kate's shtick for between when she left Aidan's channel and when she became her own thing. Then the O'Keefe case happens, the Karen Reed and O'Keefe case, and Kate, after Aidan gets involved, maybe like 4 months after, Kate becomes involved in the fall of 2023, roughly, and starts communicating directly with the prosecution team. At the time, the Norfolk DA, Michael Proctor, Brian Tully, Yuri Buchanan, etc. Kate creates this Discord. It has all these like family members and Jen McCabe and people involved with the Reed trial, and it's very private. I think like Proctor's wife or something. It's very intimately connected. And what happens is, I think Kate was working for a PI at the time named Marty Kraft, who no longer has a license as of a few months ago. And Kate kind of clearly became like a mechanism to counter some of Aidan's tactics, because the Norfolk DA's office was overwhelmed with Karen's use of Aidan as a successful PR tool to change the dynamic of the Reed and O'Keefe case, all right? That's my opinion. And so by deploying Kate, the thing is though, Kate, they were being like they were just throwing caution to the wind. Kate was just like emailing the Norfolk DA, emailing Tully, etc., and Yuri Buchanan, another member of the state police unit assigned to the Norfolk DA's office. Same ones that investigated Karen Reed, same ones that covered up Sandra Birchmore's murder, in my opinion, to protect Matt Farwell, or whoever the hell Farwell knew, and the same unit that is investigating Aidan Kearney. All right, so Morrissey recuses in October of 2023 from Aidan's cases, okay? Morrissey appoints Ken Mello as a special prosecutor. Who does Kate Peter start talking to immediately in email, very brazenly, and on the phone? Ken Mello. Now, as these cases wind their way through, the TurtleBoy case, etc., over the past few years, you had a situation wherein Mello's health became an issue, so Ken Mello wasn't really involved in the case. In March or April, right around there, I think what happened was Cosgrove was approached in March. He went to a meeting in April with a bunch of the people on the case. They decided Cosgrove was going to assist Mello, but in reality, Cosgrove just took over the cases. Now, this is relevant because in March or April of 2024, Lindsay Gattani, who was a witness involved in some of the cases related to Aidan Kearney, Brian Tully released an unredacted production of Lindsay Gattani's cell phone. Why does that matter? Well, because first of all, Tully did, we come to find out, remove some stuff from that extraction. At the very least, messages from Tully to Lindsay, messages from Kate to Lindsay, and then also at least one recording of Leah Genduso, a former state trooper. You can see how this is so convoluted, but Leah Genduso, who is affectionately called Leah Bathtub Genduso by her legions of I guess you could call them followers online. I might be being a little sarcastic there. The point is, Leah Bathtub Genduso was a former drug dealer who got arrested in 2007 for packaging marijuana and money laundering got convicted or took a plea. I don't remember which one. And then in 2008, she somehow became a dispatcher for the state police. She didn't disclose this or something, or they didn't know about her previous history. By 2014, she became a trooper. Between 2014 and 2018, she was a trooper. In 2018, Leah Genduso was exposed for having this a romantic connection to the third in the chain of command in the state police. I don't remember the guy's name, all right? And that guy, interestingly enough, and by the way, TurtleBoy exposed that, okay? And by exposing that, Leah got fired, and there was like chaos in the state police. But that happened at the very same time that another big scandal was happening in the state police, where an arrest report about a judge's daughter had been altered to protect the person. And it turns out that that trooper that Leah, the higher ranking state police commander that Leah was romantically involved with that got her fired, was involved with another woman named Anderson, and not romantically. Those two worked on the altered report about the judge's daughter, who represented the Anderson woman in the context of the proceedings related to those cases, the same lawyer that's now been retained by Brian Tully in the context of Karen Reed's civil suit. All right, see what I'm saying? It all kind of ties together, and it's very, very interesting to think about how the involvement... Hi, Nicola, great to see you. It's very interesting to think about how the involvement of all these different players really centers on Kate Peter being a proxy for the same investigatory team and the prosecution unit that was working on the Kearney case and the Reed case, because remember, they weren't just investigating Kearney and indicting him and things like that. They were also simultaneously, and are still to this day, trying to investigate Karen Reed and Aidan Kearney for another set of indictments, all right? So you can see how all of this intermeshes, and I think Kate Peter, once the Norfolk DA recused from the Kearney cases, became an intermediary with Marty Kraft kind of supervising her. And Kate Peter serving as an intermediary resulted in a bunch of conversations between Kate Peter and Ken Mello, and Kate Peter and Tully, and Kate Peter and Yuri, and otherwise, maybe even the big guy himself, Michael Morrissey, that just still to this day have not been disclosed. Why is this wild? Well, take a look at what came up overnight, little towels. Let me get rid of this wonderful artwork, because that does explain a lot of the context. But let me show you what came up overnight, okay? Let me just grab this, and let me close this, and then let me scroll up here. All right, we get this new set of discovery in the Kearney hearing. All right, we can talk about this for 7 minutes, okay? Why can we talk about it for 7 minutes? Because then I'm going to play you a 40-minute video. All right, so look at this new discovery notice that went up in the Kearney case overnight. Thank you very much to Dee Dee. By the way, if the new memo of law from Bettero gets posted, I think TurtleBoy said he reviewed it last night. I don't have a PDF. If anyone gets a PDF, please send it along anytime before 2:15 p.m. so we can read it. That's the big moment of today. All right, we are waiting for that 2:15 p.m. hearing. A lot of people are unsure of what to expect, but I read the scheduling order from the PIO, the Public Information Office, that Judge Belzeos entered. I still don't know how to phonetically pronounce the judge's name. Belezos, but I'll know today after clerk announces it in court. So this is a notice of discovery that went up in the... So today's hearing is going to involve 5 different things at 2:15. We'll talk about that as we get closer to it. But one of the primary things we're going to talk about this morning is the developments that happened overnight. So the 2 things went up on the docket overnight. One was a memorandum of law from Bettero, which we don't have yet. And then this is the notice of discovery that went up from the state. Now, listen to what's into this discovery, because this is prefatory to the 40-minute video we're going to watch that's going to get you all ready. If you're not ready, you're not ready. Mouse is corrupt. Great to see you. Good morning, my dear friend. Thank you for being with us. You came in at just the right time. We're going to be erudite and learned little towels. So this is the Commonwealth Notice of Discovery. Now, remember, we don't actually get the discovery. Kearney does. We just get the overview, okay? So here's what we got. Let me actually open this. Is this a new image already? Yeah, let me scroll in. All right, so zoom in. The first thing that the Commonwealth provided is an April 17, 2024 email to Laura McLaughlin titled, "I was asked to send this also courthouse," containing photo of Judge Cannoni, a YouTube link, and a video sent called something's... What? All right, Killer Karen, day 1, sent by email to counsel, 12/3/2025. An email from Catherine Peter to Mello Law Dated May 8th, 2024. Subject forward Aidan Kearney with 10 attachments sent by email to counsel 12/1/25. Paper copies. A report of Sergeant Buchanan. Subject dated September 29, 2023. Subject info. Oh my God. Oh my God. Oh my God. As early as September 29th of 2023, Kate Peter was sending emails to Yuri Buchanan, and the title was info that Yuri was then forwarding on, info provided by Catherine Peter regarding O'Keefe motor vehicle homicide, with 2 attachments provided as paper copy to counsel. Oh my goodness. Sofagate, the truth. April 27, 2025, Mass Hole Reporter, blog printout, 32 pp provided as a paper copy to counsel. Is that Kate's own report about the Sofagate situation? Oh, what the hell? Who's Mass Hole Reporter? Oh my word. Oh my goodness. Oh wow. All right, now let's look at some of this other discovery. Let me see if I can make sure. Yeah, you can still see it. Now look at what was provided on a thumb drive. Yuri combined redacted PDF, compilation of Yuri's text messages to witnesses, an X post attributed to Aidan Kearney at Dr. TurtleBoy, Dear Robert Cosgrove. 7, Janelle Webb interview. 8, she was the person that apparently gave the license plate. Whoa, that could have some implications. Because Aidan... Oh, God. All right. There's Facebook group chats out there about why Aidan had Janelle Webb run that plate. All right, let me just leave it at that. Online image captioned, Little Princess property of TurtleBoy. Who? What? Why? What? 9, there's a lot of memes of TurtleBoy. Why did Kate post it? Why did you post the one, Little Princess property of TurtleBoy? Photos regarding search execution individually labeled from DLV 2099 through DLV 2416. Videos recorded telephone call between Scanlon and Kearney. Remember, Kate touched that. And why is that on the 2582088 indictment? Because Kate was the one who apparently provided that. And then let's look at the last 2 things because they have to do with... the 2025 case. So then we also get the grand jury exhibits for the 2025 window incident involving Kearney and Chris Albert's pizza shop. And then 5/13/2025 grand jury minutes. And then there you go. All right. So that's the most up-to-date discovery. Now what, notice. Now what I'm going to show you is a video. All right. This is a very helpful video. You are gonna, listen, Nicola, Kate the other day, I didn't listen to it, but I heard she was talking about how, why is getting a haircut such a big deal? It's not that. It's that Kate's using that as obfuscation to veil the actual interwoven networks. And the one thing that I don't think the Norfolk DA or Kate or anyone wanted was all of this being introduced into the court record, because there's serious evidentiary and motion to dismiss consequences. I'm not a lawyer. This is not legal advice. But you can literally compromise the ability of evidence to be used at trial. You can compromise the grand jury proceeding in a way that can result in dismissal under Odell or McCarthy, which is exactly what Kearney is moving for. If you intentionally withhold discovery, which, by the way, is a huge deal. Okay, so let's look at one more thing before we watch this video. Let's look at what Lindsay had to say this morning, because I quoted this post, okay? And then I said something about my exact summary of this. There it is, the Kate Peter discovery. There's still no mention, though, of Kate Peter's 2/24/24 email to Mello that was revealed by Lindsay Gattani. Kate Peter was indeed involved with the prosecution team. And then Lindsay down here says, there's another email I'm still waiting to see if they turn over between Kate Peter and Brian Tully. Kate knows which one I'm talking about. So then the real question becomes, did the state not only fail to withhold the 2/24/24 email to Mello that Kearney's defense already has, so why the state would still not turn it over baffles me, but also is there another email from Kate to Tully that might not have been turned over? Just explosive potential development. So folks, keep your eye on each and every moment. Now, while I scroll here and get you the video, let's talk for a little bit. My name is Grant Smith Elvis, and I'm a Tao. All right, there we go. I'm going to scroll and get you a wonderful 40-minute video. That's going to take us to the top of the hour. You are going to then, by the way, your real briefing, if you're turning in for the TurtleBoy coverage, I know a lot of you, it's still 6 hours away. I know a lot of you are waiting for that. You're going to get fully caught up now, and then I'm going to do another briefing at lunch. Your towel mission for the day is to locate, if possible, a PDF of the memorandum of law from Betterow that went up overnight. Now, Dee will probably get it once it's scanned, but the court doesn't open for 9 more minutes. So if anyone can get it, please let us know. I tagged TurtleBoy in a post asking him to post it. He's being somewhat cordial right now, so there you go. And furthermore, I want to look for this video. Why do I want to look for this video? Because I think this video, and I found it earlier today, I should have just bookmarked it, but I was doing things. This video that we're going to watch is my summation of everything that's been going on in this TurtleBoy situation. It's not the Proctor cell phone analysis, although that ties into it. It is instead a overview of Betterow's filings and then Cosgrove's response and Tully and Cosgrove's and Mello's quote unquote affidavits. It was really only Tully and Cosgrove spoke for Mello via hearsay. Just that alone is devastating. Cosgrove didn't even respond to the fact that Betterow motioned for Cosgrove's recusal from the remaining cases against Kearney. Cosgrove just missed that. Tully misrepresented whether or not it was Kate or Aiden that submitted a forged federal document in the context of a copyright dispute. It was Kate. Tully attributed it to Aiden. So that's got to get corrected, apparently. And then there was a lot of, there were some more egregious errors. The state said, Cosgrove represented that anything that was not in Lindsay's phone extraction that Tully released completely incorrectly, unredacted, would be able to be found in, because Lindsay didn't have it on her phone when they extracted it. That's already been proven to be wrong because there's an audio recording from Leah Genduso that Lindsay posted on social media that shows that the state didn't extract everything and it was not deleted from Lindsay's phone at the time. Further, that it was extracted in 2024 before it was handed over unredacted with certain things removed to benefit Tully in April of 2024. And then the state also made an argument about whether or not they... Oh, right. It was that they had spent 20 hours over 5 months redacting like emails between Kate, Peter, and Brian Tully and Kate, Peter, and Ken Mello, and apparently Yuri. And when Kate... when they produced those in July of 2025, Betterow was only able to access one of the 5,000 pages. Cosgrove followed up with 5,000 more pages in July of 2023, and somehow, and that's why the new email that Lindsay provided that was in Betterow's supplemental affidavit or whatever it was, indicated that there was a 2/24/24 email from Kate to Ken Mello outlining legal strategy for approaching Kearney's cases that was not included in that 5,000 pages at all. So, and then Cosgrove was talking about the process that he went through to actually go to like put together those email records, and it just made him look horrible because of the fact that then it came out he didn't even include everything. So the 5 issues up for discussion today are discovery issues, the status of Kearney's renewed motion to dismiss under Odell and McCarthy for the state and Kate Peter and Brian Tully compromising, well specifically Cosgrove for the state, and the Norfolk DA's office compromising the integrity of the grand jury proceedings, such as to warrant dismissal due to prosecutorial misconduct, mishandling of evidence. Kate, by the way, also, and Tully admitted to this in his affidavit, Kate sent Tully 3 recordings, the Scanlon and Kearney recording, and then an original recording of Lindsay and Aiden talking on the night of December 23rd, 2023, and then another version that was apparently edited, allegedly. Tully brought those recordings to the grand jury. He apparently just played them as an attachment that Kate sent him for the grand jury, and then Tully said they're now gone. Kate deleted them. Therein, basically, Kate was able to single-handedly cause some cases against Kearney to get null pros. I don't know why, by she would do it. I think I have my thoughts about why she did it, punishment, etc., etc. Maybe the Norfolk DA and the Cosgrove and Tully didn't want people to know how intermeshed Kate was in the cases. Maybe they were trying to quarantine evidence Kate touched from the other indictments to see if some could go forward. Maybe the indictments against Lindsay were never meant to go to trial, and it was all just a way to put pressure on Kearney, get his bail revoked, try to get him to flip on Karen, etc., etc. All of that, though, culminates in this very interesting situation leading into today. Because Kate Peters, all of this new evidence that the state through Cosgrove is still not turning over, damns the state's behavior over the past 3 years in a way that's not something as simple as they forgot to do testing. There was material communication between Peter and members of the prosecution team, probably some things they were either passively acquiescing to, which is part of the standard under highball from the Sixth Circuit, which is persuasive related, and I'm not a lawyer, this is not legal advice, which is relative to whether someone is acting in a capacity as a government agent. If Kate had agency, not through even a direct ask, but that would help the case even more, but if Kate had agency through passive acquiescence of the law enforcement agency or members of the prosecution team, and she was doing things with a primarily or solely law enforcement purpose, and she was announcing on Twitter she was doing this for a law enforcement purpose to try to get him locked up, etc., etc. And she left him a voicemail saying that, using very vulgar slurs, saying she was trying to get him locked up, etc. It was her that was behind it. So that all of that combines together to put this discovery obligation under Rule 14, especially the new Rule 14 from March of 1st of 2025, which applies retroactively. The way that functions is the state's got to turn over all these communications between Kate and Mello and Kate and Tully, et cetera, et cetera. They said they were doing that, but we're hiding things. If you're, as the defense, are just alleging they're doing that, it's not good enough. But if you have evidence that there was an email sent from Kate to Mello that was not turned over, and then you submit that as a defense, you've proven constructively the state had something and withheld it. You see what I mean? It's a huge deal. So we got to find this video. I'm a little towel. Now, I found it. I'm such a little towel. Now, you might be saying to yourself, sir, you are not a towel. Yes, I am. I absolutely am a towel. Pete Bunny Towel tells me every day that I'm a little towel. Now, I'm going to make this full screen for you so you can listen to it. I'm going to pause my camera. We're going to get a little double towel action. All right, now let me go over here. Hold on, you don't need to see me twice. All right, let's do it.
About where this is all going, and then the larger picture here. We're going to do a few things. So let's do the 30,000-foot breakdown. We're going to talk about the procedural posture, why this changed from a hearing on Kearney's motion to dismiss, which, by the way, I took the time and went through and got all of the outstanding motions because it all ties into this procedural order. So it just says all of the motions. Okay, well, I went and got all the damn things. My computer might slow down a little bit because there's so many pages, at which point I might pause my camera so it can load up all the PDFs. The point is, I put this all together for you, all right? I did the legwork, and I'm doing it for both the purposes of explicating what's going on and also for the purposes of like a review in the larger context of criminal procedure. And furthermore, I want the opportunity to read both Odell and McCarthy, which are two cases that are at the core of all this. So there's a lot of noise with these motions, okay? But we're going to strip away. We're not going to do a reread of all of them. I am not a lawyer. This is not legal advice. But what I'm going to do is I'm going to strip away a lot of the filler, not even filler. I'm just going to strip away a lot of the legalese and the nonsense and stuff that's just kind of catty. I'm going to strip it away, and I'm going to isolate all the filings down to the core. And the core is what's called an Odell or McCarthy motion to dismiss, okay? I'm going to explain why this is a renewed motion to dismiss. I'm going to explain the standard under Odell and McCarthy for what exactly it means to impair the integrity of the grand jury.
All right, so you see those are the 5 things that are going to be discussed today. A, the status and potential impact of any motions currently under advisement. That's the renewed Odell motions, the supplements, the response, the new supplement. This isn't going to be heard. That's not going to be heard for like a month because Cosgrove needs time. But you can't be dilatory. Like if judge wants to hear it next week, They got to do it next week. Outstanding discovery and or discovery disputes. This is about the stuff withheld that Kate Peter was involved with even after all these new discovery revelations. We're going to hear about that today. Today's going to be explosive. Scheduling of in-person hearings on pending motions, so the motions to dismiss and or additional anticipated motions. Oh, and also the motion to recuse Cosgrove. Potential joinder motions, so that's with the window shop case, and then potential trial dates. That's what I'm saying. We can't have 5 months of going back and forth about the motion to dismiss. It's got to be like in the next 30 days. Anyway, let's continue.
Then we're going to look at the subsequent bombshell developments, which absolutely went under the radar over the holiday weekend because, and this is something else we'll talk about, this whole bullshit with Meredith and Aiden and all this shit. Who benefits from that? Think, folks. Kate Peter. As long as people are talking about what Meredith's talking about with Aiden, nobody's focused on Kate Peter. Why is Kate Peter the nexus of this? Well, you're quickly going to find out that as we review the documents based on the Odell and McCarthy standards, it's actually Kate Peter's involvement with the handling of evidence, along with her role in the orbit of the prosecution team related to the 2023 and 2024 indictments as to Aiden Kearney, that really coalesces to form and crystallize the sum and substance of Betterow and Bradel's argument under Odell and McCarthy, and in particular, there's this other case called Hybel we'll look at from the Sixth Circuit, which talks about agency as a government actor and why that analysis in particular weighs so heavily in favor of Kate Peter having a designation that would include her under the scope of Rule 14's definition of a member of the prosecution team. But that's a little bit of a very narrow aside. I want to keep it a little more broader and continue to talk about under Odell and McCarthy, we're going to look at how Betterow's evolving supplemental affidavits and Cosgrove's ridiculous response actually firm up a very strong argument for the defense under Odell and McCarthy, specifically because of the actions of Kate Peter, Ken Mello, Brian Tully. And the way those actions, as they relate to the handling of evidence, the ex post facto deletion of that evidence, the failure to preserve and retain that evidence, and a general prosecution strategy to insulate the other remaining indictments targeting Kearney from the involvement of Kate Peter, despite the fact that before Cosgrove filed his reply to Betterow filed a supplemental affidavit that included evidence that Kate Peter had email contact with Ken Mello about the 2023 indictments, and furthermore, that this was never turned over from the state, despite the fact that Robert Cosgrove spent between October of 2024 through to July of 2025 going through 5,000 emails or at least documents related to Kate Peter emailing Brian Tully and Kate Peter emailing Ken Mello, redacted them, gave them to Betterow. The first time Betterow got them, 4,000 pages were blank. When Betterow got the full 5,000 pages, the email from Kate to Ken Mello on February 24, 2024 about the strategy for prosecuting Aiden Kearney that importantly said in the beginning, per our call earlier, Ken, is very, very damaging for a number of reasons. One, it clearly existed and was withheld from Kearney's defense. And two, it directly does the one thing you're going to find out tactically all of this back and forth was about, at least from the state, in my opinion, which was to insulate the remaining charges against Kearney from anything that Kate Peter touched. Well, if you lie and say she didn't have this email contact with Ken Mello that now exists, you're screwed. And we're going to look at why under Odell and McCarthy, that's the core issue. Therefore, I believe all this noise and all this cacophony of chaos was just Kate Peter burning some of her last moles in order to generate a lot of big distractions so that when this stuff came up on Friday, people wouldn't realize the full impact of Kate's role in compromising the cases against Aiden Kearney with the willing, at best, the willing acquiescence of Brian Tully and the Norfolk DA's office, and at worst, the willing complicity of those people. Everybody see the full picture? Thank you, Ola. So you see why this is so damning? When you actually, first of all, it is incredibly procedurally complicated. Okay, that's the first thing. Second of all, what makes it really toxic is that there are people It's not just that Kate Peter, a lot of people think of her as just some person with people online. No. No, it's way deeper than that. She has tactics, in my opinion, and the people in her orbit are powerful. And every time a big filing comes up that exposes the interconnectivity between Kate Peter handling evidence, Brian Tully, Ken Mello, etc., there's this big distraction in public that always traces back to people who are in the end tied to Kate. And I think a lot of people have questions right now about who exactly that was proclaiming themselves to be a pro-TurtleBoy or pro-Karen Reed or both person was actually just trying to get close via obsequious praise to either Karen and her inner circle or Aiden and his inner circle for the purposes of relaying information back to the state through Kate. That's one possibility. The thing that totally blows my mind about all this and makes me wonder if there were double agents that Kate thought she was recruiting that actually worked for Karen. Two things. One, Olivia Lamb's mom, Christina Lamb, going to a function for former U.S. Attorney for the District of Massachusetts, Josh Levy. That's weird. That's just weird, okay? Because that means Flip and Olivia, there's no way they didn't talk about that, okay? Because that was out there, and that was easy to find. So Flip's a wild card in all this, too. And I wonder if there were some double agents, all right? The other thing is, it wasn't just how that played out. It's also that Obach's dad was an FBI agent, that like a former FBI agent. That's a little weird. Obach's now gone from Twitter. Then the other thing that's weird is that Obach and Broyles, who I think is definitely connected to Kate, Obach and Broyles knew this dude named Mark. And this dude, Mark, Christy Troney figured out, had like been criminally represented by a guy that David Yannetti personally recruited to work for his firm. And I think it was Yannetti's firm that represented this guy. All right, okay. Now it's like, who was spying on who? All right, spy versus spy. You see this? It's very nuanced. And that is why it's also a distraction. Okay? This is the big deal. The potential charges against Karen and Aiden, that's a big deal. What is not necessarily as big of a deal is all the noise happening right now. So that's what I really want people to focus back on. If there's any lessons that people do take from the static to noise ratio being ridiculous right now, it's this. One, it's like, how many divine messages is Aiden Kearney going to get before he's like, oh, fuck. Like, the reason this cycle perpetuates is because we just keep doing it to each other. Right? So, like, someone's got to break that cycle. All right? He's got to lead on it. But, like, this whole weekend was a very big test of people's character. Okay? It was definitely a test of your moral character. Regardless of the motives, the distractions, it was a test of your moral character. And the way you reacted says more about you than the players involved. As to why this larger chaotic picture is unfolding, though, you got to think of it this way. Karen and Aiden are clearly at odds, okay? But Karen, I'm not degrading Aiden Kearney. Okay, he was a history teacher or some kind of teacher. He has his own brand of intelligence. Okay, cult of personality, whatever you want to call it. That is not a negative term. He knows what he's doing in that regard. All right. Karen Reed is a different kind of intelligent. I've said this before. Those two are fighting right now. They're clearly at odds. However, Karen is more analytically intelligent because of her training and the world she comes from. Okay, so she has, I think, her own plan. Aiden has his own plan. People are playing them against each other and their supporters because, and in particular Kate Peter and the Norfolk DA and the MSP, they have their own plan. All right? So you've got these three factions here. And they each have, everybody thinks they have a fucking plan, and these are people all think they have a plan. I'm not saying they don't have good plans, bad plans, I'm just saying they all think they have a plan. All right? Those are the players. The question is, it's twofold. One, how is the pending potential indictment against Karen and Aiden going to play out if the Norfolk DA isn't running for re-election and Adam Deutsch wins the primary and then wins the general? Okay, the primary is going to be in like August or September of 2026. That is its own question. You cannot indict someone and bring them to trial in like 11 months. The pretrial process could be extensive. You might not even get there by January of 2027. Then you have Deutsch coming into office. He could just null process everything. So that's an open question. And then the other open question is, what do you do about Kate Peters' involvement in the indictments against Aidan Kearney if you put on record as the Norfolk DA that she had no such involvement, and then a document comes out before you file the motion, but after you write it, which is even more wild, confirming you were wrong? What do you do? That's why this is such a big deal. Hello, Peggy. Good to see you. 3 Clerk Monty says, aren't the things you just brought up in combination with other important public information very relevant towards connecting who are on the team of those covering certain things up? Yeah. So I think what it is, and a lot of people, I can see how they fall victim to this, because why would you ever track this web of online personalities that some of them don't even use their real names? But what you'll find is some of the bigger accounts, like just screaming pro TurtleBoy stuff or pro Karen stuff, are not authentic in doing that. They were working to get information. Okay, and now the question is, why were they doing that? Did it compromise the prosecutorial process? Okay, and more so than anything else, what were they hiding? Why were they doing this? Why was Kate Peter allowed to be involved in any of this? Why does Marty Kraft no longer have his PI license? The guy Kate was working for. The guy who clearly knew Brian Tully. The guy who was the president of a private detectives association with another guy named Verano, and Verano was brought in to search TurtleBoy's phone. So what is going on here? What is this network we all stumbled onto? And is the reason why Towel takes so much heat? Is the reason why there's so many distractions? Is the reason why Lindsay Catani is such a target? Is perhaps the reason why even TurtleBoy was such a target was because it was never really about the Karen Reed? Is the reason why Karen was such a target is because it was never really about the Karen Reed and John O'Keefe case, as sad as this is. It was about the secrets that lay beneath in Canton. And especially about this unit. And Sandra Birchmore and Matt Farwell is just the tip of the iceberg. This was some stuff. And I have an idea. There is a unifying thread to all this, all right? Just think about Hank Brennan, okay? If you think about Hank, I don't want to be. I find it very distasteful to have to be direct about something like that. But it has no place. It has no place, and they got in deep. Okay, there's some stuff that really, 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 really got too close to the Norfolk DA. And I'll quote someone, I've said this before, quote, Michael Morrissey is not the problem, it is the people around him. Okay? So there is some shit that went down that we haven't seen even 1/10 of it. I think those of you who follow the stream are starting to put it all together. In particular, I ran a poll over this weekend. I'll show you the results. And this really speaks for itself, okay? Look at this poll. It says, in the past 24 hours, has your opinion changed regarding whether certain people in the orbit of high-level Karen Reed and Aidan TurtleBoy Kearney circles were in fact moles for Kate Peter? Got almost 200 votes. 36.7% say Towel, this is pure chaos. 26.1% said, yes, I'm now a believer. 18.9% said, no, I thought that before. And 18.3% said, no, I think it's random. That's wild. Okay? Those, I've polled for a while on that. The numbers have never looked like that before. People actually are starting to see it. And come on, let's be real, all right? I have said before, Meredith is not dumb. All right? Anyone who thinks Meredith is dumb, you are completely misjudging the situation. Does that mean, and by no means am I condoning or endorsing anything she's done. In fact, I'm going to do just the opposite. But anyone who thinks she's dumb is misreading the field. Her brain's like an Excel spreadsheet. She's very smart. Okay? But let's circle back. Meredith is from South Boston. Meredith just happens to be defended a lot by Jason Broyles and Kate right now. Meredith shows up out of absolutely nowhere and just fawns over Aiden. Which, I mean, okay, that's plausible. Women do that. I don't know why, but they're right. It's their right. Maybe it's because the vibe he puts out. Like, he wants that. I don't put that vibe out. I don't really get that. Like, no one has ever, and I don't even know how I feel about this, but as far as I know, no one has ever sexually propositioned me. I don't really want to be sexually propositioned. There's a part of myself I want to reserve for myself, all right? My personal life. But no one ever is just like messaging me, sexually propositioning me. Thank God for that. I'm very grateful. Thank you for not doing that. But the point is, it's not that she approached him. It's that she has ties to South Boston. There's something there with Canton. There's something there. She just has too many ties to that community, and there's too many ties between Canton and South Boston for Meredith coming on the scene to just be random. And the way she acted over this weekend, listen, you can say what you want about the dynamics of that relationship. Personally, I'm trying to get people into this place where, like, we don't continue the cycle of airing people's personal relationships out in public as a weapon, but cutting through the merits of any side of that relationship, all right, which I do not want to psychologically analyze and I have no interest in talking about. What Meredith was doing over this weekend was, at the core, distracting from what Kate Peter was up to. That was disclosed. Now, it was weird that Cosgrove was the one disclosing stuff in his positions, but the information about Kate Peter compromising Aiden's case is the biggest deal. All right. And then all of a sudden, this chain reaction of stuff smears and all this other nonsense starts coming out on social media through people who, if you really cut through the noise, there's a lot of questions about why they're even involved in any of this. Jason Broyles, Meredith, Obach, whatever. And I'm not saying these people don't have their own talents. I'm saying they deployed them very maliciously. Very maliciously. And I think it all traces back to Kate. And therefore, this awakening that people are having is an inadvertent result of Kate using a tactic that she's gone to this well multiple times before, which is when a thing hits the docket that's very damning for Kate and her network, Tully, Mello, whatever, the Norfolk DA, Jen McCabe, she finds a way to get Aiden or his people to create, or her moles, to create a story that then supplants the discussion about what Kate was involved in. Kate doesn't care if people are out there calling her crusty whatever or insulting her looks. No, where she's going to react with that kind of tactic is when you start talking about the implications of her role in handling evidence as to Odell and McCarthy motions to dismiss, and in particular, whether some information was withheld from the Kearney defense that would expand the amount and the nature and the scope of the evidence impacted by Kate Peter. Then, then you realize where it's coming from, all right? Oh, thank you, JZ41. Welcome to the stream. Appreciate you joining today. Ola says we don't know why either. Irene, good morning. She says it's pure chaos. Three Clerk Monty said, hi, Irene. Three Clerk Monty says, connections connect, and what it implies really sucks. Yeah, it does. All right. Now, but let's think about it before we have more things to talk about. All right. Because really, I just explained it all. But if you want to talk about it, all right, let's do it this way. All right. Let's look, because this document, as strange as it is, actually acts as a really good map for what we're about to talk about. And you might be saying, Grant, I understood like 1/4 to 1/2 of what you just said. That's okay. We haven't done the process yet. We're spending the morning with Towel. We're working on getting Towel donations, not gratuitously. We just want to get Towel's bank account above negative. It's like a negative 138. If you need the donation info, it's in the chat. There's a little Venmo thing right there. Let's do that. And in return, you will get to hear me do a number of fun things. One, I will explain to you again what this procedural order means. Then I have all these PDFs queued up. Then at a certain point, we're going to talk about when Mr. Betterow brings up initially, because he writes a tripartite, it looks like it's 88 pages. It's really like 44 pages. It's actually 22 pages. What do I mean by that? It's 88 pages, double space, 14 point century school book font. It's 44 pages, single spaced, 14 point century school book font. It's 22 pages, Times New Roman, regular to double spaced, 12 point font. All right. So it's a lot. It's probably like 20,000 words, but we're not going to read all of it. But when Mr. Betterow gets to the point about Odell and McCarthy, we're reading Odell and McCarthy. Why are we doing that? Because it wraps up into a neat little package. Exactly why Kate Peter is central to all of this. Yes, Ken Mello talking to her and emailing with her played a role. Yes, Cosgrove withholding that email that later came out in the Betterow supplemental affidavit played a role. Yes, Tully enabled it. Yes, Jen McCabe probably played a role. Yes, Michael Morrissey played a role. But the nexus is Kate Peter. All right. And then look what branches out from that nexus. It's like cause and reaction. We'll call it Towell's first law of internet motion. Okay. Whenever there is something that happens that brings the focus down on, for example, Kate Peter in this situation. When you have someone like that, what you'll get is a bounce back that is not actually addressing the allegations. If Kate Peter is left with no option but to address the allegations or the new disclosures or the impact in the McCarthy and Odell context of what has been revealed that she was doing with the help of the powers that be, bro, she's losing. All right, she's losing so bad it's over. But she's got a trick up her sleeve, I think. I think Meredith was a mole going back a while before Meredith was alienated after. I don't know. I don't really care. Not my business. However, what is, in terms of what I'm trying to figure out here, is why Kate deployed this tactically right now. And if you look at the filing, it means that was the break glass moment. Because if you're burning Meredith as a mole, if you're burning Broyles, if you're burning all these moles, first of all, Aiden's going to see it. All right, look at who Aiden's now sort of supporting. Not because I think he loves everyone who's figured this out. You think he's pleased that Lindsay figured it out, that I figured it out, that who the hell else has figured it out? The people he was praising on social media yesterday. And he did it in such an Aiden way. Here are the people who you should think are less crazy now. All right, I guess that's a compliment, and that's like for an Aiden Kearney statement on the nice scale, that's like 7 out of 10. All right, you got to contextualize it. And if you don't say that, if you just don't say like good job, he'll be like, well, fuck these people. I was trying to be nice. You got to say like it was packaged in an Aiden Kearney way, but as nice as you're going to get. That was a good sign. All right. Now, why is he doing that? I don't think he loves having, this is my analysis. I don't think he loves having to do that. I think there's just certain people who, whatever their motives, wherever they were aligned at one point, have figured out what Kate was up to. How can it all possibly center on one person? Well, it doesn't really. It was more that Kate had connections that made her useful. The Norfolk DA, the MSP, Tully, Jen McCabe, whatever. You trace those connections and you get why there's such a visceral reaction, both in sum and substance, in terms of how the state, through the Norfolk DA's office, and in particular Kate Peter and her online minions, react to damning evidence that comes out during the court process. Now, one thing I want to show you is, all right, this weekend, because I know a lot of you want to hear my thought about this weekend. Well, thank you, JZ41. God bless you. Welcome to the channel. I hope you have a fun time today. Enjoy your new wrench. I know a lot of you want to hear my thoughts about this weekend. All right. So let me sum it up with a video we've watched before. It's like 40 seconds. All right.
All right. Hello. Now, we're not nearly through that video, but before we get started on the Walshe trial, I want to play another video. Now, you might be saying, Towel, what do you want to play? Well, did you see how 3 Clerk Monty was talking earlier about how there's no heroes, no villains, only shades of gray? Well, I'm going to play you Towel's analogy of the cave. Now, I love Plato. Plato, although his theories, I mean, not every one of them was perfect, and obviously it's hard to discern what Plato thought because he speaks through Socrates, and so you really have to just like, Plato both embodied the viewpoints he didn't like and the viewpoints he did like, so it's hard to understand what Plato thinks. But like, the form of Plato's philosophy was so far ahead of its time, it's almost unbelievable. Like, the psychoanalysis of the human mind did not become codified as we know it until the 1920s, maybe 1910s, okay, for military applications. He had it like 2,000 years ago. And yes, it was studied, okay, it was kept alive, his tradition. But we just forgot about it. And it works so well for this case because it explains in specific terms why the people in the cave, and I actually found out this really interesting, I kept reading the Republic recently because I wanted to learn more about Book 7. And when you go to the end of that analogy, there's the people in the cave who are just living their daily life. There are the people who cast shadows. There are the people who somehow get out of the cave and tell the story. Then there are the people who, once they're out of the cave, try to go back inside the cave and tell people what's happening. They get like brutalized, okay, by the other people. They are really not treated well. Now, I am in a different perspective, okay? I paint the cave. I paint the image. I'm not trying to live it. I paint it. And here's my quote. We live in this mythical world where your heroes must do no wrong and the people you hate must be wrong all the time. That's not right. You cannot analyze a situation if you just assume the people you like are always right and the people you don't like are always wrong. That's like being in a cult. All right? And I'm going to play you my video, which is Towel's analogy of the cave. And you might be saying, Towel, how do you just have these things? I don't. I have to try to look for it. And you can't even search for all of them depending on when they were posted. All right, so we're going to watch this. I'm going to bring this up for you now. And then as soon as the Walshe trial starts, we're going to go over to that. All right, so take a look at this Towel video. It's wonderful. Now, you see the analogy of the cave? You see how there's the people down there in the cave? They're just living their daily life. They don't want any of the slings and arrows of outrageous fortune, nor should it be put upon them. They have certain duties in the civic arena to be informed and coach and participants therein, such as to ward off the usurpation of our public sector apparatus and our organs of public discourse by virtue of their civic abdication. They must be informed enough to not be put into the cave, intentionally, subconsciously, or otherwise. However, we don't have to expect them to be like running the government, philosopher kings, or otherwise. They just have to have a bare modicum of knowledge to avoid the pitfalls of being trapped in this cave. Now, there's also people who hold like little torches, okay? Some will admit it, some will pretend that they're not doing it. Kate Peter, I think, is the most pernicious of this group. The other two, Sue O'Connell's more like legacy media. They don't have a lot of relevance anymore. I do more views in a year than some of them could hope for, and their ratings shrink all the time. And tell me the last time you heard about Nielsen quarter hours. TurtleBoy also does it, but he's open about it. Now, as a result, some of the Turtle Riders, some of Kate Peters' people, they start climbing out of the cave. They have a choice at that point. You either climb all the way up, you understand what's happening, or you try to go back down and you say, hey, what's going on? If you go all the way up here, you're going to be on an island, all right? You're just never going to go back into the cave. You've got to protect yourself first. Some people do that. Those are like the philosophers, the like really high-level thinkers, the government people. Some people, however, paint the image, all right? That's a little towel. And I've said it before, like, I didn't paint this. I interpolated what's going on onto an existing image. But I think my explication is important. We're going to listen to it, and I'm a little towel.
And that's where we're at. Tully's screwed. Fanning screwed. You're Proctor's a little bit screwed, but he was really more the scapegoat. I don't think he actually covered up Sandra Birchmore's murder. I think they just made him the fall guy. Kate Peters screwed. Karen might actually end up getting out of this because I think they want Rachel Rollins and TurtleBoy, in my opinion. A lot of people are screwed. There's no black and white here. There's no heroes. The villains have some redeeming qualities, except for TurtleBoy. The heroes have some very bad qualities. There is no heroes. There are villains. Morality is not black and white. And that's what inhibited people for so long from understanding this, because they couldn't. We live in this polemical world where your heroes must do no wrong and the people you hate must be wrong all the time. That's not right. You cannot analytically analyze a situation if you just assume people you like are always right and people you don't like are always wrong. What? That's like being in a cult. The only way that you can figure any of this stuff out is to look at it from the perspective of human morality. On the whole, most people are not Kantians. They're not operating from the categorical imperative trying to universalize moral maxims. Who does that? Very rarely is that going to happen. Most people are selfish. Most people, and I'm not being jaded here, most people are selfish. Most people are acting from personal interest, which we can't really fault them for. But some people, in particular in positions of power, are acting from places of mixed motives. Maybe they're trying to do some good. Maybe they're trying to cover up some bad. Maybe they're willing to play a little dirty. Maybe they're willing to wheel and deal on all sides. And if you think that's not happening, I don't know what to tell you. You're in La La Land. All right? Not being mean, but like you're in a fairy tale. You're living in a state of comfortable numbness, and it's going to be uncomfortable. Like, imagine if you were living your life. Like, I'll show you a good image. Give me 1 sec. Let me pull it up on the screen. I've shown the image before, but imagine if you were living in a cave. Okay, just imagine you were living in a cave, and part of living in that cave was that you were very comfortable. You know, like it's easy if you're living in a sort of underground cave and you don't have to actually go out and scavenge for food. We're using this by analogy. It comes from Plato. You don't have to scavenge for food. You don't have to kind of look for stimulation in your brain. People just cast images on the wall, like some unknown force, and like you're comfortable, like your needs are taken care of. You're satiated, but you're not thinking. You're just going day to day. And so I don't say to people lightly that this is something you should do. I'm not just gratuitously encouraging you to come to a position where you're always quickly analyzing everything. But if you're going to engage in analysis of high-level politics, one of the most important parts of the arena, the public sphere, is looking at morality as a complex interplay of motives. Overlapping concentric social circles of influence define and permeate through every element of this sphere. It's not high school. It's not regular day-to-day existence. It's complex politics. Nothing's ever as it seems, and there are no good guys and good girls and bad guys and bad girls. There's people with motives trying to accomplish things. Oftentimes they're very evil, but we cannot fall into that trap. And that's why I think the fallout from this is going to induce a lot of cognitive dissonance for people. Rightfully so. You should have cognitive dissonance. If you thought Brian Tully and Kate Peter and that unit were heroes because they investigated Karen Reed, but can't understand how they could have done bad things in the Birchmore case or with Lindsay Gattani's phone, like, yeah, you should experience cognitive dissonance, okay? Because that's kind of what happens when you fall into these traps. Now, take a look, ladies and gentlemen. That is how I visualize what's going on. So it's just people are just trying to get by, live their daily lives. They want to be comfortable. They do not want to be analytic philosophers studying Kantian moral maxims and applying them in their daily life. That's not something we should expect of people. They deserve to live, raise their families, and be happy and love people. Okay, that's life. All right, we're not trying to make this too complex. No one's saying you have to be an analytic philosopher or run the government. You can just be happy in your life. But what we have, where the problem comes in the middle of this image, is the Sue O'Connells, the TurtleBoys, and the Kate Peters of the world. Now, what they do, by analogy, in my opinion, is they cast shadows on the wall. Now, those shadows, as you can see, are like being consumed by the people in the cave just trying to get by, but it doesn't really explicate the full context. You can't understand what's going on if you're just seeing a shadow cast on a wall. You don't even know somebody's in a robe is holding it up. You don't know it's a stick figure. You just think it's a shadow. So, of course, you're like, that's a wonderful duck. What do I care about the damn duck? And the duck is a fitting analogy here because a lot of people invoke rubber duckies who are on the Karen Reed side. Now, look at that. That's just a duck. I like ducks. Oh, I'll just sit here and watch the duck. I love the person showing me the duck. Oh, Kate Peters, wonderful. She likes ducks. Okay, that's a little dangerous. using duck by analysis here. Let's say Kate Peter loves Brian Tully. Brian Tully's a duck. All right, we love Brian Tully. Then you got Sue O'Connell casting an image of Karen's parents. Oh, Sue O'Connell likes Karen's parents. It's beautiful. They're little trees. We love them. Then you got TurtleBoy casting an image of his beloved Karen Reed. Unrequited love is such a horrible thing. Don't worry, TurtleBoy, you'll get through it. Anyway, so TurtleBoy casting his image of Karen Reed to hide his unrequited love. And people are like, TurtleBoy's just defending an innocent, quote-unquote, woman. He doesn't, have any ulterior motives. Look at Karen Reed. We love Karen Reed. But then you have some people who climb out of the cave. They see the Sue O'Connells and the TurtleBoys and the Kate Peters for what they are. They ignore them. They start climbing up. And then you get to the top and you're like, wait a minute here. There's just a world out there and I consume it and understand it and I don't have to be subject to the projections of someone interpreting it for me. And then you're Sean McDonough. You see what I mean? And then you see the light and you're like, wow, it's a little weird up here. So, oh, all right. Now, I'm not saying that Sean McDonough was incapable of this from the beginning. I think he did it pretty quickly. But you still got to go through the process. You'd be hubristic to think that you can just get up to the top of the chain and just see the sun if you don't climb up the little cave there. So, therefore, Plato, ladies and gentlemen, predicted over 2,000 years ago how Karen Reed, Sue O'Connell, Aidan Kearney, and Kate Peter would try to manipulate the public. All right, everybody on the same page? All right. How can people, I didn't say I love Karen Reed. I said that there are people who are very blinded and just see an image of Karen Reed without understanding the context, and they're like, oh, that's a Karen Reed, and they love her. That doesn't mean they understand her or that their love is a reflection of her, an accurate depiction of who she is. They just love the image of her. It's propaganda. And Plato didn't put it in the terms. If you read, this comes from book 8, I'm pretty sure, this analogy of the cave. If you read book 8 of the Republic, you're going to see the analogy of the cave. Plato predicted the rise of the discipline of public relations 2,000 years ago. He didn't call it public relations, but that little casting of the shadows onto the wall of the cave, bro, that's public relations. He knew what it was before it was even a thing. This man knew what that shit was before we had fucking TV, before we had, I'm pretty sure we had just invented writing. We didn't have electronics. This man was a G, all right? He was a genius. So that's why now this is my artistic rendering of the analogy of the cave, adapted for the Karen Reed and TurtleBoy situation. But that's why this is so complicated. No one can understand, other than maybe Sean and a few other people who I really respect. It wasn't that anyone was all good or all bad. It's that some people did good things, some people did bad things, and that they're all mixed in there together. And you can't parse out truth from narrative unless you're willing to admit that people you either like personally or have whatever dedication to their cause might have done something wrong. Otherwise, you're a sycophant, and that you undermine cogent public discourse, and you threaten the integrity of the justice system, and you need two adults in the room, like Hank Brennan and Leah Foley, to clean it up. God bless America, ladies and gentlemen. My name is Grant Smith Ellis. Let's see court's coming into session. Hold on. I'm going, little towels. We're seeing if court's coming into session.
How funny is that? We were actually watching the Don Adelson trial, but the commentary landed right as I was saying court's coming into session. Why is that relevant? Well, because that means I took the wrong one off. That's fine. I'll just fix that. We can watch the Brian Walshe trial. All right. It was actually exactly as court was coming into session, and I'm a little tail. Thank you very much for being with me. My name is Grant Smith Ellis. Going to try to give you the best bandwidth quality possible on this Brian Walshe coverage. And then remember, the 2:15 hour is what we're all looking forward to. You also get Double Towel today, back at 8 p.m. for a fun dual stream with Social Change Warrior. A little bit past my bedtime, but I'll get a coffee or something. Speaking of coffees, you want to throw into the Towel Coffee Fund. I'm going to be streaming the Aidan Kearney hearing today. I am making that available for all other networks as a pool feed. I put in a formal motion. If you would like to participate, all right, jurors are now entering. If you would like to participate in that, feel free to send a donation. You can see the Venmo will be up on the screen, and God bless all you for supporting Tao Channel. I'm a little Tao. We're about to begin day 5.
Hear ye, hear ye, hear ye. All persons have anything with the Honorable Justice Diane Frenette, Justice of the Norfolk Superior Court. Draw near, give your attention, you shall be heard. Whichever calls from Massachusetts in this honorable court, please be seated. Please turn off your cell phone.
Hope you all had a nice night. Jurors, will start today with the questions that we have every morning. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Were you able to comply with my order that you not do any research about this case?
Yes.
Were you able to comply with my order that you not access any social media or any news media?
Yes.
And you all still have open minds?
Yes.
First, again, thanks for your obedience to those rules. We're ready to begin today's work. The record should reflect that all jurors have answered yes to all of the questions. You can come back on the stand.
Thank you, Your Honor.
Morning, Trooper. You understand you're still under oath?
Yes, Your Honor.
Please be seated.
Thank you.
And you may proceed.
Thank you, Your Honor. May I approach?
You may.
Trooper, do you recognize that report I've just handed to you?
Yes, sir.
And have you had a chance to review that report before coming in here today?
Yes.
Is that a redacted version of what's been marked for identification I with some images blurred out?
Yes.
And so that would be a collection of text messages between the number identified for Brian Walsh and the number identified for Anna as far as contacts. Is that correct?
That is correct.
What are the last four digits of the Brian Walsh number?
The last four is 8646
And what are the last digits for Anna New?
7966.
Your Honor, the Commonwealth would seek to have this marked as the next exhibit, the redacted version of I.
Any objection?
No objection.
The Celebrite report between the interactions of the phone ending in 8646 to 7966 is now in evidence as Exhibit 169. Thank you.
Your Honor, may I publish 169?
You may.
Thank you. Ms. Gilman, can we have what's been marked as 169 on the screens, please? Trooper, directing your attention to the first text on the page, which phone number is, what are the last four digits of the phone number sending this text message?
8646.
What is the body of the text?
Hello.
And what is the date and time it was delivered?
December 25th, 2022 at 11:53 a.m.
And Ms. Gilman, could you scroll down to the next two texts? Trooper, which number is sending this text?
The number ending in 8646.
And what is the body of this?
Thomas asked if you were coming today.
And what was the date and time it was delivered?
December 25th, 2022 at 11:53 a.m.
And then if you could scroll down, Ms. Gilman. Thank you. Trooper, which number sent this next text in the chain?
The number ending in 8646.
And what is the body of it?
I haven't heard from you at all.
And what is the date and time it was delivered?
December 25th, 2022 at 11:54 a.m.
Now, could you, Ms. Gilman, scroll down to the next text in that chain? Trooper, which number is sending this message?
The number ending in 7966.
And what is the body of this text?
My flight got canceled driving up.
And what was the date and time it was read?
December 25th, 2022 at 12:57 p.m.
Ms. Gilman, can we go to page 51? Trooper, this top text on the page, which number is sending it?
Could you scroll up a little bit?
Yep.
I guess you'd have to go all the way up to 50. Which number is sending this text, Trooper?
The number ending in 8646.
And if we could go back down to 51. What was the time in the bottom corner of this text after it says sent?
December 30th, 2022, 6:33 p.m.
Now, Ms. Gilman, could you scroll down to the next message in the chain? Thank you. Trooper, which phone is sending this message?
The number ending in 8646.
And what is the body of it?
Hello, Thomas found the phone playing on William's bed. William said he forgot it was there. Ha ha ha. Okay, call anytime.
What is the date and time? Now, this doesn't say delivered, correct? Or is there a time when it was delivered?
It does not say, sir.
What is the date and time in the bottom corner of the text?
January 2nd, 2023 at 2:33 p.m.
And so, sir, if there's no delivered, what does that mean?
I don't believe it was ever delivered to the intended recipient.
But there's a date and time. Is that when the text was written?
The bottom right?
Yes.
That's when it was sent.
That was when it was sent, because there's a status saying sent.
Correct.
Okay. Could we scroll down to the next text? Trooper, which phone number is sending this?
The number ending in 8646.
Could you read the body of this?
Hello, where are you? Please call, text, or email. Exhausting day with the boys, and we had fun. Going to bed early. Big day tomorrow for everyone. I still love you. Ha ha ha.
And what is the date and time in the bottom?
January 2nd, 2023, 7:18 p.m.
And does this note if it was delivered?
It does not.
Could we go to the next page, page 52? Which number sent this message, sir?
The number ending in 8646.
And what is the body of it?
Hello.
And what is the date and the time?
January 3rd, 2023 at 6:39 a.m.
Does this denote if it was delivered?
It does not.
Could we have the next text? Which number sent this?
The number ending in 8646.
And what is the body of it?
Where are you?
And what is the date and time of this?
January 3rd, 2023, 6:39 a.m.
And this has a status of sent?
Yes.
Could we have the next message? Which number sent this?
The number ending in 8646.
And what is the body of it?
I'm worried. Please call or email.
And what time was this sent?
January 3rd, 2023, 6:39 a.m.
Could we go to page 53? Which number sent this message, sir?
The number ending in 8646.
What is the body of this?
Where are you? I just called and it went straight to voicemail. Calling you in Viber now.
And what is the date and time this message was sent?
January 3rd, 2023, 8:30 a.m.
Can we have the next message, please? Which number sent this?
The number ending in 8646.
And what is the body of this text?
I will call after I drop the boys. If I don't hear from you this morning, I'm going to report you missing.
What is the date and time this was sent?
January 3rd, 2023, at 8:32 a.m.
And going down to the next message, what number sent this message?
The number ending in 8646.
What is the body of this message?
Hello, I texted your sister and Alyssa. I am calling Jeff if I don't hear from you. Where are you?
And what is the date and time this was sent?
January 3rd, 2023, 12:16 p.m.
Going down to page 54. Sir, which phone sent this message?
The number ending in 8646.
And what does the body of it say?
Hello.
And what is the date and time it was sent?
January 3rd, 2023, 7:03 p.m.
And the next message, sir, which phone sent this?
The number ending in 8646.
And what is the body of this text?
Where are you? The boys and I are worried. I'm calling work tomorrow if I don't hear from you.
And what is the date and time this was sent?
January 3rd, 2023, 7:04 p.m.
Going down to the next message. What is the phone number that sent this?
The number ending in 8646.
And what is the body of that?
Where are you?
And what is the date and time that was sent?
January 4th, 2023 at 10:14 a.m.
And can we go to page 55 for the final message? Sir, what number sent this?
The number ending in 8646.
And what is the body of it?
I am calling Jeff now.
And what is the date and time it was sent?
January 4th, 2023, 10:15 a.m.
For the messages on January 2nd through January 4th of 2023, does any of the messages denote that they were delivered?
It does not appear that.
Your Honor, I have no further questions.
Cross-exam.
Morning, sir.
Good morning, sir.
Yesterday you testified to what you referred to as location data, correct?
Yes.
And the location data that was retrieved by apps, various apps that are contained on the devices.
Yes.
And is it fair to say that with regards to apps being able to collect location data, that service can be turned off in those devices?
If the user decides to.
Okay. And if the user decides to turn off the location tracking aspect of any app, then that particular app just does not collect the location data, correct?
To the best of my knowledge.
Okay. So, to the best of your knowledge, then, if someone knew how to turn off the location data, all the apps on any device that they were using to go from point A to point B, you wouldn't have that data that you told us about yesterday.
The phone collects quite a bit of data at all times.
I thought you just answered the second to last question. To the best of my knowledge, if you turned off the apps, the device would not collect location data.
Well, app-specific location data. Yes.
I'm sorry, you're going to have to speak up if you don't mind.
You're asking about app-specific location data, correct?
All right, yes.
Okay, yes.
So, are you telling this jury that if someone turned off the location tracking aspect of an app, that you would still get location data from other sources?
There's a possibility, yes.
Possibility, all right. I want to focus your attention now to Exhibit 161. That is that's the Safari search history.
Okay, yes.
When you say okay, you mean yes?
Yes.
Is that what you mean? Okay. I don't want to confuse you. If I ask a question, just tell me, ask it again, and I'll.
Yes, sir.
That's the Safari search history of the Apple iPhone 13 mini, and it ran a date range of December 25th, 2022 to January 4th of 2023. Is that right?
Correct.
And then that same exhibit, and I think it was referred to yesterday, contains what was referred to as Chapter 2. You recall that? And the Chapter 2 is the Safari web history of the same device that runs from December 31st, 2022, from 9:28 a.m. to 9:31 a.m.
Correct.
Is that correct?
Yes.
And you testified yesterday that even though the data would be collected and extracted from those two sources, the search history and the web history, that the web history would generally contain additional and more detailed information?
That's correct.
And who was it that decided then to limit the web history information included in Exhibit 161 to only 1 day for just a couple of minutes?
It was a decision by the prosecution team.
Okay. And so you told us yesterday that you work for the Norfolk County District Attorney's Office, correct?
Yes.
So, and you told us yesterday that you're an investigator, correct?
Yes.
And so, as part of your role as an investigator with the Norfolk County District Attorney's Office, is it fair to say that you take direction from the District Attorney prosecuting a particular case?
More collaboration. We bring the investigative piece. They bring the legal advice and piece to the case.
Do you ever then inform the district attorney, whoever it is that you're working with on a particular case, that, for instance, web history would have additional information that might help explain entries that were found in the search history?
I present the data that is extracted from the device.
So my question was, do you ever take the time to explain to the district attorney assigned to the case you're working on with them that the web history would contain additional information in addition to the search history?
Yes.
So in any event, with regards to Exhibit 161, you were instructed or advised to only include the web history for one day, December 31st, and only for a few minutes.
Well, that particular searches were on Apple Maps, which were contained on Safari history, search history.
Were you instructed not to include certain information in Exhibit 161 then?
We had the date range of December 25th, 2022 through January 4th, 2023, sorry.
And what about the web history? Were you instructed only to limit the inclusion in Exhibit 161 to that one day, December 31st?
We only chose to do that specific, those specific searches from 9:28 to 9:31 a.m.
Okay, I'm just going to ask, and it's probably me. I can barely hear you.
Sorry.
I'm sorry. I might be going deaf.
That's fine.
Piers, are you able to hear?
And
Great.
Apologize.
That's my concern. But you need to be able to hear him as well. I'm concerned about that.
I understand.
Do my best.
Yesterday, you were asked, let me ask this. You would agree, wouldn't you, that in the search history included in Exhibit 161, that at page number 9, there are indications of a search involving Expedia and other flight-related searches?
Could you show me that, sir?
Sure. Do we have Exhibit 161? I see.
You may.
Thank you, sir.
Or refer to you as Trooper? Or do you have another title? I just don't want to misstate.
No, that's fine, sir.
Trooper?
Yeah.
So, Trooper Key, I want to focus your attention now to page 1 and the entry number 9. Am I correct in saying that that references a search related to Expedia?
That's correct.
And that search occurred at 12:25:22 at 11:39 a.m. Is that fair to say?
Yes.
And those searches related to Expedia, they continue through record number 20 at page 2. Is that correct?
Yes, it goes from Expedia to Check a Flight to Check a Flight JetBlue.
All right. So yesterday you told us and you testified to one entry having to do referring to JetBlue, correct?
Yes.
There's a number of searches in Exhibit 161, isn't there, that have to do with searches for Expedia and flight information?
Yes.
And once again, if you were to look at the Safari web history of the same device for this same information at the same time, you would find more information and put context into that search. Is that accurate?
Yes, there would be more information.
Okay. But as you sit here today, and based on what is and is not included in Exhibit 161, you can't give us more context to any of those searches regarding flight information, can you?
No.
Yesterday, and I'm going to ask you to turn to page 4. Yesterday, you were asked questions about an entry on page 4, record number 42. Am I saying that right when I refer to record number 42? Do you understand what I'm talking about?
Yes, sir.
Thank you. That was a search regarding what?
Number 42. Would you like to read the date, time, or just the search term, sir?
You can read it anything you want.
Okay.
Yes, to make it complete.
Item 42. The search occurred on December 25th, 2022, 12:28 p.m. And the search was Xmas Day plane crash.
Okay. And those types of searches, and when I say those types, the subject matter that's contained in record number 42, it continues through record number 45 on page 4, doesn't it?
Yes.
And that is timestamp 12/31/03 at record number 49.
Correct.
Now, yesterday you were also asked about a specific reference, and once again, page 4, record number 53. And that's the record that indicates Anna Walshe found dead, correct?
Correct.
And those searches continue through 12:45:58 on page 4, don't they?
Yes.
Now, it's fair to say that once again, if you had the web history to that particular search, that would give more context into what that particular search is that you just talked about at number 54, record number 53 at page 4. It would give you more information and more context, would it not?
It would. Yes.
You have no idea, do you, as you sit here today, what the user was thinking when he or she inputted that search that you just testified to, do you?
I do not. I know the content of it. I do not know the intent of it.
Okay. Are you aware of the fact, given the fact that you're an investigator, and I presume you conducted some investigation in this case on behalf of the Norfolk County District Attorney's Office, are you aware of the fact that Mrs. Anna Walshe, her flight was canceled on 12/25?
Yes.
And did you investigate the circumstances of that cancellation?
I personally did not.
Okay. So you're unaware of the snowstorm or anything like that that caused canceled flights?
I don't know the particulars around the.
All right. I want to focus your attention once again at Exhibit 161 to a number of searches that began at record number 445 at page 30.
Page 30, sir?
Page 30. And it's record number 445. Are you there?
Yes, sir.
Okay. It's fair to say, isn't it, that in looking at those entries starting at 445 and continuing through record number 495 on page 34, that they involve searches for what looks to be champagne or wine and varieties of champagnes and wines?
Do you mind if I take a look?
I don't mind at all. No,
okay. 445 through
495.
495. Yes, that appears wine and champagne.
Okay.
Through those searches.
And it's fair to say, isn't it, that you've carefully reviewed all these records, haven't you, before you testified here starting yesterday?
Yes.
And if you turn to page 62, beginning at record 924, and I'd ask you to just run through up to page 63, record number 943. Once again, a number of searches regarding champagne or wine or things like that.
Yes.
Okay, you agree with that, right?
Yes.
And we could continue to do this, but for instance, though all of those searches were being conducted on December 30th of 2022, weren't they?
The ones from line 924 through 943, yes, they were on December 30th, 2022.
And the searches between record 953 through 1016 on page 68, do you have those in front of you?
What was the beginning item, sir?
Record number 953, page 64.
Okay.
Through record number 1016, page 68. Once again, those searches occurred on December 30th, correct?
I'm still looking, sir.
I'm sorry. You tell me when you're ready.
Yes, sir.
And don't let me rush you.
Yes, those searches occurred December 30th, 2022, between approximately 7 p.m. to around 7:15 p.m.
Right, on December 30th, correct? Yes?
Correct.
And you're aware, in the investigation of this case, that Mrs. Anna Walsh had planned a New Year's Eve party to be conducted in the Cohasset home on New Year's Eve, correct?
Yes.
And you're also aware that, or maybe you're not, but there are additional searches throughout this as you continue to go down these searches that, once again, someone is shopping for expensive champagne, someone's shopping for champagne or items like that, all in the same time period, correct?
Yes.
Now, yesterday, you were asked specifically by the government to testify to an entry number, record number 1069 at page 72. Can you find that? It's at 8:38 p.m. on 12/30/2022. Record number 1069 at page 72.
Yes.
And you testified yesterday, and you were asked what that search was, and you stated to the jury, "I'm good." Correct?
Yes.
And you didn't give any other context to that, correct?
Correct.
As an investigator in this case, you are aware of the fact that there is a movie named I'm Good, correct?
Yes.
Okay. And you're also aware of the fact that if you were to look at the search web history related to that search, that it would further explain and give context to that search, and that I'm Good is a movie. Is that fair to say?
I would have to see the web history itself, sir.
Okay. So you would agree, wouldn't you, Trooper, that that search that you were asked specifically about yesterday, I'm Good, at record 1069 at 8:38. That search regarding a movie occurred in between all this all these searches going on, having to do with champagne and wine and everything else, correct?
This occurred after the ones you had me read prior. I would have to look if there were searches containing wine and champagne after, sir.
Well, let me focus your attention then, and that's a certainly fair and accurate response. Why don't you look at page 72, the same page, and record number 1078. Have you had a chance?
Yes, sir.
And once again, that's champagne-related searches.
Yes.
So it's fair to say, isn't it, Trooper, that when you were asked yesterday on direct examination and to specifically refer to that one search at number 1069, I'm good, there's certainly nothing nefarious about someone conducting a search for a movie entitled I'm Good, correct?
Again, sir, I only know the context of this. I don't know the content or the content, I don't know the intent behind it.
You would agree that these records that you have in Exhibit 161, if you know, they have multiple searches related to movies and movie titles, correct?
I just know the I'm Good one that you referenced, sir.
Okay, well, let me just briefly point you to record number 1128 at page 75, if you can go there.
Yes, sir.
Are you there?
Yes, sir.
Starting there, if you could just start there, that looks like a reference to a movie or a movie clip, correct?
1128
Yes.
states tone MOV, TOE-MOV.
Do you know what that refers to?
I do not.
Okay. Just now run through the searches and up to and including number 1147, page 77. Can you do that? And as you look through those, there are multiple references to movies and movie clips, if you know.
Yes, there is, sir.
And then, finally, if you can look at record number 1148 on page 77, now we start some more champagne searches. Is that accurate?
Yes, it is, sir.
So, you're not, as you sit here today, you don't know who was actually searching for champagne and those related searches all during this day of December 30th.
I do not.
And you don't know who was searching for all those movies and things like that.
I do not.
And you wouldn't testify to the jury now that there's anything nefarious about someone conducting multiple searches for champagne or movie clips, is there?
Could you repeat that, sir?
There's nothing nefarious about someone searching for champagne or multiple movie clips during this period of time.
No.
And based on your investigation of the case, you did carefully look at each entry of the searches, correct?
Yes.
Now, once again, yesterday specifically, and you can turn to record number 1271, page 85, you were asked specifically yesterday by the government to look at that search. Can you look at that one again and tell us what it says?
Line 1271, dated January 2nd, 2023, 6:42 p.m. And the search states, I'm good.
So you testified to that yesterday, and you gave no context to it, but once again, it's a reference to the same I'm good that we saw had been searched for back in December 30th, correct? While someone is conducting champagne searches, correct?
Yes.
And as you sit here today then, You can't tell the jury that there's anything suspicious about or nefarious, that's my word, about this search you were asked about yesterday that was conducted on January 2nd of 2023 at record number 1271.
No.
Trooper, I'd like you to look at record number 1170 at page 78. That occurred on December 30th at 11:16:34 p.m.
$11.70, sir?
Yes, sir.
Okay.
You have that?
I do.
What does that search?
Search occurred on December 30th, 2022 at 11:16 p.m. and it states nightshade.
Okay. Now, you're an investigator assigned to the district attorney's office, and you worked on this case. Is that correct?
Yes.
And what is that nightshade referring
Would you like me to explain the searches below? I believe it's related to what you're asking.
to? Absolutely, if that helps.
Yes. It says nightshade noodle bar.
And those searches go through record number 1175 through page 79 regarding nightshade and noodle bar and things like that.
Yes.
So tell us, Trooper, what is nightshade or nightshade noodle bar? What is that?
I believe it's a restaurant.
Okay, and where is that restaurant located?
I am not sure, sir.
You're not sure. If I told you it was located right on the town line, close to the town line of Marblehead, Massachusetts and Lynn, Massachusetts, would that sound accurate to you?
I would have to search it.
Okay, so you haven't searched it.
No.
In the context of this case, you have, as you sit here today, you have no idea of then the context of that search regarding nightshade, do you?
It appears to be a restaurant, sir. That's
All right.
all I can say.
And are you aware of the fact that in your investigation of the case that Mr. Walsh actually made a reservation for a New Year's Day dinner at the Nightshade restaurant for himself and Miss Anna Walsh for New Year's Day?
I was not aware of that.
I would ask at this time to have this plug for ID. Okay. Sure.
Anybody want to show it to me? That'd be a good idea. Thank you.
May I approach you?
Yes?
Sir, you all set with this?
Pardon?
You leave this here? Okay.
Trooper, I'm just going to show you what's been now marked for ID as Exhibit J. Have you ever seen that before in your examination of the iPhone? The iPhone 13?
I reviewed the messages. I don't specifically recall this one.
You would agree, wouldn't you, that that message indicates in its context that it's a reservation at the Nightshade Restaurant?
Yes, sir.
And what is the phone number that it was created from?
The phone number ending in 8646.
I apologize. Did you tell us that you had or may have seen it? You just don't recall as you sit here?
Yes, I reviewed the text through the past few years. I probably have seen it in the past, but I don't recall it.
At this time, I'd move to have that text put in there.
Any objection?
No objection, Your Honor.
The text message that's previously been marked for identification as J is now in evidence as Exhibit 170. Thank you.
So is it accurate to say then, Trooper Keefe, that with regards at least to this particular text and the information that it contains, that to the best of your knowledge, nobody from the Norfolk County District Attorney's Office, such as yourself, as an investigator, went up and talked to anybody at Nightshade or tried to get records of any reservation that had in fact been made on 12/30 for a dinner date?
I did not, sir.
Okay. Trooper, I'd ask you to look at Exhibit 161 at record number 1250 at page 84. It's a search conducted at 12/31/22 at 10:26:16 a.m. Is that correct?
Yes, sir.
And if you will, sir, follow that search up to and including record number 1270 through page 85 that ends at 6:42:54 p.m.
What was the ending line, sir?
Record number 1270
1270. Okay.
at page 85.
Yes, sir.
What do those searches involve based on the content of the search query?
These searches appear to be kids' play places, how to file for a charity, can you donate your lottery winnings, how to file a 501c3 for a church.
It's fair to say that those searches involve queries about charities and how to file charities related to a church or things like that, based on the search queries, correct?
Yes.
And do you know what a 501c3 is?
I believe it's a nonprofit charity or organization.
Did you or anyone from the Norfolk County DA's office, to the best of your knowledge, investigate what that charity search involved?
I did not, sir.
And that charity search was conducted on December 31st, New Year's Eve, at 10:26:16 a.m. That's the search at record 1250, page 84, correct?
Well, 1250, sir?
Yes.
1250 is can you donate your auto winning tax-free?
Okay, I'm sorry. It doesn't specifically include the word charity.
It does not.
Thank you for correcting me. As you go down to the next searches, 1252 on, it specifically starts talking about charities and 501c3s.
1256 begins the searches for filing a charity.
Thank you for correcting me. No one went and tried to find out what that was about.
I did not, sir.
Okay. Yesterday you were asked specifically, sir, to tell the jury what was a search at record number 193, page 14. Can you turn to that? It's page 14, number 193. Are you there?
Yes, sir.
And you were specifically asked what that search was about, and you told the jury it was about Autobahn, correct?
Yes.
And you were asked nothing else about any of the related searches that go through record number 198 regarding Autobahn, correct?
Correct.
And some of those searches specifically state Autobahn USA, correct?
Yes.
What is Autobahn USA?
I believe it's a car website or
Okay,
vehicles,
so,
motor vehicles.
okay. And are you aware, based on your investigation of this case, that, and based on the content of the text messages between Anna Walsh and Brian, that Anna Walsh had asked Brian Walsh to buy her a Porsche?
Yes.
And are you aware of the fact that they talked about him buying her a Porsche in the text messages?
Yes.
And are you aware of the fact that he sent her pictures of a Porsche? In fact, 2 Porsches that were for sale?
Yes.
Are you aware of that?
Yes.
And are you aware of the fact that that took place on December 25th of 2022?
Yes, sir.
Did you ever go out in the context of the investigation of this case and talk to anybody at Autobahn to see if Mr. Walsh had appeared and was talking about buying a Porsche for Anna Walsh around Christmas time of 2022?
I did not, sir.
Okay. Sir, I want to focus your attention to record number 418, page 29. And that is a search that was conducted on December 27th of 2022 at 6:17:23 a.m. Am I right about that?
Yes.
And the related searches to that, they go through record number 438, correct?
Correct.
Those searches are related to a Verizon store, correct?
Yes.
And they're actually location searches in some instances of a Verizon store, correct?
Yes.
And it's a Verizon store located in D.C., correct?
That is correct.
It's not a Verizon store located in or around the Cohasset area, is it?
No.
And are you aware of the fact, Trooper Keith, that on or around December 27th, contained in the text messages that have now been introduced into evidence, that Ms. Walsh stated to Mr. Walsh that her phone wasn't working properly at the same time on 12/27.
Yes, I do recall those.
And that she told him words to the effect of it just literally stopped working, or words to that effect.
There was something to that effect, yes.
And he texted her back and said words to the effect of, do you want me to get you a new phone, or do you need a new phone, correct?
I believe it was something like that, sir.
And then in the early morning hours of December 28th, Mr. Walsh sent her information about, well, here's a Verizon store in D.C. that you might go to if you need help.
Yes.
And she responded, do you remember that?
I remember the messages about the Verizon store.
Yesterday, specifically on direct examination, you were asked about a search conducted at record number 1368, page 92. And that search was conducted on January 4th of 2023.
Sorry, sir, what was the line again? I just got to the page.
I'm sorry. Record number 1368, page 92.
Okay.
You were asked about that yesterday.
Yes, I was.
And you told this jury it was about the Mazda building.
The crossing building.
Oh, the crossing building.
Yes.
But you weren't asked for the context or anything of the sort. You just simply told the jury what the search query was, correct?
That's correct.
I want to ask you now to go back to record number 804 at page 54. Are you there, sir?
Yes, sir.
Is it fair to say that beginning at 804, page 54, on December 29th of 2022 at 9:13:47 p.m., that those searches are related to the Mazda building also?
Yes, sir.
And those searches go through record number 825 at page 55.
Yes, the Mazda building, crossing building. Correct.
So yesterday you weren't asked about those searches that go back to December 29th. You were only asked about the search on January 4th. Is that correct?
No, I believe I was asked about those searches prior to.
All right, fine. Then I'm
Yes.
wrong. Do you know what the Mazda building is?
It's a building in D.C., I believe, near where Anna Walsh works.
What about the crossing?
I don't know those specifics, just building in D.C.
As an investigator in this case, and since you were asked specifically by the government yesterday to tell the jury about those searches, you went and investigated, didn't you, what had been occurring at the Mazda building in Tishman Spire regarding their management of the Mazda building in that area?
I don't know the specifics, sir.
Are you unaware of the fact, Trooper, as an investigator connected to this case, that there was a Legionnaire disease outbreak in October of 2022 of those properties that were managed by Tishman Spire?
I was not aware of that.
Are you aware of any letter that's contained, or let's strike that, that's not fair. Are you aware of any letter that was issued by the DC Department of Public Health specifically to Ann Walsh in her capacity as Regional General Manager regarding that Legionnaire disease outbreak?
Objection.
Sustained.
Did you investigate and ask anybody at Tishman Meyer about anything occurring in October regarding the building that they were managing, specifically that Anna Walsh was managing?
Objection.
We'll see at the side of the bench.
So I would ask you, Mark.
It's marked as K for identification.
Based on your review, Trooper Keith, of the contents on the iPhone that is the subject of Exhibit 161, it's fair to say that in the searches running from the date of December 25th of 2022 up and including the end of December 31st of 2022, you saw no evidence of searches in the Safari search history regarding any searches for things like tools or searches suggesting how to dispose of a body or anything like that, correct?
I did not see any of those December 25th to the 29th.
Okay, and it's fair to say that based on your review of the search queries that were made and are contained in Exhibit 161, what you see for the search queries, it's fair to characterize them as there's multiple searches for various actors and actresses and music and movies, piano lessons, kinder care, and even a dog barking toy. Do you recall those?
I do, sir, yes.
And you were asked something about yesterday, and I'm sorry I don't have the citation, and that's my fault, but do you remember telling this jury about a search that involved something called My Exes?
Yes.
Then the search right below it, I think, if you recall, and I once again apologize I don't have the citation, but I think you were asked on direct that it also had something like a reference to a song, correct?
Yes.
But you weren't asked to give context to that at all. You just told the jury what the search was, correct?
That's correct.
And you would agree with me, wouldn't you, sir, that once again, there's just nothing nefarious about someone searching for what turns out to be a country western song, correct?
Correct.
Trooper Keith, you in the past applied for search warrants, haven't you?
I have, sir.
And you know what the procedure is, correct?
Yes.
And you understand that, are you familiar with the phrase probable cause?
I am, sir.
And can you just explain briefly what probable cause means in the context of getting a search warrant?
Objection.
Overruled.
The facts and information pertaining to your investigation in order to charge a crime, more or less. More likely than not that this crime had occurred.
And it's fair to say that once you start an investigation, your experience tells you that you might get a search warrant that covers a particular time period. And if you get information, either based on the content of what you discovered pursuant to the search warrant or your continued investigation, you can return to a court and apply for an additional search warrant, can't you?
It depends what the search warrant is for, what the search warrant is for.
In a case where you're investigating what happened, such as this, what happened to Anna Walshe, wouldn't it be important to you to look back beyond 12/25 of 2022 to see if there was any evidence in the iPhone Mini or the iPhone SE or the iPad or the MacBook to see if there were any other entries that indicated that the person using those devices had planned to do any harm to Anna Walshe?
At the time, we did not have probable cause to expand that search warrant, sir.
Well, you certainly had At the time? I'm sorry.
During that investigation. During-
You have to speak up a little bit.
Sorry. Could you repeat the question again?
I'm sorry.
Yeah, it was.
You would agree.
Objection, Your Honor.
I'll see you both at the side of the bench. you know we're working over there and discussing a lot of evidentiary issues. But you can get up. It's sort of tight because there's a lot of you doing that. But you can get up and stretch and move around. You can even step off, like right there, if you're lucky enough to be on an NC. But just keep yourself alert, comfortable. All right? Thank you.
Yes, sir.
Who was the Mass State Police officer designated as, quote, the case officer in the investigation of this case on or around January 8th of 2023?
That would be Trooper Michael Proctor.
And what does case officer mean in that context?
You manage the case. So you're the lead case officer. You delegate tasks and things that need to be done throughout the course of the investigation.
So you manage the case and you oversee the investigation. Those are your words, right?
Yes.
And it was Michael Proctor.
Yes.
And it is fair to say, it's accurate, that you, in fact, you signed off on and applied for some search warrants in this case.
Yes, I did.
And you were the trooper in charge, being a forensic digital specialist, to analyze the data on the iPhone Mini, correct?
The iPhone 13 mini, yes.
But you yourself, then, just yes or no, you yourself you never applied for any further search warrant to look at more data on the iPhone 13.
I did not.
Trooper Keefe, yesterday, you were asked to show what was referred to as a PowerPoint presentation, correct?
Yes.
And in that PowerPoint presentation, what you did was you compiled, with the use of the Lexis software, you compiled a bunch of data points and believe that you were able then to explain the certain locations of those two phones, the iPhone SE and the iPhone Mini, over a period of time relevant to the investigation of your case, correct?
That's correct.
And correct me if I'm wrong, but one of the reasons you compiled that PowerPoint presentation, I call it a presentation, but you compiled a PowerPoint, was to try to assimilate and get a lot of information together so you'd have context for the information, correct?
Within that GPS data set, there's thousands of points. So this is just one specific point within that data set for those two different devices.
So when I use the phrase to give context, in other words, once you start using that location data, and based on your review of the digital data, then you can make further conclusions about what a particular data point means when it shows up on the location data, right?
Unsure of the question, sir.
Well, it was a terrible question, so let me try it this way. You know, if you just look at those data points individually without any context, you don't know what data point came before it, you don't know what data point came behind it. All you have is a bunch of individual data points that really don't tell you much of anything. Correct?
No.
Well, I'm not correct.
No.
Once you put together all those single, independent data points, you begin to better understand what the location data is telling you.
Once they are uploaded using the mapping software, it's an interactive map, and you can look at the thousands of data points day day by day times, specific dates, times. They'll map out specific dates, times of the events of the location.
So it helps you better understand what the events were over a period of time.
Yes.
So did you ever put together in the investigation of this case the information that was taken out of the iPhone 13? And did you ever take it and put it in some format where you compared it to the other digital data, for instance, that was taken off the MacBook Gray, device number 3?
You'll have to specify data. I don't know what data you're talking about.
No. The data on the MacBook about, it included the activity that was gleaned from the MacBook beginning on or around December 25th up to and including January 1st of 2023.
Is there anything specific? There's a lot of data contained within both devices. I'm not sure what you're asking me to compare.
Well, I think you told us, Jerry, yesterday that with regards to the location data, you had something like over 40,000 data points to deal with, correct?
From the iPhone 13 mini, yes.
Okay. So then you decided, out of that 40,000 different data points, you decided which ones you would use to help better understand what events occurred during that relevant time period that you testified to yesterday, correct?
Yes.
So I guess my question is that, did you ever make an effort to get all the data information from the MacBook Gray searches and then compare it to the data that you took off the iPhone 13 mini and look at that data and line up and see what happened over a period of days, 12/25, 12/26, 12/27, through January 1st, according to the times of when each event happened on each one of those days between those devices?
So Trooper Nicholas Guarino did the MacBook extraction and analysis. Are you asking specifically about location data?
No, I'm talking about the data that was gleaned from the MacBook Gray and, for instance, the data that you gleaned from the iPad, from the iPhone mini.
I did not compare the two, if that's what you're asking.
Would you agree with me, Trooper Keefe, that if you lined up all of the data that showed what happened on those two devices, for instance, the information, the activity on the MacBook, and you combined it with the activity on the iPad, on the iPhone mini, I apologize, the iPhone mini 13, that you would have a better understanding of exactly what was going on during the day of, for instance, 12/25/22 and 12/26/22, that would help you better understand the context of the information.
Objection.
Overruled.
There are two different devices. They'll be used at two different times.
Well, you used two different devices, used at two different times to compile your location data, didn't you?
Yes, for different days throughout that time frame.
Right. So it's not, the issue isn't two different devices, is it? It's the fact that you have two different devices operating on the same day. You actually can combine all the activity that happened on device A and with the activity that happened on device B and have a better understanding of what was going on.
I did not compare the two devices, sir.
So, I hate to do this, Judge.
Yes,
Can we come to sidebar?
you may.
pictures. Why don't you, I'm not sending you on a break. You can stand up and move around. We need to do a little work. Well, we're still here in the courtroom, but it's not. But I need to send you out. So you can stand up if you want.
Boy, what's coming up? I heard Michael Proctor's name was mentioned. Somebody want to catch me up? No, only 2 of the 3. Hi, got a secret. You can keep it. So good to see you, my friend. And God bless you to that wonderful super towel up here with me in the northern tundra who knows I can't leave the house when it's 19 degrees with a -5 wind chill. It literally killed me this morning. That was hard. Anyway, God bless you for sending a towel donation for lunch. Yes, Little Towel is providing you a public information service, and I am grateful to all of you for watching, for talking, for being you. You are special because you are you, and don't you ever forget that. That's why I remember all of you. This is very interesting, though, the mid-morning motion hearing. It might not be a motion hearing. It might be an evidentiary hearing. Sorry, I burped a little bit. Anyway, my point is, we're going to watch it together. Why? Because I'm a towel. Try to get you guys the best audio I can. I'll boost the feed if I need to. They walk away from the mic sometimes. It's nobody's fault. They're just stationary mics. Also, we have the 2:15 TurtleBoy hearing, of course, but that is not for 3.5 hours. So, everybody sit tight. Everyone be a little towel. I am a little towel. All right. What are we talking about? Come on, Larry Tipton. What do you got to say?
My apologies.
Oh, there you go. We're all set.
I think if I could quickly ask that exhibit number 169 be brought up on the screen. Then, Trooper, you have your exhibit, your product is exhibit 161. You have that.
Yes.
Now we need to call it. I think it was the last exhibit. Exhibit 2, it's the last exhibit.
168.
And may I approach your honor?
You may.
Well, it's going to be hard, Trooper. I'm presenting you with what's been marked Exhibit 168,
Okay.
characterized as the call log.
Yes, sir.
So just so the record's clear, 168 and 161 is before the witness right now? Okay, just want to make sure.
Correct?
160.
Yes, 161, 168.
Right.
And the text messages were introduced this morning as Exhibit 169.
One sec, we got to go back to get one clip from 17 minutes ago. Hold on, listen to this.
Working on it. A lot of you doing that. Working on it. And discussing a lot of evidentiary issues. But you can get up. It's sort of tight because a lot of you doing that. But you can get up and stretch and move around. You can even step off, like right there if you're
Yesterday, and I I'm sorry I don't have the citation, and that's my fault.
Overruled.
The facts and information pertaining to your investigation in order to
We're looking for it. We're going to get the moment. Michael Proctor came up, so it was after a long sidebar. It was at 10:31, so it was 18 minutes ago or so, but for some reason the court TV feed's a little bit off, so it should be right here. Hold on.
Stop and stretch and move around. You can even step off, like right there, if you're lucky enough to be on an NC. But just keep yourself alert, comfortable. All right? Thank you.
Right, it's right here. Hold on.
Yes, sir.
Who was the Mass State Police officer designated as, quote, the case officer in the investigation of this case on or around January 8th of 2023?
That would be Trooper Michael Proctor.
And what does case officer mean in that context?
You manage the case. So you're the officer. You delegate tasks and things that need to be done throughout the course of the investigation.
So you manage the case and you oversee the investigation.
Yes,
Those are your words, right?
Yes.
And it was Michael Proctor.
Yes.
And it is fair to say, it's accurate, that you, in fact, you signed off on and applied for some search warrants in this case.
Yes, I did.
And you were the trooper in charge, being a forensic digital specialist, to analyze the data on the iPhone Mini, correct?
The iPhone 13 mini, yes.
But you yourself, then, just yes or no, you yourself you never applied for any further search warrant to look at more data on the iPhone 13 mini.
I did not.
137. Time-stamped 12:15?
Yes, 137.
Time-stamped 12:15 p.m., correct?
December 25th, 2022, 12:15 p.m., yes.
And that, from the call log, that indicates some interaction between the two devices, and that Exhibit 168 has to do with phone ending in 8646 and phone ending in 7966, correct? Assigned to Brian Walsh and Anna Walsh, correct?
Yes.
And there is a 1 minute, 23-second call between those two phones, correct?
Yes.
We don't know the content, do we?
I do not.
Okay. And then as you continue to proceed in this relevant time period, you go to Exhibit 161 again, at page 3, record 35.
Yes.
And that is a search conducted at 12:22:06 p.m., correct?
Yes.
And the search is Anna Walsh, Tishman Spear. Is that right?
Yes.
Now we stay on Exhibit 161 for the next 5 requests. 161, page 4, record 43. Timestamp 12:28:57.
Yes.
Search Christmas Day plane crash.
That's correct.
Same exhibit 161, dated 12/25/22, same time period, page 4, record 50. I'm sorry, record Yeah, I'm right. Record 50.
Would you like to read the content, sir?
Yes, go ahead.
Number 50, December 25th, 2022, 12:31 p.m. Jeff Chad Tishman
Right.
Cyper.
Now just keep going down. Exhibit 161, 12/25/22, page 4, record 53.
Anna Walsh found dead.
12/45/47, correct?
Yes.
And once again, I think you just told the jury, Anna Walsh found dead. Correct?
Yes, sir.
And as we continue to go down, the next is Exhibit 161, page 5, record 57. At 12:46:10 p.m.
Yes.
And it's a search for Jeff Chod, C-H-O-D.
Correct.
Now, I'm going to ask you to look at Exhibit 168 at page 11, record 132. Timestamp 12:57 p.m.
Yes.
It indicates a phone call between these two phones.
Yes.
It lasted 4 minutes and 45 seconds.
Yes, it's an outgoing call from the device ending in 8646 to the number 7966 Anna New.
Okay, and you don't know what they were talking about, if they were talking at all. You just know that there was a call that lasted 4 minutes and 45 seconds between those two phones at that time.
Correct.
And then if you go back to, I'm sorry, if we could have page 2 on the exhibit 169 for 12:57:26. And the entry is, as seen on the screen, my flight got canceled driving up. Is that fair to say?
Yes.
So just stopping there. Between 11:52, we started with 11:52, exhibit 161. We're now down at the time period of 12:57. Is it fair to say that what looks like is that Anna Walsh, at least Anna Walsh's phone, texted the phone assigned to Mr. Walsh and told and texted, my flight got canceled and I'm driving up?
Yes.
And before that, those texts that you read to the jury, where they're entered, Anna Walsh found dead, are plane crash, correct? The ones you testified to just a moment ago? Those searches, they appear to be searches to see if some harm came to Anna Walsh, correct?
Again, I can read the context. I don't know the content of the search.
But did you consider that in your investigation of the case when you looked at all this data together?
That specific search and text message?
All this data together that you just now told the jury about. Did you look at all that data together at one time like you've just done for the jury and created a context for all of those communications in those 3 different sources of information? Did you ever do that?
What the call log, 3 sources? I'm not sure what.
Did you do it?
I've looked at all 3 of them multiple times.
Did you ever look and compare them and see that there were searches that looked like someone was concerned about harm that may have come to Anna Walsh, and then when Anna Walsh texted and said, my flight got canceled, none of those alarming texts occurred out there?
Objection.
As to the characterization,
Yes.
sustained.
Did you see, I understand. Did you see any other text after the 12:57 text from Anna Walsh's phone saying my flight got canceled driving up? Did you see any text after that where there were any searches about plane crash or is Anna Walsh dead or anything like that? You didn't see anything like that, did you?
I would have to review them again, sir.
I want to ask you to look at Exhibit 168, beginning at page 11, record number 129. What is that time stamped?
You said 168?
Exhibit 168. I'm sorry, Trooper.
No,
168, record, I'm looking at record 129, page 11.
Sorry, what was the line again, sir? Sorry.
That's okay. Do you see on page 11 a call that lasted 1 hour, 22 minutes, and 33 seconds?
Yes,
An
I do.
outgoing call. Do you see that?
I do, sir.
And that is a 1 hour, 22 minutes, 33 second call that's an outgoing call from the phone assigned to Brian Walsh, correct?
Correct.
And then do you see another call on page 11 that lasted 3 hours, 2 minutes, and 37 seconds?
On page 11, sir?
Yes?
3 hours? I do
If you do not, you can say that.
do not see a call.
Do you see a call that lasts 6 minutes and 5 seconds? On page 11,
Yes, I do.
and then do you see another call that lasted 1 minute, 1 hour, 27 seconds and 27 seconds and 07 seconds? Do you see that? And that call originated on the phone assigned to Anna Walsh.
I'm not sure what. Can you repeat that?
Yes. Do you see a phone call that lasted 1 minute, 27 seconds?
On page 11, sir?
Yes.
I do not.
Then this might be a good time to stop.
Okay, we'll take a break. There's, have a nice morning break.
All rise, please.
All right, we're now on it.
Follow me.
All right. I thought we were doing a voir dire or evidentiary hearing for some reason. We were not. I'm so cold though. I just want to let you know, I don't think anyone can be warm in Massachusetts today. It was about negative 20 with a wind chill when I got up this morning. It is probably up to 0 with the wind chill now. But yeah, it's about 19 degrees Fahrenheit. That's negative something. Let me tell you how cold it was in Celsius. What is 2 degrees F in C? It was negative 16 degrees Celsius this morning in Massachusetts.
What do you need, Ethan? I'll take advantage of this time to take a look at the search warrants.
All right, here we go.
All rise.
So we're on recess. Now, what temperature is it now in Massachusetts? It's negative 7 degrees Celsius, if you speak Celsius. Good morning, current resident. I don't know what a Frenzel lens is, but the fact that you taught me it will allow me to give you a wrench. All right, so what is a Frenzel lens? Frenzel lens is it some kind of scientific instrument? A type of composite compact lens which reduces the amount of material required compared to a conventional lens. Interesting. Must be some kind of heating instrument. Do you like channel the sun and then it radiates outward to facilitate heat? That would be cool. In any event, we are on recess. in the Brian and Anna Walsh trial, and just developments galore, ladies and gentlemen. Developments galore heading into the 2:15 p.m. TurtleBoy hearing. Yes, if you're counting down, strangely, I'm sure some people are actually counting down. Not exactly sure what's going to happen. I'm thinking it's going to be pretty interesting, at least the oral arguments. We are 3 hours and 12 minutes, I did that backwards, away from that. Now, I am a little out, and I am staying with you to monitor all the developments, and we are now on morning recess in the Walsh trial. Michael Proctor's name came up this morning. He was the case manager. Does that mean the defense will be referencing Michael Proctor? I don't know. Nanya, good morning, Nanya. How are you doing? How's everybody feeling? We have about a 20-minute break here. Abby wants to go outside. Oh, no, Nancy. Nancy, I don't know if any human, dog, or otherwise can withstand this weather. Maybe you just show Abby what the weather's like, and Abby will be like, no, thank you. I am not a husky. Now, what if Abby has some husky somewhere in their lineage? You know what I'm saying? Okay, it's possible. Abby's probably like, why is the TV talking about me now? But listen, I'm just saying, you maybe just show Abby the weather, and Abby will be like, no, thank you. It is far too cold. But in any event, maybe I know some obviously breeds of dogs are way more cold resistant than others. I don't think Abby is cold resistant. But huskies, oh man, I bet if there's any huskies living in New England, they're having the time of their life right now. Current resident says a Fresnel lens is a magnifying lens, usually the size of a piece of paper, that, yes, I made s'mores oven with in the backyard once. I love it, current resident. That's kind of ingenuitive thinking we need. Those are the kind of skills that will revitalize the American Republic. We must become more self-sufficient. Nancy and I are going to start a victory garden. We have a plan, ladies and gentlemen. It's going to involve a victory garden. There's some other plan involved that Nancy and I came up with. I don't remember what that plan was, but one of the plans is a victory garden. Abby has a sweater. Oh, okay. This is excellent news, ladies and gentlemen. Even though it is cold, Abby has a sweater. Now, you might be saying, who is Abby? Abby is a dog. Now, Nancy had a Samoyed. I don't know that type of dog. That wouldn't come inside when it was cold. Yep. And listen, some dogs, I have seen the videos. Some dogs are from very cold areas of the world, and you put them in snow and try to tell them to come inside, and they'll be like, no. And a lot of people are like, why are you leaving the dog in the snow? What do you mean leaving the dog in the snow? The dog's natural habitat is the snow. Now, it's only certain breeds of dogs. But yeah, some dogs, you're tormenting them when it's too hot, and they need to be in the cold. So, wait, what did I say about a Japanese victory garden? These are American victory gardens. Absolutely not, Nanya. We will not be building. I don't think Nancy and I at any point in time had a plan to build a Japanese victory garden in America. First of all, Nancy and I don't like the damn Japanese because of what they did at Pearl Harbor. We'll think about moving on from that. I don't know if we're ready. Oh, sorry. I tried to unpause my camera, but the fan's making it slow down. I don't even want to watch the fan. We're getting rid of the fan. What do I have? Do I have a video we can watch? I might have a video we can watch. Samoyed is an all-white husky. Well, current resident, you're going to fit right in here. I'm telling you, you are very erudite, and we are little towels. And you might be saying, why are they all towels? Well, it's a long story. We have towels, washcloths, soap dispensers, microfiber towels, beach towels, towelettes, you name it, we have towels. That said, we also have a 2:15 p.m. hearing, so let's see if I can play a little video for you that explicates all of that, while also continuing to talk about how I am a towel. Now, if you're tuning in for the Walsh hearing, we are on morning recess. It should be about 20 minutes. Oh, and then we could look at what Lindsay Gattani just released. So, remember how we talked this morning about how there was new discovery filings from Robert Cosgrove? And I said that it was really strange that the date of the email that Cosgrove said that Kate Peter sent to Ken Mello was in May of 2024. Well, ladies and gentlemen, we have figured out a moving date. That date was not correct, and Lindsay Gattani has the information. So let's take a look at this. All right, there we go. Click that. Oh, yes, ladies and gentlemen, what you're about to see. So earlier today, there was a notice of discovery filed in the Aidan Kearney cases. Let me zoom out a little bit. All right. Now, you see that? You see that? little notice of discovery there? That notice of discovery says, and I want you to read it, that an email from Catherine Peter to Mello Law dated May 8, 2024, subject forward AK with 10 attachments sent by email to counsel on 12/1/2025. Excuse me? That means that was after this was turned over by Lindsay. Now, why do you say, but Grant, I thought the email that Lindsay had talked about in one of Bettero's motions was from February of 2024, February 14th. You're right, it was. So what do we see when we go over to the right? Oh, goodness. What do we see? A post from Lindsay Gattani that says, Discovery just handed over in the Commonwealth v. Aidan Kearney 2023 indictment incorrectly states that an email from State Informant Kate Peter was sent to Special Prosecutor Ken Mello on May 8, 2024. However, the email was actually sent on February 14, 2024, and is the email that I recently shared here on X. See screen recording below, which shows the exact same email, forward AK, and 10 attachments. I'm sure the CW will just chalk this up to a typo, though, right? Oh, there it is, ladies and gentlemen, Wednesday, February 14th. And look, it says, "Good morning, Ken. So sorry to hear about your health issues. Per our brief conversation, I have attached the screenshots of text messages posted to Facebook by Jennifer Altman, purported by her to be between herself and Tim Bradel. The original post was in a private Facebook group called Jennifer Altman Was Rude, but at least she has facts, created and administered by Altman. I've also noticed a couple things about Bradel's argument, just as a layman. One, he never informed the jail of the mix-up. This had to do with, like, people calling Kearney in jail, despite representing to the court that he had. His statement was pretty well impeached by testimony from the jail employee. Two, the letter Bradel provided from Demborowski, Good Counsel Legal Services, is dated 1/24/2024, the day he was served with your emergency motion, suggesting to me. All right, let's go to Lindsay's post here, and let's see if we can just read it from this screenshot. Hold on. It's got to load, ladies and gentlemen. All right, so here's the full email, and let's see if we can zoom this in. All right. So it's not actually the level of zoom in that I wanted, but I have a plan. I have a towel plan. Ready for my towel plan? All right, so this is Kate Peters' email to Ken Mello, a dramatic reading by Little Towel while we're on morning recess in the Walshe trial. All right, so here we go. It says, so we're going to end it. We ended at number 2. I'm going to just mute this in case it has music. I don't think it does, but let's go. Continue, please. Thank you. It's a video that I'm telling to continue. All right. Furthermore, per Ms. Demborowski's own verbiage, she suggested to the volunteers that they might make themselves available to Mr. Bradel, not that she suggested the use of volunteers to Mr. Bradel directly, as he has suggested in his response. Each one of these volunteers have ties to Aidan that predate his October 11th hearing by at least months, if not years, and no visible ties to either law firm. I've also attached some other items explained below. Oh, too quick. Hold on 1 second. As I'm sure you are aware, I am in contact with many of the named witnesses in both cases and have been operating on a volunteer basis as support and advocacy. They share their concerns with me, and I do what I can to educate myself and them on the pertinent laws and court process to the best of my ability. This is Kate Peters saying this to Ken Mello. In regards to the upcoming bail review, the victims are understandably concerned that upon his release he will flee or ramp up his behavior. I explained to them that a cash bail amount is not punitive or designed to necessarily curb behavior, but instead to assure a defendant's appearance in court. That being said, their concern regarding Aidan's flight risk is, in my opinion, justified for the following reasons while she's giving him bail arguments. 1, Aidan can likely afford a higher cash bail. Just from the internet, we can see that he has an active running fundraiser for legal fees that has raised in excess of $100,000. I have attached a screen capture of the total as of today, 2/14/24, showing you that was the date. The live link to the page is here. It is fair to estimate that Aiden has been making anywhere from $300 to $1,000 per live stream in Cash App and Turtle Chat donations. On a live stream from July 23rd, 2023, Aiden read out his donations that amounted to approximately $2,800 in a 2-hour stream. These donations are not taxed, and it is difficult to track how much exactly he is making, although he is claiming on his blogs that he is making a ton of money and paid $60,000 for a brand new vehicle up front due to his donations, ad revenue, and merchandise sales. And then he links to the video from Kearney. Then quotes from it. As a result of my hard work, my following drastically increased and I made more money. I apologize to absolutely nobody for my financial success. Turtle Club memberships have increased tenfold. I used to have a couple hundred members paying $15 a month. Now I have almost a couple thousand. Donos on the live show drastically increased. In case you haven't noticed, there are thousands of people wearing free Karen Reed and TurtleBoy gear with our logo on it that probably should have clued him into the fact that TurtleBoy is killing it. Website traffic and social media more than doubled, and when that happened, ad revenue increased. His figure of almost a couple thousand Turtle Club members is a bit ambiguous, but if you cut it down the middle at an estimated 1,500 members paying $15 a month, that's $22,000 per month in revenue to Aiden, in addition to his donations and merchandise sales. These are his claims, not mine or yours. Some of these are bolded. Some of them are quoted. I am so confused. She is so bad at life. B. Aiden claims to be getting 4 million page views a month per his interview with Gretchen Voss from Boston Magazine. Kearney has no such constraints. Quote, he continued to write about the case, our story, one story after another, as his monthly page views rocketed from 1.5 million, he says, to as many as 4 million. His website is using Google AdSense to bring in ad revenue. The average CPM for Google AdSense is around $2, meaning they pay $2 per 1,000 views to website operators. At 4 million views per month, he is likely making $8,000 a month in ad revenue alone. At his October 11, 2023 arraignment, Aiden was found indigent. Aiden was found indigent? Whoa, what is that? I don't even know what indigent is. Is that a word? No, indigent. Okay. I-N-D-I. Oh, she did spell it right. Oh. There was a hidden I there because it's so small on the screen. I have it zoomed in on the software. But yes, okay, credit where credit is due. It is INDIGENT. But first of all, I thought for a second that there was an extra I, but it turns out there isn't. But first of all, setting aside the word indigent, which is, by the way, kind of hard to pronounce. Setting aside the word indigent, it says here, just so folks understand, we're reading a email from Kate Peter to Ken Mello about how Ken Mello should make legal arguments about how... to keep Aiden in jail. Yes, that is right. I will give credit where credit is due, and that is indeed the right spelling. But yes, let's focus back on the meaning of her sentence, because indigent, the word means not able to pay for a lawyer. So, at his October 11, 2023 arraignment, Aiden was found indigent by probation per the interview they conducted, despite the aforementioned revenue. Aiden is likely generating every month and his recent purchase of a brand new luxury SUV in cash. This suggests to me that he is likely to attempt to hide assets and resources from the court that could be used to aid in his flight. A conservative estimate of Aiden's monthly cash revenue right now, gleaning from the factors and information outlined above, is around $3,500 a month or $420,000 a year. This is in addition to the $111,100 he has raised through the Give, Send, Go campaign. Aiden's home is currently valued at approximately $643,000 per Zillow estimate. Aiden has received additional revenue via public appearances relating to Karen Reed. $1,500 for an appearance and Q&A at the Star Drive-In in Taunton. $2,500 for an appearance at a comedy show is all that is known to us at this time. Who the fuck is us? Aiden poses a potential flight risk. Aiden, this is Kate speaking to Ken Mello, basically like a PI, and apparently speaking for Lindsay. Aiden has made statements to Lindsay Gattani expressing his belief that he is likely to be convicted, and his desire to abscond. All right, hold on. going on a slight pause. Hello, I've returned. I'm a little towel. Everybody forgive Little Towel. Listen, Pete Bunny Towel, he had an issue. He thought he saw a communist. It was actually the mailman. All right, he started running after the mailman. I'm not kidding you. Pete Bunny Towel, he just got up and started running. What? Don't tell them. Listen, he thought it was the mailman, all right? He thought there was a communist. It turns out it was just the mailman. Now, you might be saying to yourself, sir, there is no way that your stuffed Pete Bunny Towel started running after the mailman. He did. You don't understand. He's that vociferously opposed to communists that he ran after the mailman. Now, you might also be saying to yourself, sir, do we get to go back now and reread the rest of this Kate Peter email? We absolutely do get to do that. Oh, my goodness. I know. It's an exciting day. It's an exciting day for Pete Bunny Towels who don't like communists. It's an exciting day to be a towel. All right, so we're going to go through this very slow. So picking up where we left off, I think we were learning. Now, listen, some of these values, which Kate is just wrong about, they got used, I think, in the bail hearing. But anyway, Aiden has expressed statements to Lindsay, expressing his belief that he is likely to be convicted and his thought desire to abscond, indicating that he has a large sum of cash, wishes to toss his phone into a river and disappear. I've attached the screenshots, and the messages can be found in her phone dump as well. Whoa, 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 whoa. Whoa! Boom! Oh my God. Wait a minute. Whoa. Whoa. Do you understand the implications of this? On February 14th, 2024, Kate knew an extraction of Lindsay's phone was done, and Kate knew what the content. She was involved. They were going through that extraction and telling Kate about it. This was February 14th, 2024. Oh, that's so bad. It's actually a stuffed Pete Bunny current resident, which makes it even better. He is absolutely vociferously opposed to communism. Him and I, we talk a lot about the damn commies and how we need to protect America. And also, this is Pete Bunny Towel. Pete, would you like to meet your new friend, current resident? He is thrilled that he said he likes you because you are vociferously opposed to communism. I think you've just made your new best friend. He thought you were a dog at first, but, I mean, in their defense, you haven't come up on the screen, so maybe you were a dog. No, I was literally talking about a stuffed Pete Bunny. He really doesn't like communists. All right, there he is. You are making new friends by the day, Pete Bunny Towel. Peep is loved the world over. A lot of people like Pete Bunny Towel. I wake him up rudely from his naps all the time. And Peep, no goodness. He's very pleased to meet you. And he said that he doesn't care about me reading this email. He just wants to meet his friend who doesn't like communism. All right, so there you go, Peep. You and the current resident are now bonded. All right, you're going to go. Oh, he's now all awake. All right. Look at that. He's so pleased. Peep's looking at the chat. Oh, very good. All right, Peep. You take a nap. We'll be back. All right. Peep is back on his chair. Peep has a little chair he sits on. He has a little pillow, a little blanket. You know, I try to keep him comfortable, all right? He's my companion. Me and the Pete Bunny Towel. All right. Aiden called the Holden police on 12/24/23 to inquire about the bolo, and according to Holden police, made a promise to turn himself in that day. Instead, he evaded police, who were driving by his house looking for him and looking to serve him the restraining order for 3 days, until eventually turning himself in at 12 p.m. on 12/26/24. How does she know this? He called the police to inquire, made a promise to turn himself in on Christmas Eve. He then evaded police, and then until he turned himself in at 12 p.m. on 12/26. He later sent a message to his followers from jail, placing blame squarely on his victim and referring to himself as a fugitive during that time period, indicating to me, at least, that he was knowingly and purposefully avoiding authorities. Message attached. Oh, hold on. I gotta go slow because this scrolls really fast. Aiden. Oh, sorry, we already went through that part. Then she posts the thing about himself. Aiden has followers all over the country who support him financially and could likely aid and abet his escape through financial contributions, obstruction, and harboring him. I have also been documenting the messages from jail he has been dictating for his people to post on social media and blogs, some of which we are wondering may constitute further intimidation. At a minimum, he is openly continuing to taunt the named victims in these cases. I will draft another email detailing this in the interest of time and organization, as I know it's a lot, and addressing the witness's concern and desires regarding bail conditions, not the actual cash amount. Let me know if you have any questions, Kate Peter. All right, so there you go, ladies and gentlemen. That was released on social media by Lindsay Gattani, and I think you can see right there that is a big, big deal. All right, it's a big deal for a lot of reasons. Okay, first of all, it's now in discovery. Okay, and we're also going to go back to the Walshe case, folks. I'm sorry, I missed the. Hold on. I missed the return. Of course, right as I was reading the Kate Peter email, because I am a little town. All right, hold on one second. We got to get caught up, okay? We're going to quickly get caught up.
Maybe not relevant to the inquiry that's going on right now, but Attorney Porter's records are good. He wrote 76, 85, 119, and 136. Almost memory is correct too. They all go to Verizon or AT&T records, so we can talk about that more later. Anybody need anything before I bring in the jury?
Does that mean I can explore it more with you?
No, it doesn't. It just puts the record more precisely as to why, but there may be others that you can explore that with. All right?
I actually don't get it, Judge.
You don't what?
I don't get it. I'm trying to understand the rulings. I don't.
All right, well, you can make your pitch.
So you're telling us that I can't explore getting further search warrants to go back 1225 with this witness?
I think you can with regard to his sort of, I'll call it area of expertise, but that's not what you really want, right?
You mean with the Verizon records?
Yes.
Yeah. No, I don't.
I mean, as I look through back to go through, I mean, I think you have to have the filter that I'm placing right now is you have to have a good faith basis for all your questions, both sides. This, I won't call him an expert, but this trooper's expertise, as is revealed by those search warrants, is in a particular narrow focus. Now, you set the foundation for some broader thing, maybe Ken, I don't know, making reasonable inferences from what I know about the case, then I may permit it. But with this witness, and there may be other witnesses, to include Trooper Proctor, seems like Trooper Guarino had a slightly different role than even Trooper Keith. So I think there are proper inquiries or proper individuals that you might be able to make these inquiries to depth. I don't think this is one of them.
I understand the question.
Based on the record that's before me, you can ask probing questions if you wish, and you know something that I don't. Again, I'm the consumer of the evidence, just like the jury in that regard. And I certainly do have a lot of learning from the time that I've spent on this case, but on what I know right now, I don't think it's a proper line of inquiry.
I understand the court's ruling.
All right? Let's bring him back in.
All rise. Jurors entering. Court is back in session. You may be seated.
You may proceed.
Thank you. First, I'm going to apologize, but would you tell us, Trooper, that Exhibit 168, the call, that call log is arranged beginning at late dates going to early dates, correct? It starts at January 3rd, 2023.
Yes, it starts January 3rd, 2023 to December 25th, 2022.
And all of the other two documents that we're using, the Exhibit 169 and 161, those all start with the earlier dates and proceed, correct?
Yes, those are in ascending. This one looks like it's descending order.
Okay. So now that I understand that, hopefully I won't confuse you. So here we go. So now, starting with Exhibit 168 at page 11, record 129, occurring at 1:40.10 p.m. Do you see that?
Yes, sir.
That's a call that lasted 1 hour, 22 minutes, and 33 seconds, correct?
Correct.
And it was a call that originated on the phone assigned to Brian Walshe.
Yes, it was an outgoing call to the number ending in 7966, Anna New.
Okay. Staying on that document, page 11, record 126, time stamped at 3:02:37 p.m. There's a call that lasted 6 minutes and 5 seconds.
Correct.
And once again, it originated from the phone assigned to Brian Walshe, correct?
Correct.
Now, go to page 10, record number 124, an event happening at 4:11:06 p.m. There's a call that lasted 1 hour, 27 minutes, and 7 seconds.
Correct.
Now, that call originated from the phone assigned to Anna Walshe, correct?
Yes, that is an incoming call.
Are you aware of the fact, based on your involvement in the case, that Anna Walshe, her flight was canceled and she wound up driving up from D.C. to Cohasset?
On December 25th, sir?
Yes.
Yes.
And would it be accurate to say that during this time frame that we've just talked about, these three calls, that's when Anna Walshe is driving from D.C. to Cohasset?
Yes, that could be inferred from that.
So it appears from these records that during this time frame, Jim, that after her flight's canceled, her phone is texting the phone assigned to Brian Walshe saying, my flight was canceled, I'm on my way, that they're having no less than 3 phone calls between themselves, at least between their phones, as she drives up.
Yes.
To class. And then, if you can, look at the screen, and I'm referring to page 2, and the text time-stamped 6:37:46 p.m. on 12/25. It looks like Anna Walshe, or the phone assigned to her, texts, I'm an hour and a half left.
Correct.
And then as you continue on Exhibit 169 at page 3, time stamped 7:26:02, it appears that that phone texts an image of a car to Brian Walshe, correct?
Correct.
Or at least the phone assigned to him. And the photo looks like it's a photo of a Porsche.
Yes.
And now if you refer to Exhibit 161 at page 14, record 193,
timestamped 8:28:12 p.m.
193, sir?
Yes.
Yes, okay.
That's one of those Autobahn searches, correct?
Correct.
Where it appears that someone's looking for a luxury car. Or at
Yes.
least searching the Autobahn for a car.
Yes.
If we go now to Exhibit 169, and we're looking at page 3, we see a text that timestamped 10:34:50 p.m.
Yes.
And it involves a property listing at Zillow.
Correct.
And if you scroll down 1, 2, 3, 4, 5, 6, 7, 8 texts, all of those texts encompassing page 3, 4, 5, 6, and 7, they continue to be text regarding Zillow postings for property, correct?
Yes, they all appear to be text sent from the number ending in 7966, assigned to Anna Walsh, to 8646, about properties.
And those properties are all situated in or around the greater DC area or Baltimore, correct?
Yes.
And do you know, officer, from your involvement in this case, about what time Miss Walsh arrived in Cohasset when she drove up from DC?
On the 25th?
Yes.
I do not know.
If I told you that she arrived sometime around 8 or 8:30 in the evening, does that sound accurate to you based on your review of all the data?
Sounds reasonable.
So it would appear that all these Zillow listings we just referred to that are occurring sometime around 10:30 p.m. on 12/25 through 10:58, it appears that he's already home. Anna Walsh is already back in Cohasset, and she's texting on her phone to a phone assigned to Brian Walsh all of these listings, correct?
Yes.
Now we're referring you to what's been marked Exhibit 168, the call log. I'm going to refer you to record number 114 at page 10. And it shows that there was some type of phone connection for 5 minutes and 19 seconds between the phone assigned to Anna Walsh and Brian Walsh, and to the phone assigned to Brian Walsh.
Correct.
And we can go down and just follow that on page 9, record number 112. We see a 36-minute phone call between the phones assigned to Anna Walsh and Brian Walsh. Correct?
Correct.
Once again, you don't know what the content of the phone call was, but that's what it appears, that there was a 36-minute phone call between them.
Yes.
And we continue to go down. Page 9, record 106. Now, there's a 21-minute phone call, correct?
Yes.
Now we're on Exhibit 161. Now we're on a different date. We're on the next date. December 27th of 2022. I'm going to refer you to record number 316, page 22. You recognize that entry on Exhibit 161?
What was the page number, sir? Sorry, I put the 168 down.
That's fine. Page 22, record number 316.
Okay.
You see that?
I do.
It occurred at 6:57:46 a.m., correct?
Yes.
That's that reference you were asked on direct examination yesterday, that reference to all my exes, correct?
Yes.
And then on the same day, and now we're looking at Exhibit 168, the call log. We're going to refer you to page 9 and ask you to look at record 104. They begin a series of phone calls 3 phone calls, 10 minutes and 43 seconds, 1 minute and 1 second, a third one, 26 minutes and 21 seconds, all originating from the phone assigned to Brian Walsh to Anna Walsh. Do you need me to tell you exactly what the records are? I apologize.
Yeah, could you go again with the record number, sir?
Yes. 104,
Okay.
102, and 100.
Okay, yes.
Okay. And then there is at record 98 on page 8, 98 at page 8, there's a 23-minute phone call.
Correct.
And that originated from the phone assigned to Anna Walsh.
Correct.
Now, I want to refer you to now the text messaging that's been entered as Exhibit 169 at page 7, and it's timestamped 10:59:32 a.m. And it appears that the phone assigned to Anna Walsh texts, when can they have the thing signed? Do you see that?
I do, sir.
And immediately following that, in the call log, Exhibit 168, is a phone call that lasts 6 minutes from the phones assigned to Anna Walsh and Brian Walsh. And it originated from Anna Walsh's phone, didn't it not?
I'm just checking the call log now, sir.
Do you see that?
I see the text, but I don't see the specific call you were referring to in the call log, sir.
Okay. Let me try to give you page 8,
Yep.
record number 96, time stamped at 11:05:17 a.m.
Page 8, 98 on this one has a different time and date, sir.
All right, what is it? Just tell the jury what it is.
This one is December 27, 2022, 10:41 a.m. That's number 98.
Okay.
This one.
And it lasts for 23 minutes, 10 seconds.
Yes.
Go on down to now, page 8, record number 96 on the same exhibit, 11:05:17 a.m. A phone call that lasts 6 minutes and 54 seconds.
Correct.
Now, we're going to jump down a little bit, and at Exhibit 169, the text messages, on page 8, a text message timestamped at 6:36:44, there's a text that reads, "Did they sign?"
Yes, I see that.
And then you see a text following that, the very next text, timestamped at 6:39 p.m. in Exhibit 169, and it looks like it originates from the phone assigned to Anna Walsh, and she says, "I emailed Stephen to see if he helped with the paperwork," correct?
Yes.
And then as we go through these text messages, the next text message is the phone assigned to Brian Walsh. She said they signed. That's the text message.
Yes.
Then the same phone texts immediately thereafter, "Let's get this deal done."
That's correct.
And then there's a text from Anna Walsh, apparently, or the phone assigned to her immediately thereafter. "Did she text you?" You see that?
Yes, I do.
Then the phone assigned to Brian Walsh says yes. And then the next text is on page 10 at 6:39:36. Anna Walsh texts, at least her phone does, "I didn't see it."
Yes, correct.
And then a few seconds later, that phone texts, "Great."
Yes.
And then that same phone assigned to Anna Walsh at 6:40 texts, "Let me have Stephen confirm and I'll Venmo them."
Yes, correct.
And then there's a text that says, "Great," from the phone assigned to Brian Walsh. Then immediate text about an hour and a half later that says, "Hello." And that's at page 11 on Exhibit 169 at 8:03:04.
Correct, yes.
So based on your investigation and based on your review of this data, that series of texts where they're talking about a deal and Venmo and everything else, it appears to you, doesn't it, that they were involved in the sale of property or something? Is that fair to say?
It appears they were looking at,
Conclusion. Oh, withdraw.
You can answer.
it appears they were looking at properties and possibly have sold a property or something based off those text messages.
Did you, as one of the investigators in the case, did you have any assignment to go try to explore what this sale was?
I did not.
Okay. Let me ask you something, Trooper. You're assigned to the Norfolk County District Attorney's Office, correct?
Yes,
There's a number of other troopers that are assigned to that office specifically to investigate serious felonies, allegations of serious felonies, correct?
that is correct, sir.
And is it fair to say that, I think earlier in cross-examination testimony, you said that you collaborated, you talked to each other, you
Correct.
shared information, correct?
Yes,
And so one of the reasons you share information amongst your fellow troopers that are assigned to the district attorney's office is so you can all learn more about the case and make a better understanding of what the data means and what the information you're getting might mean, correct?
yeah, we collaborate, share information about any investigation going on.
Based on your collaboration with fellow troopers in connection with this case, are you aware of any one of your fellow troopers assigned to investigate this case that ever went out and tried to determine the nature of that sale of property that we just went through based on the information that's in these three different sources of information?
I believe so.
Okay. And do you know what the sale of property was?
I don't know the details of it.
Do you know where the property was that was sold?
I believe the North Shore somewhere.
Do you know how much it involved?
I do not.
Do you know whose name that property was in?
I do not.
Do you know where the proceeds went, the proceeds of the sale went?
No, sir.
Okay. I want to ask you, refer to Exhibit 169 on the screen. It'll be at page 11, a text time stamped at 8:03:04 p.m. And there is a text coming from the phone assigned to Brian Walsh that says, hello.
Yes,
It's followed by a text that says, from the phone assigned to Anna Walsh, phone died.
correct.
There's a text that immediately follows that, indicates a screenshot of a phone.
Yes,
Is that correct?
yes,
And then a text that immediately follows, literally, that's the word that's used. And that's coming from the phone assigned to Anna Walsh.
yes,
And then a text that follows about 2 minutes later, coming from the phone assigned to Brian Walsh, where he simply says hello.
yes,
Then an immediate text after that from the phone assigned to Brian Walsh. Do you need a new phone?
correct.
And then there is that text where it appears at 6:18:55 a.m. at page 14 on Exhibit 169, where Brian Walsh, the phone assigned to Brian Walsh, is texting location data to 1001 Connecticut Avenue, Northwest, a Verizon store.
Yes, it appears to be an address to a Verizon store.
Okay, and that's what we talked about a little bit before, right?
Right, yes.
But now we have it in context, don't we? We realize that there's text going back between these phones of Anna Walsh's phone seem to not be working right, and then the phone assigned to Brian Walsh finds the location of a store and sends it.
Yes,
And if you just keep going down those texts, the next text, the phone assigned to Anna Walsh, she says, thank you, right?
yes,
Okay, now we're changed to the next date, 12/28/22, we're looking at Exhibit 169, and there's a series of texts that began at 7:10:59 a.m. on page 14, and the phone assigned to Anna Walsh says, "Will work from home today," correct?
Correct.
And then there's a text that follows 3 minutes later from the phone assigned to Brian Walsh, says, "Feel better."
Correct.
And I mean, from reading those texts, it would suggest that Anna Walsh wasn't feeling well and she was working at home, correct?
Yes.
And then there's a text immediately thereafter from the phone assigned to Brian Walsh saying, "Let me get the boys ready." Correct?
Yes.
As we scroll through these texts, the text at page 16, timestamp 7:15:15 a.m., there's a text, comes from the phone assigned to Brian Walsh, says, "Love you." Correct?
Could you scroll down a little further, please?
Page 16, timestamp 7:15:15 a.m.
Yes, correct.
And then immediately thereafter, there is a text, page 16, immediately following that text, coming from the phone assigned to Anna Walsh, and she says, the phone says, "Love you too."
Correct.
The phone assigned to Brian Walsh says, "I will get you a plunger." Correct?
Yes.
Next text from the phone assigned to Brian Walsh, "and a Porsche."
Yes.
The phone assigned to Anna Walsh says, "Ha ha."
Correct.
Then Anna Walsh phone says, "Thank you."
Yes.
The phone assigned to Brian Walsh says they both start with P.
Correct.
Do you think that phone is referring to the Porsche and the plunger?
Yes, sir.
And then Anna Walsh, the phone anyway, responds, "I'll take care of the plunger. You just get the Porsche." Correct?
Yes.
Okay. And then there's a couple of texts back and forth saying, "Ha ha, ha ha." Right?
Yes.
Immediately thereafter, at about an hour and a half later, same exhibit, 169, page 20, at 9:26:13 a.m., from the phone assigned to Brian Walsh, there's a screenshot of a Porsche, correct?
Yeah, it appears to be a vehicle. I don't know if it's a Porsche or not, sir.
Okay. And then there's a second text and another screenshot. And can you tell if it's of a Porsche?
Don't believe so based off the picture.
Okay. Then at 9:30, on 12/28, page 21, still the text, the phone assigned to Brian Walsh says hello.
Correct.
And about 3 hours later, the phone assigned to Anna Walsh texts back, "Fix the phone."
Correct.
She then continues, her phone does, "SIM card died." Correct?
Yes, sir.
Now, I'm going to jump down to the next text at Exhibit 169, page 22, timestamp 3/22/23, and it contains 3 more images of property, correct?
Could you scroll down, please? Thank you. Yes, sir.
And then there's a text of 3 movies being sent from the phone assigned to Anna Walsh. It's 3 movies, and if you can read the related data to those movies, does it indicate to you, based on your experience as a forensic digital specialist, that those movies have to do with the property postings?
Yes, could you scroll up a little, please? Just, okay, yeah, so they're attachments to a text, yes.
Okay. And then, right at the same time, there is a reference made to 3 family brownstone from the phone assigned to Anna Walsh, correct?
Yes, correct.
Then what happens is, on the call log, Exhibit 168, at page 6, record 66, there's a phone call between
the phones assigned to Anna Walsh and Brian Walsh.
Record 66, sir?
Yes.
Yes.
And then when we go back to Exhibit 69, right in the same time frame, now there's text being exchanged between the phones assigned to Anna Walsh and Brian Walsh, including a text, "looks good," then 1 minute. And the phones continue to text. And then there's another phone call that we can find at Exhibit 168, page 6, record 64. And it's a phone call between the phones assigned to them. So those phones are communicating together. I mean, we don't know what they're saying, right?
Correct.
And then if you go back to the text, we're still on the same day, 12/28. Now there's text about from the phone assigned to Brian Walsh, then the numbers work. It's a timestamp 3:50:19.
Yes.
Now there's a couple of phone calls that immediately follow that text. Phone calls between the phones assigned to Anna Walsh, and that's from Exhibit 168, first at page 6, record 62.
Yes, sir.
And then page 5, record 60.
Yes.
Then what happens? Same day, 12/28. On the call log, Exhibit 168, at page 5, record 56, there is a 21-minute, 47-second phone call between the two phones assigned to Anna Walsh and Brian Walsh.
Yes, incoming call from 7966, assigned to Anna Walsh.
And then about 30 minutes later, another phone call, this time originating from the phone assigned to Brian Walsh, that's for 15 minutes and 11 seconds.
Yes.
If you continue to scroll through the text messages that are contained in Exhibit 169, and I want to refer to page 30 and the text message timestamped 11:18 a.m., 11:18:10 a.m. You see the text coming from the phone assigned to Anna Walsh that said, "It's incoming soon at 199K.
I do.
And the next text is, "Had 2 bathrooms, good shape."
Yes.
Next text from the phone assigned to Anna Walsh, "Offer 195K.
Yes.
Response from the phone assigned to Brian Walsh, "Probably." You see that?
Yes, sir.
Then immediately thereafter, a text that says, "Let's see what TJ says."
Yes.
And then there's a series of texts that immediately follow, "Okay." Then there's another Zillow posting. We're now at page 32 of Exhibit 169. And then there's a specific reference from the phone assigned to Brian Walsh. They paid $80,000 in 2015, correct?
Yes.
And there's a second text, assessment at 4. What's that text say? At 11/21/31, page 32.
Assessment at 120K, 120K.
Thank you.
You're welcome, sir.
It sounds like the communications going on between these two phones is talking about the possible purchase of a new property, right?
Yes.
And that Zillow reference in Exhibit 169 at page 32 at 11/19/54, that Zillow reference is a property in DC, isn't it?
Yes.
And then scrolling down to page 33, 11/21/50, we see a text
zesting at 175K.
Yes.
And what does zesting mean? Do you have any idea?
The estimate of the property?
Okay. And then the next text is our unit is really 1820 square feet.
Correct.
All right, may we approach?
Yes?
And hello. We are still at Sidebar. I was actually watching the Sidebar right along with you as I was trying to find a towel cheeseburger. No success, but I'm going to get one. I have a plan. I will obtain my towel cheeseburger. Let's see. Knowledge of philosophy does not always ensure you will impart it into your everyday ways. Yeah, I agree with that, bossy Texas chick. I don't know what you all are talking about, but sometimes you have to have... it's really hard to apply epistemology. It's really hard to apply deontological ethics. It's really hard to apply morality. It's really hard to apply the law. Now that I think about it, it's in your day-to-day life. It's hard.
As we continue with this series of texts, now we're on December 29th, page 33 of Exhibit 169. At 11:21:59, the phone assigned to Anna Walsh text, and this one as well.
Yes.
The next text from the phone assigned to Anna Walsh, 1320 above ground, 500 under.
Correct.
Do you have any idea what the reference or the context is for that text? 1320 above ground, 500 under.
The possible square footage of the property?
Okay. And then the next text, coming from the phone assigned to Brian Walsh, let's see how much work it needs. You see that?
Yes.
Then there's a text, are they renting it out?
Yes.
Then the next text, makes sense to take it down hard. Correct?
I see that, yes.
And then does it sound like to you, based on your investigation in this case, that there's a discussion going on about possibly buying a new property in or around the DC area?
Yes.
I want to go forward now to Exhibit 161. I'm going to focus you to page 54, record 804, occurring at 9:13:47 p.m. And there's a reference once again to the Mazda building in Washington. Oh, I'm sorry.
.804, sir?
Yes, record 804 at page 54.
Yes.
And exhibit 161.
Correct, yes.
Then returning now to the text of exhibit 169 on 12:30, page 40, a text occurring at 6:01:24 a.m. from the phone assigned to Brian Walsh. Flight on time? Question mark.
Yes.
From the phone assigned to Anna Walsh. Hi.
Yes.
Phone assigned to Anna Walsh. Next text so far.
Correct.
Next text, yes, from Anna Walsh's phone.
Correct.
Next text from Anna Walsh's phone, boarding now.
Yes.
Next text from the phone assigned to Brian Walsh, great.
Correct.
Next text from Anna Walsh, signed, ha.
Correct.
Then the next text, immediately following that, from the phone assigned to Brian Walsh, did you get test? And then the next immediate text that follows is the word rest.
Yes, correct.
Does it appear to you that the texter intended to say, did you get rest, and change text to rest?
Objection to conclusion.
Sustained.
Okay. Then the next text is awake early, I see, and that comes from the phone assigned to Anna Walsh.
Correct.
And at page 43 in Exhibit 169, the phone assigned to Anna Walsh simply says a little. And then that phone says, it was a big Thursday night. Do you see those texts?
I do, sir.
And those are at 6:02 a.m. on December 30th.
Correct.
As you scroll down to the text dated 12/30/22 at page 46, a text at 12:07 p.m., there's a text coming from the phone of Anna Walsh, and it includes 2 photographs, correct?
Yes.
And I believe the photographs are blurred, but based on your review, do these photographs include pictures of a female and a young child?
They did.
And the response from the phone assigned to Brian Walsh says, looking good.
That's correct.
Then immediately thereafter, I should say not immediately, but 3 minutes later, a text coming from the phone assigned to Anna Walsh, and it includes another photo of, if you know, a female and a young child.
Correct.
And then a text from the phone assigned to Anna Walsh, hanging out hard.
Correct.
If we move down to the text at 49, page 49, timestamped 1:26:49 p.m., there is a text coming from the phone assigned to Anna Walsh, and it appears to be a movie. Do you see that? It's timestamped 1:26:49 p.m.
Hold on one second, sir.
Sure.
Yes, there appears to be a movie attachment.
Okay, a movie attachment. I'm sorry.
Correct.
I should have been more clear. And then we see in the call log, Exhibit 168, at page 2, record number 20, record number 18, record number 16, they're all on page 2. We see a series of phone calls between the phones assigned to Brian Walsh and Anna Walsh. Do you see that? It's at all on page 2, records 20, 18, and 16.
Yes, I see those, sir.
Okay. And then back to Exhibit 169 at the relevant time period, about an hour later, at page 50, there is a text coming from the phone assigned to Brian Walsh that contains 7 photographs, correct?
Yes.
And if you recall, and I understand that the photographs are blotted out, but if you recall, they're photographs of a woman and a boy.
Yes, sir.
So what we have here, and what you've just described to the jury, is when we put all the data together from primarily 3 sources: the call log, the text messages, and the data from the work you did in extracting the data from the iPhone mini. We see that all of those data, when looked at, they help frame a picture of communications about buying property and selling property, shopping for a Porsche, trading pictures between each other, all in the time period encompassing December 25th, leading up to December 31st of 2022. Isn't that right?
This shows communication between Brian and Anna Walsh from December 25th through December 30th. We only went to the 30th, sir.
And to be fair, it shows communications between phones, data.
Yes.
time.
Text message, phone calls, communication between those two devices during that time period.
Trooper Keith, you would agree with me, wouldn't you, that there's no such thing called iMessenger?
What do you mean?
Okay. You're familiar with Facebook, correct?
Yes.
And Facebook has a communication or texting app associated with it, and it's called Messenger, correct?
Facebook Messenger, correct?
It's not called iMessenger.
Not that I'm aware of, sir.
And then you're familiar with text messaging that originated with Apple, and it's referred to as iMessage, correct?
Yes.
And it's not referred to as iMessenger, is it?
Not that I'm aware of.
And it is possible, isn't it, to receive Facebook Messenger postings on someone's phone from someone's Facebook account if that person, the holder of the Facebook account, permits that person to see their Facebook Messenger communications.
Depends where you got the data from, sir.
Okay. You did not find anything on the Apple iPhone 13 mini of any Facebook Messenger postings between Anna Walsh and a person named William Faster.
Specifically Facebook Messenger
Yes?
between those two? On the iPhone 13 mini?
Yes.
Not that I recall.
You did see, didn't you, a Facebook communication on that iPhone mini between Anna Walsh and a man named Michael Redmond on December 25th of 2022. Didn't you?
I would have to see the document, sir.
I think I'm going to have to come inside.
Okay. Why don't we go?
We are at Sidebar. I'm waiting for my towel cheeseburger. And then I got a towel coffee. You know why? because we have double towel today. Not only do we have the big Aidan Kearney hearing coming up at 2:15, where Kate Peter is all over that damn thing. I'll tell you all in that Discovery. Big, ladies and gentlemen. But we also have the 7 p.m. Towel and Social Change Warrior discussion. I'll be broadcasting that on my feed. And we'll be just talking, and that'll be quite interesting. I think they have a lot of data points they want to discuss. Some of which I'm sure I'll know about, some of which I'm sure I'll have no idea about. But that's what happens when you towel and you have an encompassing memory. But yes, Towel's going to get a coffee so I can be awake. I don't stay up till 7 p.m. Well, there's 7 p.m. Oh, my goodness. Well, I guess it's not like, it is a little pushing it. I'm not going to lie for me. 9 p.m. By 10 p.m., listen, you make me stay up till 10 p.m., there better be some kind of national emergency, or I am just going to be a very upset little towel. I don't stay up that late for any reason most of the time. I like to get up at like 3, 4 a.m. I like to check on the Japanese markets. I like to look at some of the other East Asian or West Asian markets, East Asian markets. I like to look at the European papers by like 4 or 5 a.m., Le Monde, El País. I like to read the BBC. Generally, I just try to kind of keep an eye on Der Spiegel a little bit. I try to keep an eye on the continent before the sun has risen in the United States. And then, as the American sort of papers are waking up, they're normally doing their first dispatches, barring a breaking news event at like 6, 7 a.m. So I'm already up, like, before the Times has done its, like, overnight amalgamated digest. I'm already up before a lot of the other papers are doing their thing. So, yeah, I like getting up early. I'm a little towel.
So may I approach you?
You may.
Just going to ask you, Trooper, have you seen that in your examination of the iPhone Mini 13? If you haven't, that's fine.
I can't tell what device this was extracted from, sir.
So it is fair to say, though, that when you examined the iPhone Mini, you never saw any communications involving Anna Walshe and William Fastow, correct? On the iPhone Mini.
Any communication whatsoever under
Between the two of them.
specific application? This was the iPhone 13 mini?
Yes.
Can you clarify? I'm not sure what you're asking.
On the iPhone Mini that we've been talking about today. And I thought you just answered it. You did not see any communications between Anna Walshe and William Fastow first, let's say, with Facebook Messenger.
Not that I recall.
And of course, one of the, well, before I ask that question, so you don't recognize
This what you just handed me? I can't authenticate where this came from. I don't know what device it came from. I can't speak to that.
Then at this time, I'll just have it marked for ID.
We'll mark it for identification. Are we at K? No. Oh, geez. All right. Thank you. What is it?
So, now, look, you said to my question, you said, I don't recall if you saw communications on the iPhone Mini between Anna Walshe and William Fastow using Facebook Messenger.
Correct.
You don't recall?
I don't.
Of course, in the nature of this case and the fact that you are assigned to the Norfolk County DA's office, and it would be pretty important, wouldn't it, if in fact you found messaging that was between Anna Walshe and William Fastow on the phone assigned to Brian Walsh. That'd be pretty important stuff, wouldn't it?
Yes.
And as you sit here today, and I ask you a very simple question, did you see any Facebook Messenger messages between Anna Walsh and William Fasto. You said I don't recall. But that'd be right, that's what you said.
Yes.
You would agree that's pretty important. That would be pretty important evidence if you found that on that phone, wouldn't it?
Yes.
And you would agree that with regards to Apple iMessage, the text message, you didn't find any iMessages appearing on the phone assigned to Brian Walsh, iMessages between Anna Walsh and William Fasto, correct?
No.
And of course, in the context of this case, that would be pretty important evidence if you found any communications, whatever form, on the phone assigned to Brian Walsh, communications between Anna Walsh and William Fasto, wouldn't it?
Yes.
And the other thing you did not find is any evidence of deleted messages using Facebook Messenger on the iPhone, the Mini.
I would have to take a look, sir. I don't recall specifically.
Okay, but once again, that software you use, whether it be Celebrite or Magnet Gray Axiom, it's able to detect deleted materials. In fact, that's one of the forensic tools, one of the forensic reasons it's used, to see if there's deletions of data that might be important to a case, correct?
Well, it all depends. The software that company has published at the time, the software the device is running. So never do they get all the data extracted from a device. So the deleted data may never be parsed out and read.
Okay, well,
There's a lot of factors that go into that.
but if you wanted to find messages, whether they be Facebook Messenger or Apple iMessages between Anna Walsh and William Fasto, and you thought it was, as you told us, it would be very important evidence to find, you would do everything you could as a forensic digital specialist to try to find them, wouldn't you?
Well, her device was never recovered, sir.
I'm sorry?
Her device was never recovered.
I'm talking about the phone assigned to Brian Walsh.
You just said messages on her device between.
If I did, I apologize, and I might very well have said that. Thank you for correcting me. Messages between Anna Walsh and William Fasto appearing on the phone assigned to Brian Walsh. That would be pretty important evidence, correct?
Yes.
And you would do everything you could as a digital forensic specialist to try to find that, wouldn't you?
Yes.
And that's it for me.
You're done?
Just a minute. I think I'm finally done. Thank you, sir.
Thank you, sir.
Redirect.
No, Your Honor.
The witness may step down.
Thank you, Your Honor. Do you want to leave this stuff here?
Yes, the lawyers will take care of that, but thank you.
Your Honor.
Commonwealth may call its next witness.
Commonwealth would call Heather Sullivan.
Please the clerk for me, raise your right hand.
Do you solemnly swear or affirm testimony you'll give in the cause now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. You can be seated.
Just watch your step.
Good afternoon, Judge.
Good afternoon. You may proceed.
Thank you, Your Honor. Could you please state your name and spell your last name for the record?
Yes, sir. Retired Trooper Heather Sullivan, Sullivan.
And you say retired. When do you retire?
In July.
And how long were you a state police trooper?
20 years.
And what can you just tell us your path through the state police, where your assignments?
Sure. I was on the road for the first 7 years of my career. For the last 13 years, I've been in crime scene, 7 of which I worked at the crime scene office that's attached to the medical examiner's office. In the last 6 years, I worked in the crime scene services in Danvers.
And what were your responsibilities at the crime scene services in Danvers?
It was my responsibility to go to any homicide, suicide, unattended death, any crime scene where I would need to collect evidence, process it for fingerprints, or document any items of interest.
And what type of training did you need to obtain in order to get into that unit?
We had on-the-job training, but it was years and years of training. Every year we have some sort of class, proficiency tests in crime scene, videography, documentation, evidence collection, tire track, footwear, and fingerprints.
You say proficiency tests in those areas. Did you pass your proficiency tests?
Yes, sir.
And are you familiar with competency tests?
Yes.
Did you pass your competency tests?
Yes, sir.
Now, I'd like to ask you some questions about January 9th of 2023. Did you have the opportunity to be involved in an investigation that initially started in Swampscott that afternoon?
Yes, sir.
Where did you respond to in Swampscott that afternoon?
330 Paradise Lane. It was an apartment complex, and I was called there by Norfolk County Detective Unit.
And about what time do you think you got there?
About 1,400 hours.
And Ms. Gilman, can we have what was marked as Exhibit 90? It's a photograph. And forgive me, I don't have the file number in front of me. Do you see this photograph?
Yes, sir.
Do you recognize it?
Yes, it's one of the 2 trash receptacles I was responsible for documenting.
On Exhibit 90, it says HAS. Are those your initials?
Yes, sir.
And could we have Exhibit 91? Do you recognize this image?
Yes.
What is this?
It's a trash compactor at the same location that I also documented.
Now, what was done with those 2, the trash compactor and the dumpster?
I, like I said, I documented it with photographs all the way around, and then we were going to search it at a different location.
And did you go to that different location?
Yes.
Where was that?
300 Forest Street in Peabody. It was Greenworks Republic's transfer station.
Ms. Gilman, can we have Exhibit 107, which was, I believe, file number 6556? Thank you. Now, does this look like where you went to in Peabody?
Yes.
Okay. So once you got to Peabody, what was done with the 2 dumpster? What was done with the dumpster and the compactor?
I'm sorry, I didn't hear you.
Oh, no, my bad. What was done with the contents of the dumpster and the compactor once you got to Peabody?
They were separately transported to this location, 304th Street, and they marked off an area. I documented it before they dumped the trash, and then individually they started with one of the trash receptacles, dumped that, and spread it out so we could go through it and search it.
So, and who did that process? Who dumped it out and searched it?
So the company who transported the receptacles, they're the ones who dumped it, but they put it in a location where we could go through it methodically. The CERT team, which is a special emergency response team, there's about 10 of those individuals who were there to go through the individual trash bags. And what was the conditions like while everyone was doing this? As far as weather. Oh, it was it's January, so it was very cold. It was outdoor location. It looks like it's indoor, but it's half indoor, half outdoor.
And so when the CERT team would get to a bag, would they open several bags at once, or what? How would they do it?
So they did it methodically. So they each, kind of attacked it together. They went through each individual bag, looked to see, we actually had a meeting about what we were looking for, so they knew what to look for. If they found anything that they possibly thought was of interest, they would flag me down. I would photograph it. And then if it was something that the detectives wanted to collect, we would collect it and spread it out so we can document it further.
So could I, at this point in time, Ms. Gilman, could we have Exhibit 125? So do you recognize this image?
Yes, sir.
Is this one of the bags, contents of the bags that you had to spread out and do further documentation of?
That was some of the contents in one of the bags, yes.
And what's this, bless you. What is the significance of the yellow placard?
That tells me, so as I was spreading things out, each bag got a placard, and then we would know which items came from which bag.
Now, when items were packaged up and brought back to the lab, did they all go to the same person, or did different people enter them into the LIMS system?
So I entered any evidence that we collected for crime scene services, which would be specifically for fingerprinting. I would collect that evidence, and then the detective unit collected anything we weren't actually processing for fingerprints or DNA, and then another person from the forensic scientists unit, also in the crime lab, they collected anything that they would be testing for DNA specifically, and only that.
Okay. And so these items here, were they tested for fingerprints?
They were collected by my lab and sent to the Boston lab because it was their, basically their area that the incident occurred. So they took that evidence and they fingerprinted it.
Now, but you were able to enter these into the LIMS system, correct?
I entered anything that I collected, documented it, collected it, tagged it, and put it in the LIMS system.
All right. I may have a moment, Your Honor.
Yes?
Ma'am, do you happen to have gloves with you? I see a box.
I do.
Okay. Your Honor, may I approach the witness?
Okay.
For the record, I'm bringing you some parchment paper just in case you need it.
Sorry.
Do you recognize this object?
Yes.
What is it?
It's one of the bags of evidence that I had collected because I can see my handwriting on it.
And what does it say on the exterior of the bag?
Tin snips by placard 8, and I itemized it 7-9. The LIMS number is 23-00596 with my initials and the date that I collected it.
Could you put some gloves on and open that bag and make sure that the snips are inside?
Do you mind if I stand?
No, go right ahead.
The snips you found at the scene that night?
Yes.
You can place them back in the bag. Your Honor, you have this marked. The Commonwealth would seek to have the tin snips with the bag marked as the next exhibit.
All right. No objection. The snips in the bag are now in evidence as Exhibit 171. Is that correct?
May I approach, Your Honor?
You may.
Ma'am, do you recognize that bag?
I do.
What is that?
It's a brown paper bag, item 7-10, which I itemized in limbs, and it's a hacksaw, and it was by placard 8 as well.
Could you open that bag and make sure the hacksaw is inside? If it is, could you please do so?
It is.
Without trying to make anything of a mess, but thank you. Thank you. Could you return it back? The Commonwealth would seek to have the hacksaw and the bag marked as the next exhibit, Your Honor.
No objection. It's marked and admitted into evidence as Exhibit 172, the hacksaw.
May I approach, Your Honor?
Yes.
Thank you, Your Honor. Do you recognize that bag?
Yes, sir.
What is that?
This is a brown paper bag with a hammer, item 7-11.
And if you could keep your voice up.
Yes, I apologize.
No, that's okay. I have you getting up and doing all that stuff, so that's my fault. Could you open the bag and make sure the hammer's inside? Let me help. Thank you. And that's the hammer you saw that night? The Commonwealth would seek to have the hammer in the bag marked as the next exhibit.
Hearing no objection, it's in evidence now as 173.
May I approach, Your Honor?
Yes.
Do you recognize this bag?
Yes, sir.
Could you open it and could you tell us first what is it?
It's a bag with packing tape, item 7-12.
Could you open it and look inside and confirm that the pack tape is inside? And does that appear to be the pack tape that you found at the PVD at the trash site that night? The Commonwealth would seek to have this bag with the packing tape marked as the next exhibit.
It is now, the packing tape is now in evidence as 174.
Ms. Gilman, could you take that down? Thank you. Your Honor, may I approach?
You may.
Ma'am, do you see that bag?
Yes.
Do you recognize it?
Yes, it's a brown paper bag with a hatchet in it, item 7-13.
Could you open that bag and confirm the hatchet's inside? Could you please put the hatchet back inside? Could you put the hatchet back inside? And that's the same hatchet that you saw that you retrieved from the trash station and PVD that night?
Yes.
Commonwealth would seek to have the bag with the hatchet marked as the next exhibit.
Any objection?
No objection.
The hatchet is in evidence as Exhibit 175.
May I approach, Your Honor?
Yes?
Do you recognize that bag?
I do.
And what is that?
It's a bag. Actually, don't know what's in this. Craftsman shears.
Craftsman shears.
Yes.
Could you open it and confirm the Craftsman shears are inside?
Sure.
Thank you. Are those the Craftsman shears you saw that night in Peabody?
They were.
For the record now, if the shears are back in the bag, Your Honor, the Commonwealth would seek to have the bag with the shears marked as the next exhibit.
Objection.
What limbs number on that? Is it 714?
714.
All right, the shears 714 are in evidence as 176.
May I approach one more time, Your Honor?
You may.
Recognize that bag?
I do.
What is that?
It's a brown paper bag with a measuring cup in it, item 7-15.
And could you open that bag and look inside? Is that the measuring cup you saw that night in Peabody?
Yes.
Commonwealth would seek to have the bag with the cup now back inside as the next exhibit.
Objection.
Number 715.
715, the measuring cup is now in evidence as 177.
So I take it you took these items back to the lab and entered them into the LIMS system.
I did, sir.
And you didn't do any further work on these items once they were in the LIMS, once they were entered into the crime lab evidence system.
Correct.
Your Honor, may I have a moment?
Yes?
Thank you. On the measuring cup, there was some dark powder. Do you remember seeing that?
That wasn't like that when I packaged it in the beginning.
And now, in your training experience of working in the crime lab, do you recognize that type of substance?
Seems to be black fingerprint powder.
And one of the reasons you took it to the crime lab was to be fingerprinted?
Correct.
Nothing further, Your Honor.
Cross-exam.
I have no questions.
All right, the witness may step down. Thank you very much.
Thank you.
Commonwealth may call its next witness.
Commonwealth will call Richard Atkinson.
Do you solemnly swear or affirm the testimony that you give in the cause now and hearing to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
You may proceed.
Thank you, Your Honor. Sir, could you state your name and spell your last name for the record?
Sure. Richard Atkinson, Atkinson.
And where do you work, sir?
I work at the Office of the Chief Medical Examiner in Boston.
What is the Office of the Chief Medical Examiner?
It's where the medical examiners in Massachusetts work.
And what does a medical examiner do?
A medical examiner is a doctor who's in charge of examining the bodies of people who are deceased to determine their cause and manner of death.
And how long have you been with the Office of the Chief Medical Examiner?
I've been there 11 and a half years.
And could you tell us your educational background?
Sure. I have a 4-year bachelor degree from Stony Brook University in New York. I then did a 4-year MD at Columbia University College of Physicians and Surgeons. I then did a 3-year anatomic pathology residency at New York Presbyterian Hospital and Stony Brook Hospital. And then I did a 1-year fellowship in forensic pathology at the office where I currently work.
And so I take it that worked into you starting your career at the OCME?
Yes.
Now, do you know what it means to be board certified?
Yes.
What does it mean to be board certified?
To be board certified in a specialty in medicine, you usually have to finish the residency in that specialty and complete a certain number of cases or see a certain number of patients and then take a test.
And are you certified in any areas of medicine?
Yes.
Which ones?
I'm certified in anatomic pathology and forensic pathology.
And can you tell us what is forensic pathology?
Sure. Forensic pathology is the branch of medicine that's involved in determining the cause of death and manner of death of people who die of not obviously natural causes.
And what is anatomic pathology?
Anatomic pathology is a bigger umbrella term that refers to diagnosing disease by looking at tissue or blood samples, that kind of thing.
Now, can you tell us, sir, what happens to a human body within the first hour of death?
Several things can happen. Usually there is rigor mortis within a couple of hours. It can, however, almost immediately occur after a person's death. That's just when the muscles tighten up in the position that the person died in. There's also something called lividity or livor mortis. That's when all the blood in the body, once the heart stops beating, settles down to the lowest point. So if you're lying on your back, it will settle to your back and give you a pink discoloration of your back, and also a white discoloration of your front.
Now, sir, what is an autopsy?
An autopsy is just an examination of the body of someone who has died, including looking at the external surface of the body and also cutting into the body and examining the organs.
How many autopsies have you performed?
I've performed just 1,500 full autopsies, about 2,700 additional examinations that weren't full autopsies, and I've supervised 300 additional full autopsies.
How long does an autopsy take?
It depends. An autopsy can take less than an hour if it's simple. It can take a day if it's a difficult case.
And how, you said the external and internal, how do you begin the external examination of a body during an autopsy?
We examine the clothing in some cases. Then we examine the external surface of the body by taking photographs, by drawing our findings on a body diagram, and just looking for signs of injuries or disease that might have led to the person's death.
And what consists of the internal portion of an autopsy?
The internal portion is removing the organs, also looking for signs of disease or injury, and sometimes removing items like bullets that may have killed someone.
And when doing an autopsy, I neglected to ask this, but I imagine there is a facility at OCME that you do this in.
Yes.
And can you just tell us, like, what do you have as far as tables to work on for patients?
The table that the decedent lies on?
Yes.
It's a metal table with raised edges.
And what do you wear when you perform an autopsy?
I wear a lot of protective equipment, a full Tyvek suit, extra sleeves and an apron over that, a mask and face shield, and 3 pairs of gloves.
And when you do an autopsy, what attempts do you make to get access to a decedent's medical records?
We make every attempt we can to access their medical records. In Massachusetts, the law is that we're entitled to them in Massachusetts. So,
and when performing an autopsy, what samples do you take from the body during an autopsy for further analysis?
We take fluids and sometimes tissue for toxicology testing. We also take it sometimes for DNA testing, for looking at under the microscope, various different things.
And can you tell us what histology is?
Yes.
What is histology?
Histology is the study of tissue by looking at it under the microscope.
And how many times have you ever testified in a court before giving your a medical opinion?
Yes.
Now, on January 10th, 2023, did you have the opportunity to seize items taken from a trash facility in Peabody?
Yes.
Where did you do that?
At the office of the chief medical examiner in Boston.
Why were you examining items why were you examining items at the OCME?
Normally, we're not involved in examining items, just bodies of people. In this case, the objective was to determine whether there was any human tissue on these items.
I may have a moment, Your Honor.
May.
Thank you. Okay.
You may.
Doctor, you recognize this image?
Yes.
And what is this an image of?
This is an image of several pieces of blue and white carpet that I examined.
Commonwealth would seek to have this image marked as the next exhibit, Your Honor.
Any objection?
No objection.
Can I see that?
Yes, I apologize, Your Honor. Yes. Thank you. I will also put it in the record each one.
Yes. So for the record, what's the JPEG number of 178 that's now in evidence?
Is PC 110181.
All right. The photo of the rug with that JPEG number is now in evidence as 178.
And Your Honor, may the Commonwealth publish?
You may.
Thank you, Your Honor. Let's go in. We have a PC 110181. Doctor, can you see that?
Yes.
So, Doctor, can you tell us what are we looking at here in this image?
There were 7, though I think some of them are not in the image, 7 pieces of rolled up blue and white carpet with some stains on them, and the pieces of debris that you can see just above the ruler were also present on some of the pieces of carpet.
And who places the ruler there?
I do.
Your Honor, may I approach?
You may.
Do you recognize this image, sir?
Yes.
Is that one of the pieces of carpet that you had the opportunity to examine?
Yes.
Your Honor, the Commonwealth would seek to enter evidence PC 110195, image of carpet.
Any objection?
No.
That 110195 is now in evidence as 179, photo also of rug.
And may the Commonwealth publish, Your Honor?
You may.
Ms. Gilman, do we have 110195? So, Doctor, is this one of the carpets that you had the opportunity to see that night or see that day when you were at OCME?
Yes.
And that ruler, did you place that there as well?
Yes.
And Doctor, do you have an idea of what the aggregate measurement of the carpets were together?
No, I don't think I recorded that.
Do you want to make a motion?
Yes?
Doctor, do you recognize this image?
Yes.
Is this another one of the pieces of carpet you had the opportunity to examine that day?
Yes.
Your Honor, the Commonwealth would seek to enter in PC 110198, second image of carpet.
No objection.
The photo of the rug 110198 is now in evidence as Exhibit 180. Is that a good place to stop for today?
Yes, Your Honor.
All right, I'll see counsel at the side of the bench.
Yes, Your Honor.
All right, it's chaos. I repeat, chaos reigns, ladies and gentlemen. If you thought the 2:15 p.m. TurtleBoy hearing was going to be ridiculous, after this filing I just read from Robert Cosgrove, we are about to enter a level of ridiculousness that I didn't think was humanly possible. Now, yes, let's jump ahead and see if the Walshe hearing. All right, so it looks like the Walshe hearing is done for the day. As you know, they end early on Fridays.
Thank you.
Your Honor.
Thank you. I see counsel at the side of the bench.
All right. I'm eating, but I'm not reading this motion. Sorry, I got a towel cheeseburger. My name's Grant Smith Ellis. Listen to me. I'm not reading this motion. Nope. I'm going to bring it up on the screen. We can listen to the PDF get read out. I cannot believe what I just read. Cosgrove coming in with the Texas Pete today. No, I love your references, current resident. You are a very wonderful super towel. All right, listen to me, folks. I have just come across, I don't even know how to describe how ridiculous this is. There is ridiculous, and then there is the filing I have just read from Robert Cosgrove. Every once in a while, every once in a great eon, you get a filing that really intrigues you, you know? Every once in a while you get a filing that's really dense, that's really interesting. And then there are those days where you get a filing that quite literally, ladies and gentlemen, leaves your world aghast, where you cannot comprehend how you have read it. You can't comprehend how it exists. And this is that document. And you may be saying to yourself, Grant, that's not possible. Yes, it is. Yes, it is, ladies and gentlemen, and I am going to show you the proof. We're going to listen to it as soon as the Walshe hearing is concluded. The lawyers are probably just doing some scheduling matters with Judge at side back. Now, for us, what are we doing? Oh, we're about to do some things, little towels. Let me just tell you right now. We're going to listen to this. All right? We're going to listen to it, and we're going to see if it'll read. All right? There's no promises that it will read, but we're going to try. Come on now, you can do this for us. We believe in you. Didn't find any. You lawyers and making non-machine readable PDFs. You know what? That's a crime. It's a travesty. It's a sham. It's a mockery. It's not actually a crime. Just incredulous. How dare you? How dare you lawyers upload PDF that cannot be read by screen readers? Do you understand? That means disabled people cannot read them. You damn lawyers, you got to learn how to make machine readable PDFs, okay? It's not that hard. You click one button. You know what I have to do as a result of you lawyers, not you in the chat, but you know what I have to do as a result of you lawyers? I have to go get the PDF. I have to convert it to text. I have to upload it. I have to let it screen it, which shows that there are tools out there that are capable of doing it. And then I have to re-download it. Then I have to get the text file. Then I have to make it's just this whole process. Now, do you think a disabled person who is blind is going to be able to do that? No. They have a screen reader. They know how to use their computer. And they know how to get the file to start reading. Is there any reason to make them convert it to text? No, absolutely not. And I am just going to keep yelling about this until all the lawyers start uploading their motions and whatever in machine readable OCR. It's not that hard. It's literally the easiest thing we can do. We need to make some kind of rule. We're going to make it a court rule. I'm going to speak to somebody somewhere in some office. We're going to put it in a rule somewhere. Some people think rules are just sui generis. They just exist. No. Somebody in some room somewhere is like, I think we should have a rule. Like, they get really up in arms about it. You know where bike lanes come from, ladies and gentlemen? Bike lanes come from the fact that some politician sometimes wants to just have a bike lane. So they're like, you know what? Let's have a bike lane. Now, you didn't turn in for bike lanes. You turn in to hear me yell about Robert Cosgrove being an absolute incredulous non-towel. I don't even know what to call this, but we're going to listen to it. Brian we'll see if anything else happens in the Walshe hearing, but for right now, we're listening to this, all right? We're going to have a bot read it. You know why? And we're going to have I'm going to try to find a bot that can properly take on the intonation of an old man like Robert Cosgrove, who has just crossed a line, crossed a line that I didn't even think was possible. It's sick. Sick. All right, let's get this document up on your screen. Let's get ready for the 2:15 p.m. hearing. Listen, I've never wanted a hearing to be a showdown, really, you know what I'm saying? I want this to be a showdown. I thought I'd find myself rooting for Better Own Bradle, but go in there and tear Robert Cosgrove apart. You do it, Better Own Bradle. Oh, my word, what a ridiculous filing. Oh, goodness gracious me. About an hour until the Aidan Kearney hearing. I'll get that all up and ready. You still have a live look in up at the Walshe hearing. They're just on a live sidebar. That is not what we're paying attention to right now, though. You can keep a live look in on that, but you know what we're doing? We're reading this motion. I'm not reading it. I'm going to have it read out. And I'm going to pick a ridiculous voice, so you're going to have to give me a second here, okay? Hold on, not yet.
Commonwealth.
Not yet. No, he does not get a British lady voice.
Commonwealth of Massachusetts. Norfolk, SS the Superior Court.
All right, looks like we're done for the day in Walshe.
I didn't ask you over there, but I assume based on our last little bit, anything the Commonwealth needs to address with the court before I get off the bench. And same to the defense. Everyone have a nice weekend.
Thank you.
All right, so we're done for the day in Walsh. I'm going to pause this. I'm going to pick the most ridiculous possible voice for this reading. And you might be saying to yourself, why, Grant? Why? Well, because I want to. I think it's freaking hilarious. What about George? Go ahead, George.
Read Aloud is a Chrome and Firefox extension that uses text-to-speech technology to convert web page text.
How about David?
Read Aloud is a Chrome and Firefox extension that uses text-to-speech technology to convert web page text.
Read Aloud is a Chrome and Firefox extension that uses text-to-speech technology to convert web page text to audio. It works on a variety of websites, including news sites, blogs, fan fiction. Commonwealth of Massachusetts. Norfolk, SS, the Superior Court. 2382 CRO 00313. Commonwealth versus Aidan Timothy Carney. This case is specially assigned to Judge Belizos. Commonwealth's memorandum in opposition to Attorney Bettero's affidavit in support of motions to disqualify, etc. The defendant Aidan Carney has filed an affidavit in support of motions from Attorney Mark A. Bettero. As with a previous Bettero affidavit, henceforth, B.A. The motions are phantoms, and there is no memorandum of law accompanying the non-existent motions. The Commonwealth infers that the affidavit in support is intended to serve all three functions, and assuming arguenda that this court consents to accept it as such, the Commonwealth offers the following response. The defendant first asks this court to preclude the Norfolk County DA's office, henceforth, NDA, from appointing an Otlier special prosecutor to docket No. 2482 CR 00043. The 2024 case, due to its irreconcilable conflict with witness Lindsay Gaetani. Section 1A. That request is moot, as the district attorney's office has since entered a nolle prosequi on that case. The defendant remains free, of course, to contest the validity of that nolle prosequi by litigating whether the NDA's alleged irreconcilable conflict at annos feo or AAA that action, and insisting on the revival of that indictment, but so fat section EONF doing so. Noga ye. 1314 to 803 ALZ03Y. Next, the defendant asks this court to disqualify Special Prosecutor Cosgrove from docket No. 2382 CR 00313, the 2023 case, because of his alleged irreconcilable conflict with Ms. Gaetani. Section 1B. Much has been said in previous filings with respect to Ms. Gaetani, and she herself, with prior leave of this court, has filed a number of pro se documents. All of that pays examination, but the Commonwealth offers a brief background summary. Gaetani is a single mother and a faithful, perhaps even compulsive follower of online postings on such outlets as YouTube, X, and Facebook. In this context, she viewed some of the defendant's online postings related to the then pending Karen Read case, sent him a laudatory message, ordered one of his free Karen Read t-shirts, then sent him a photo of herself wearing that shirt. Correspondence ensued, and not long thereafter, an intimate physical relationship. Bolstered by Kearney's bragging about his inside knowledge of the Karen Read case, dinners and drinks, use of the internet to exchange texts, including those with explicit sexual content, and the defendant's sometime practice of videoing their sexual escapades with his cell phone camera. At some point the Gaetani-Carney relationship began to founder, and at about the same time, Gaetani began to have doubts about the innocence of Karen Read. Whether on her own initiative or as, the defendant posits, the influence of other denizens of the online community, such as Catherine Peters, Gaetani contacted Lieutenant Brian Tully, who was leading the NDA investigation into intimidation of witnesses in the Read case by the defendant. Tully interviewed Gaetani The Commonwealth had already developed another witness, Natalie Wiewike Berschneider, who could attest to communications between Karen Reed and the defendant. During the months of April and June 2023, Gaetani's information confirmed such contacts after underscore that date based on what the defendant had told her. Tully reported on the interview to Special Prosecutor Kenneth Mello, who had Gaetani served with a grand jury subpoena. Gaetani had apparently hoped not to have to testify and began to panic upon receipt of the subpoena. She telephoned the defendant and informed him that she had been subpoenaed and attempted to minimize her role in the matter. After some discussion, the two agreed to meet at Gaetani's apartment building, where Carney demanded to examine Gaetani's cell phone and took notes on some of its contents. He urged Gaetani to delete various items from her phone, representing that he had checked with his attorney, Timothy Bradle, and that as there was no preservation order in effect, that there was no problem in doing so. At one point in the early hours of the morning, Gaetani excused herself to use the bathroom and telephoned Special Prosecutor Mello, awakening him. Mello had difficulty understanding what Gaetani was saying, beyond understanding that she was fearful, but effectively arranged to transfer the call to Tully. A brief exchange of messages followed, then Gaetani returned to the defendant. Further conversation ensued, as did other events. After speaking with Gaetani the following day, December 24, 2023, and learning that she had not reported the incident to the local police, Tully did so. The defendant's arrest soon followed, resulting in revocation of previously imposed bail. Gaetani was granted a 209A restraining order. The defense's theory, as discussed in the Commonwealth's memorandum in opposition to Attorney Bettero's affidavit in support of motion and associated submissions, henceforth, Mem. Opposite, is that Catherine Peter, Lindsay Gaetani, Mr. Mello, Det. Lieutenant Tully, and possibly others diabolically plotted to have Mr. Kearney's bail revoked by luring him into intimidating Ms. Gaetani after they made her what Mr. Bettero describes as a witness. Taking care to put the term in scare quotes. Mem. Opposite. At 16. Subsequently, the defendant went to the Medfield police and alleged that Gaetani had wiretapped him by recording a sexual encounter without his consent, using a home security camera. As a result, Gaetani was interviewed by the Medfield Police, MPD, and in the course of that interview, MPD were informed of a sexual encounter on October 14, 2023, which Carney had recorded. Per Gaetani, he sent her a copy of the recording the following day. The question arose as to whether Gaetani, on that occasion, lacked the capacity to consent, and thus was raped by Kimi, but Gaetani initially did not want to proceed with charges. The police subsequently met with Mr. Carney and, among other things, advised him that they had a copy of his video of the October 14th encounter. According to Ms. Gaetani, on April 13, 2024, Carney publicly announced on YouTube. Episode 654, aired April 13, 2024, that Medfield police were investigating him for rape, calling a tally. This was the first public mention of the allegation, initiated by Carney himself. 8. Defendant's answer and counterclaim, hereafter, A&C, Carney vs. Gaetani, Worcester Sup. 2585 CV00035. Carney launched an online campaign of vilification against Gaetani. She was a fake victim, an unfit mother. She supposedly Kearney's postings as cloth on, and on the attacks went, with Kearney's devoted online acolytes gleefully piling on, picking up the cry of fake victim, photographing Gaetani at various locations, sending accusatory messages to her children's school, and texting her with obscenities, accusations and threats. 1. Among Kearney's enthusiastic collaborators in the campaign of vilification against Ghaktani was Jason Broyles, who initially appeared online under the pseudonym Haley Walbrecht. Broyles serially posted derogatory material about Ghaktani, interspersed with exhortations to her to prevent him from continuing to do so by telling the truth. I sent publicly adopt Kearney's version of events and repudiate her own statements. Eventually, Ghaktani responded to the verbal assaults against her on her social media account, denouncing the defendant as a rapist and describing him with other derogatory terms. On January 8, 2025, represented by counsel, Kearney filed suit in Worcester Superior Court, alleging slander, libel, and intentional infliction of emotional distress, and seeking damages and injunctive relief. After an unsuccessful motion to dismiss, Ghaktani, proceeding pro se, filed an answer and counterclaim on September 8, 2025. In the course of litigating a Dedham District Court case involving an alleged violation of the 209A order granted Ghaktani against the defendant, Cosgrove had provided as discovery the Medfield Police report on the October 14, 2023 incident to attorney Bradle. Bradle, or someone acting on his behalf, gave the report to Kearney. Kearney provided it to Broyles. On August 8, 2024, Broyles posted Ghaktani Files Part 3, including the unredacted confidential police report of Ghaktani's sexual assault allegation. ANC 65. In ANC, in addition to answering Kearney's allegations, Ghaktani attempted to implead Cosgrove, Lieutenant Tully, and a Medfield police officer. The factual basis of all her allegations against Cosgrove is that his turning over the report to the defense violated GL Circa 41, Section 97D. As a result of Ghaktani's filing ANC, Cosgrove filed a motion to withdraw from 2482 CR00043, believing that a conflict existed between defending, should it become necessary, against Ghaktani's ANC, and prosecuting an indictment where she was the alleged victim and primary witness. That motion was allowed without argument and without objection. The defense now seeks to leverage that withdrawal to force Cosgrove's removal from the present case, in which Ghaktani is alleged to be the victim and is not a necessary witness for the Commonwealth. All of the named victims in the present case are either witnesses in the Karen Reed case or relatives of witnesses. Ghaktani is not a percipient witness with respect to any of the counts in the present case. To the extent she would be of any use to the Commonwealth at all on these counts, it would be to testify, based on her conversations with Kearney, as to Kearney's relationship with Karen Reed, which goes to his motive for the intimidation of the witnesses. If the Commonwealth wishes to introduce such information, it can do so through other means, including the contents of 2 of Kearney's cell phones seized pursuant to warrant, which show extensive communication between the defendant and Reed, as well as communications with some of Reed's attorneys. In short, there is no need whatsoever for the Commonwealth to call Ghaktani, and no need for prosecution to, as the defense posits, defend the credibility of a prosecution witness who has sued him for his alleged misconduct. BA, L8. The defendant argues, however, that it will call Ghaktani, who has apparently now, for whatever reason, made a complete U-turn and taken a Kearney-like position that's special. Prosecutor Mello and Lieutenant Tully conspired with Kate Peter to use her and sacrifice her as a pawn. Gaetani would be expected to testify that during her relationship with Carney, Karen Reed would come up a lot in conversation. Further, that he told her he communicated with her on a daily basis, and that with much of his reporting on the Reed case, he would have to run everything by her, that she had a lot of control or almost complete control over anything that he posted. He was not allowed to make any sort of comment about her case without first consulting with her and getting her prior approval. Grand Jury Minutes, February 1, 2024, pp. 11-13. To take down Carney, and that therefore, Cosgrove should be disqualified on the ostensible grounds that he is somehow ethically conflicted from cross-examining her. Degree. Whatever purchase this argument may have for the now dismissed complaints where Gaetani was herself the alleged victim, there is no basis for dragging the entirety of that dispute into the present indictment, where Gaetani accounts for virtually zero of the Commonwealth's evidence, either in its collection or its presentation. The expected evidence will primarily be the testimony of the alleged victims and Kearney's own video online statements. A side trip into whether the Commonwealth did or did not properly conduct the Gaetani investigation is irrelevant, not probative, and highly prejudicial, threatening to turn the trial into a circus. The Commonwealth will vigorously oppose the attempt to divert the jury down this lengthy and winding side road to nowhere but confusion. Should this court, after hearing, permit the proposed Gaetani defense testimony to the extent that Ms. Gaetani's U-turn contradicts previous statements made under oath, she may expose herself to legal peril, and the court should ensure that before she proceeds, she has appointed counsel. Clearly her interests are far from synonymous with Mr. Kearney's. Finally, the Commonwealth notes that to the extent any disability arises from Ms. Gaetani's A&C, whenever, if at all, the counterclaim against Cosgrove goes before the Middlesex Court, it is unlikely to survive a motion to dismiss or for judgment on the pleadings. Its entire basis is an act by a prosecutor in the course of his duties, and whether or not Cosgrove was correct in concluding that providing a copy of the police report to the defense was proper. Greater than a prosecutor is not required to uniformly buttress or implicitly vouch for the entirety of the testimony of a witness he calls. The modern view, and the law in Massachusetts, is that subject to a few limitations, any party, including the party that called the witness, may attack her credibility. See Massachusetts Guide to Evidence, 2020 ed., Section 607, citing GL Circa 233, Section 23. Tooley 14 Discovery, no liability should attach. See, e.g., Werty v. Lynch, 27 Mass. App. Court 498, 499, 1989. The defendant's third and final request is perhaps his most brazen. He asks this court to disqualify Cosgrove from an ongoing investigation of Karen Reed and Mr. Carney for conspiracy to commit witness intimidation, the 2005 investigation, again based on the alleged irreconcilable conflict with Ms. Gaetani. To facilitate his demand that this court preemptively intrude on the lawful authority of the executive branch, Carney attempts to mount an attack on a search warrant authorizing seizure of cell phones belonging to Karen Reed. B.A. 164-77 and N.14. As this court undoubtedly knows, when there is a claim that seized electronic devices may contain attorney-client privileged material, a taint team is generally required. See generally. Preventive Medicine Associates, Inc. v. Commonwealth, 465 Mass. 810, 2013. Moreover, 2. Search warrants are required, though the two may effectively be combined into one. So the process is search warrant number 1 authorizing seizure of the device, taint team established, search. Warrant number 2 limiting the scope of the search. Presently, the matter of the Karen Reed search warrants and the establishment of a taint team is before this court, Krupp, J., having heard argument, received memoranda, and taken the matter under advisement. It is part of the normal search warrant process. Assuming the court allows the Commonwealth's motion to set up a taint team procedure, and assuming search warrant number 2 is authorized by the court, and assuming a resultant search yields evidence, and assuming that evidence results in a grand jury presentation, and assuming that grand jury then indicts Karen Reed, then Karen Reed, as in any other case, may bring a motion to suppress that evidence. Karen Reed may bring such a motion. Not Kimi, who has no standing, as he lacks any possessory or other cognizable legal interest in Karen Reed's phone. Conclusion. For the reasons set forth herein, the Commonwealth asks that this court deny the defendants' motions. Respectfully submitted. S. Robert C. Cosgrove. Robert C. Cosgrove, Special Assistant District Attorney. 45 Shawmut Road, Canton, Massachusetts, 02021.
Just outrageous. Oh my goodness, outrageous. Listen, we have to get ready for this 2:15 hearing, so we have to watch the recap video about Bradel and Cosgrove going back and forth. But let me just tell you, this is hands down one of the most outrageous things I have read in my entire life. Okay? Oh, wow. Just wow. First of all, reading backwards, okay? Cosgrove was like, we just need Judge Krupp to give us permission and we'll move forward with indicting Karen and Aiden. Or Karen. Oh my God, we just need the permission to move forward with the taint team procedure. Now we know what it is. As soon as Judge Krupp issues that ruling, oh my goodness, ladies and gentlemen. If you see a ruling from Judge Krupp on those phones and the taint team procedure, the floodgate, especially if they then can move forward, there's going to be a little lag with going through it. But that would be the sign. And listen, how much time does the Norfolk DA have left? You know, there's only 11 months till the election. Oh, my word, ladies and gentlemen. Cosgrove, in that last part right there, laid out exactly what he's going to do. And if you're just tuning in, we are just 45 minutes away or so from the Aiden TurtleBoy Kearney hearing. No, Judge Krupp has not been moved. He is still in Norfolk Superior Court. And that ruling could come down any day. Oh, my God, I thought it was them waiting to brute force their phone. No, they just need the ruling from Krupp. Well, what are we talking about, Nanya? Yeah, that is a Norfolk County case. Krupp didn't get moved. Judge Krupp just rotates like every other judge, but he's in Norfolk County. All right, this is big. Let me breathe. Oh, dear God. I can't believe what I've just listened to. Did you like listening to it? Cosgrove in the voice of a whiny lady? Listen, this is absolutely wild. And let me just lay out why some of this is so wild. First of all, okay, so this Cosgrove didn't even respond to this initially. He had to do a whole nother filing. Now, the other thing is, here's where it gets absolutely wild. This honestly seems like reading something written by Kate Peter, or at least like highly advised by Kate Peter. And I really think there's something about that, and we'll talk about that in a little bit. But before that, let's start with this sort of initial layout. This is just so like dripping with disdain, and it's adversarial towards Lindsay. This is a case about Aiden Kearney. Cosgrove is adversarial towards Lindsay. This is the very reason he should be recused, argues Aiden, because Cosgrove, in a filing about his own recusal, spends most of it attacking Lindsay Gattani. Folks, my word. And the reason why I think Kate had some role in this is the way that Cosgrove in particular lays out like how Lindsay was attacked, that's exactly the kind of thing Kate would do. Like condemn the attack, but repeated verbatim. Like I skipped over that part and I'm not going to read it, but like this single paragraph is the most inappropriate thing ever written by a prosecutor. And if you weren't, what makes it so insidious is if you weren't familiar with this filing, you would think, oh, that's just Cosgrove laying out what Kearney did to Lindsay. He's trying to call a TurtleBoy. No. It's so much more insidious. He's trying to call attention to the attacks on Lindsay while putting it in the veneer of, oh, I'm just critiquing TurtleBoy for saying it. No, that's a Kate Peter tactic, man. You look like you're condemning it when really you want to spread the underlying attack. Jersey Girl, thank you so much for the compliment. Welcome to the Blue Wall of Justice. You have been afforded a towel wrench. Jersey Girl says, hi from New Jersey, Grant. Love your coverage. My pleasure. Now, let me just tell you, this is the single most abhorrent, ethically offensive, inappropriate paragraph ever filed by a prosecutor anywhere, in my opinion. Just look at it. Come on, I'm not going to read it. I'm not going to dignify this. But if you're a judge and you actually know the context, this is not Cosgrove condemning Kearney. It's Cosgrove attacking Lindsay by other means and doing it viciously. Viciously. Oh, my word. Now, I think there's a few point of facts that are just incorrect, as always, in a Cosgrove motion. So here, Cosgrove doesn't actually lay out what happened. Like Lindsay didn't make the initial report, and then she didn't want to report. He just says she initially didn't want to report. Did she go back? But now, listen, it gets really bad. Okay, it gets really, really bad when you get down to this part. I cannot believe this man. Robert Cosgrove said this. So this guy, Jason Broyles, is a man who pretends to be a woman online named Haley. All right. And I'll tell you that he's under his own sort of questioning right now by a lot of folks on all sides of this. I think he's connected to Kate Peter. All right. I think Jason Broyles is connected to Kate Peter and has always had dual motives. However, you see Cosgrove kind of like talking about how Gaetani Lindsay was vilified by Jason Broyles on the Haley account. I don't think that was to just the benefit of Aidan Kearney. I think that was for Broyles to get close to Kearney by making it look like Broyles was an acolyte. You know who I think really wanted Lindsay to be attacked by Broyles? Kate Peter. All right? And if you see, like, Cosgrove's talking about how Broyles pops up. Remind you, Broyles popped up right after the Jennings report, all right? In about March or February of 2024, right after Lindsay became a witness, a website popped up online called the Jennings Report, run by this fake profile called Mark Jennings. Well, it turns out that Mark Jennings, after he registered a website and forgot to veil his information in the public lookup, in the registrar lookup, he was a guy named Father Mark Murphy. Father Mark Murphy got defrocked from the Catholic Church, and then he worked for like Athena Garrison as like a political consultant, and then he kind of like went off the grid, moved in with a nice husband or something. I don't know. Good for him. The point is, he shows up, and as soon as he gets exposed as the Jennings report, which was targeting Lindsay and me in the exact same way that Broyles went on to do so, which only really benefited Kate in the long run. That, as soon as Jennings' report gets exposed, Murphy goes away and Broyles comes up as Haley Walbrecht. Now, Broyles had appeared initially in the fall of 2023 under his real name by helping to pay for a free Karen Reed billboard. And then he disappeared for a while and came back under Haley Walbrecht and started going at Lindsay, me a little bit, but mostly Lindsay. And I'll tell you, folks, I think it was no coincidence. I think that all this time, nothing's ever happened to Broyles. It's because he was really helping Kate and Cosgrove and the Norfolk DA. Now you say, why? Why would he do that? Well, why would they do that? Well, because it lets them have a mole close to TurtleBoy, and two, Lindsay was an expendable, quote, distraction, in my view, for the powers that be in the orbit of prosecuting Kearney and Karen Reed, and so they looked down on her, and they were like, oh, who cares if we release her unredacted phone extraction or manipulate it to remove messages from Tully to Lindsay and from Kate to Lindsay, and audio of Leah Genduso that Leah sent to Lindsay via voice note. Who cares if we do that? You know, who cares if we have it released by Tully? Who cares if Cosgrove releases Lindsay's SA report? Who cares if we have Broyles make a big distraction? That'll take the heat off the other witnesses. You know, nothing will stop the heat, quote unquote. And furthermore, Lindsay didn't have the connections to protect herself, and they clearly never were going to go forward with these charges. They were just using Lindsay. She was an unwitting honeypot to serve their benefit of getting Kearney put in jail in 2023 or into 2024, keeping him away from the Reed trial. It was all part of this sort of very tied-in plot, but Lindsay was the unwitting honeypot. And now that from the very beginning, they need, I believe, the Norfolk DA and Kate and that whole group needed to keep Lindsay in check, so they had in their back pocket Broyles being tormenting Lindsay to create a public distraction with Lindsay as the distraction by releasing her phone extraction, etc., keeping the Turtle Riders focused on her. And then simultaneously, Broyles was, and those groups would be mentally targeting Lindsay so she'd be destabilized and more susceptible to Kate's predatory behavior, because Lindsay would be so overwhelmed with the emotional stress of the situation she wouldn't be able to process what was going on. Well, I saw that happening, and I was like, okay, someone has to just empower Lindsay to be able to see through this. Well, how'd that work out for you, Kate? You know what I'm saying? You don't target the vulnerable, and it is very hard to help explain how to not only see these tactics, but when you're experiencing them, be stoic enough to have your cognition control your emotional response so that you're able to not only see through the tactics, but put together the larger mosaic and thus prevent this kind of stuff from happening. But let's see what Cosgrove does here. What does he do? Ladies and gentlemen, Cosgrove admits that he released an unredacted SA report in the context of discovery, and then he pins it on Broyles for publicly posting it in a court document. I don't believe there's an exception. I'm not a lawyer. This is not legal advice. I don't believe there's an exception to GLC 4197D. I've never even looked at this. Let's take a look. Is there an exception to, I'm not even going to ask. I'm going to just read the statute. GLC 4197D. Is there some kind of exception? I have no idea. All right. So let's take a look at this. I have never, and I just want to show you this. There's not one. I'm telling you. We're going to look at this together. Let me make sure. Yep, this window. Look at this. We're going to look at this. I have Googled it. We're going to find the statute. You can see they're all blue. I have never looked for this. I don't know what the answer to this question is. So we're going to click this one, okay? And what we're wondering is, Cosgrove's argument is that he was performing his official duty. So let's see what this says, okay? Is it a defense for, and I don't know, I'm not a lawyer, I'm not a legal advice, but let's see what this statute says about the rules for what happens if you release that kind of report. Is there a defense? Does it say, is it a strict liability? I don't know. Let's take a look. All right, here we go. Section 97D. All reports of R and SA or attempts to commit such offenses, all reports of abuse perpetrated by family or household members as defined in Section 1 of Chapter 29A, and all communications between police officers and victims of such offenses or abuse shall not be public reports and shall be maintained by the police departments in a manner that shall assure their confidentiality. Provided, however, that all such reports shall be accessible at all reasonable times upon written request to the victim, victim's attorney, other special specially authorized by the victim to obtain such information, prosecutors and victim witness advocates, as defined in Section 1 of Chapter 258, domestic violence victims counselors as defined in Section 20K of 233, SA counselors as defined in Section 20J of 233, if such action is necessary in the performance of their duties, and provided further that all such reports shall be accessible at all reasonable times upon written, telephonic, facsimile, or electronic mail to LEOs, DAs, or ADAs, and all persons authorized to admit persons to bail pursuant to Section 57 of Chapter 276. Communications between police officers and victims of said offenses and abuse may also be shared with the foregoing named persons if such access is necessary in the performance of their duties. Okay. Tell me, I understand there that it says a little bit about having access to it in the furtherance of their duties. And, this might not be the only section, actually. Hold on, let's look up the other section as well, because I think he referenced one more, didn't he? Hold on, let me look up the other one. He might have only referenced one. Hold on, Massachusetts. I thought he referenced something else. Maybe he did it in two different places. No, it's that one. But the point is, it talks a little bit in there about accessing it. The statute is classified. We were able to find it. It talks a little bit in there about accessing it, about accessing this kind of material in performance of your duties. Where does it say anything about releasing it? Not to mention releasing it unredacted. Raises more questions. Hi, 5MEO DNP. It is so good to see you, my friend. We have a big 2:15 p.m. Eastern hearing coming up in about 27 minutes, and I'm so glad to see you with us. Now, I will say, regardless of Cosgrove's argument here, okay, which I think is very attenuated and stressed, he still is like, Broyles posted it online. He's still... So then why haven't you charged him? I mean, I'm not a lawyer. This is not legal advice. I just have a question. Even if Cosgrove has this really weird argument, which I don't think, I'm not a lawyer, but I don't think it really aligns with what we just read, especially on a first read. Where does it say anything in there about, it says it about accessing it in the furtherance of your professional duties. Where does it say you could just release it unredacted? I don't think the legislature intended that. I'm going to go find who wrote that statute. They might be dead, but I'll find who understands that statute, and I'll ask them. I'll petition my government and say, tell me what this means. You're an electronics guy. At this point, I think it's less about electronics and more about who is working for who, Because even if they're throwing Broyles a little bit to the wolves here, I mean, they're basically accusing Broyles. I mean, I'm just interpreting it. They're basically accusing Broyles of being the endpoint of the public release. I mean, and obviously this is a court filing, so it's Cosgrove submitting it, and there you go. But what we hadn't heard before is who released it. And I'm telling you, Cosgrove admitting to releasing it, unredacted. Oh, goodness. Goodness gracious me. And let me just say, it gets a little bit weirder as well, okay? So, the thing I really don't like about... There was some stuff that I just found, factually tenuous and just a little weird. And then there was some stuff I was really uncomfortable with, okay? Now, the first thing I was really uncomfortable with is, one... I get that the state is saying, oh, we don't need to call Lindsay as a witness. But then they're also saying that Gattani is the only one who has information about certain communications between Reed and Kearney. And I know that to be true, because if you read Tully's affidavit from the search of Karen's phone, paragraph 72 to 84 in particular, pages 29 through 31, you will see exactly what I'm talking about. Which is that it wasn't just Natalie. Natalie was out of the picture completely by July of 2025, because initially it was about housekeeping, people thought, but it wasn't about that. Natalie and
Karen had a falling out because Natalie introduced TurtleBoy to a Sony producer, and TurtleBoy just like ran with it, and that pissed Karen off because Karen was like, "You can't go with the first offer. What are you doing?" So in that context, you got. And Lindsay was the one who. Lindsay is in fact the only witness for Tully's affidavit that spans the period September or so, October 2023 through December of 2023, when Karen and Aiden kind of have that falling out initially in December because Karen told Aiden not to go to Lindsay's on December 23rd. So to me, okay, that's where I find it so weird that Cosgrove's like, we don't have to call her. Well, notwithstanding that it's the state's choice who they're going to call, the defense can call her, okay? And then Cosgrove says it in other words here, but he's like, we won't let, if the defense tries to call Gattani, we're going to object. They don't even want to, no, well, Bossy Texas Chick, it looks ostensibly like a good job, but if you know the factual record, as I think, I'll declare myself one of the foremost experts on this factual record, he's just leaving a lot out. And the way that he's presenting the argument, one, it's an unnecessarily Kate Peters style attack on Lindsay. That paragraph where he smeared her for 7 sentences, calling her all those names, making it look like he was calling out Kearney for saying that about her. No, that was disturbing. And you won't get kicked out, Bossy Texas Chick. Just, just understand the network here. And if you read this motion less as about the state even caring about Aiden Kearney and more about Cosgrove trying to get back at Lindsay because it appears Lindsay revealing communications between Kate Peter and Ken Mello that were withheld from Kearney and Discovery has exposed the Commonwealth through the Robert Cosgrove misleading the court, perhaps unintentionally. So, yes, never forget the third option. Especially when I've done a close reading and we're getting close to a bombshell 2:15 p.m. hearing. Oh no, we're doing all facts, all erudite, cogent towel commentary today. We won't be belaboring anything, but it will be in a very quick and direct response if the factual record comes up. And furthermore, I got a second towel of coffee because I have to stay up till 7 for the social change warriors discussion I'm going to have. So there you go. You get extra awake towel. All right. Now, the other thing here is Cosgrove openly threatens her. He's like, oh, if Gattani contradicts anything she previously said. Excuse me? Is that what this is about, Cosgrove? No, there isn't anything about that that's at issue. It's the new evidence that Lindsay was privy to, which has to do not even so much with Aiden directly, but with Kate Peter communicating with the prosecution team that was withheld from Kearney and Discovery until Lindsay revealed it, and then all of a sudden you found it, I guess, Cosgrove. So just that sentence alone is so gratuitous. I mean, it demonstrates... in some sense, it demonstrates exactly what people were talking about. Yes. Well, Bossy Texas Chick, all legalese is the art of bamboozling. But the art of being a judge, in my opinion, is feeling pleasure in seeing through the bamboozling. So we always take a look at how the judge responds to the different arguments, and then we inductively reconstruct what the judge might have been feeling about who's spewing the most nonsense. Now, here, I think, frankly, Kearney wins on the merits, all right? I'm sorry. The reality is a lot of stuff was withheld from Discovery. There was a lot of tomfoolery. The stuff that was withheld from Discovery came out in public or through Lindsay or whatever, and then the Commonwealth tries to make up for it. It involves Kate Peter. That's why there's so much noise. This motion, though, just egregious. Just from Cosgrove, I think it is a terrible motion. Not only is it terrible on the merits, it is in form the embodiment. He's literally cutting against his own argument. This is an argument by Cosgrove to not have to recuse himself from the existing 2023 indictments and the 2025 indictments involving the window shop with the pizza. This situation, all right, is... this is supposed to be
Cosgrove responding to a motion to why he shouldn't be recused. Instead, he does the very thing that would warrant someone being recused, which is he uses his position to, one, argue a collateral civil case, argue the merits of a collateral civil case, two, make an admission in that collateral civil case about being responsible, hitherto unknown, by the way, information, that Cosgrove was responsible for the leak. It was only known that it was the Norfolk DA's office, quote unquote. But to openly, listen, it looks like in this paragraph, I'm not going to leave it up on screen, okay? It looks like up on this screen, Cosgrove is just trying to highlight some of the attacks on Lindsay, okay? But if you actually read it, all right, it is just Cosgrove doing what Kate Peter does, which is taking a lot of negative things, every smear you can imagine, every lie, every horrifying thing, and just quoting them and saying them about Lindsay while pretending to critique Kearney's followers. Come on, outrageous. It's on whatever page it is. It's that alone. I mean, listen, we have to rethink, in my opinion, the entire way, like, this case is being litigated, because that is punching below the belt. That is a former judge, that is a very skilled lawyer, a litigator with extensive experience, taking pot shots akin to an internet post against Lindsay, as if Kate Peter herself were penning this motion by talking to Pam Friedman and having Pam tell Cosgrove what to write. I mean, it is hands down one of the most gratuitous. It really pushes the line as to acceptability. One, he's going to lose on the merits. Two, the form of it is an embodiment of the conflict that Kearney's lawyers are trying to show the court. Cosgrove took the bait. I've never seen this. I'm so frustrated with this fucking case, because it's like, at least Betterow writes like a snarky lawyer, but like a fun snarky lawyer, like it's intelligent. Cosgrove writes like he's pissed he can't go on Twitter and chirp at people, so he's like, I'll just chirp at them all in the motion. It's not fucking social media. This is so petty. Betterow's motions, I don't always love them. He goes a little overboard. But they have that like flair. It's not gratuitous flair. It's flair with a purpose. This is not flair with a purpose. This is petty. And it's petty towards, it's unnatural and it's odd and it's towards a named witness and someone who's cooperating with the state. It's a harbinger of very bad things. It's a red flag. First of all, there's no need for it, okay? The motion didn't call for that level of pettiness. Second of all, it's inappropriate because he is a counter plaintiff or potential plaintiff, counter plaintiff or defendant or whatever the hell in that other case. Third of all, he's literally admitting to things in this filing that materially affect the other case. Fourth of all, he's wrong. Like, the way he's presenting facts is designed to make the court think Lindsay has less credibility than she does, and he's wrong about some of the almost everything he says about in that regard, which is making him adversarial towards her, which is the whole point of Kearney's motion for Cosgrove to be withdrawn. Nunya, absolutely. 2:15 p.m. is it? Oh no, what word did I say? What happened? Did I 5-MEO DMT? I don't know which word I said, but you just let me know. I may have said the F word there. I apologize about that. All right, now 15-minute countdown, ladies and gentlemen, until the hearing. You know what that means. Time to fire up the old Zoom machine. Oh boy, we're really at this moment, huh? Oh boy. All right, little towels, 15-minute countdown. I believe it starts at 2:15. Yes, I'm looking at the motion right now. It is at 2:15. The Zoom doesn't even open till 2:15, so I want everyone to preemptively prepare themselves. We will not be getting in this Zoom before 2:15 p.m., okay? It won't be happening. It says it will be opening promptly. With attribution, they are welcome to do so. Thank you to those who've been tuning in. If you were referred here by other channels, I am very grateful. Now I'm punching in the old numbers to the Zoom machine now. Here we go, ladies and gentlemen. It's one of those moments. Here we go. All right. All right. Here we go. Here we go. We are in the waiting room. The host has joined. Oh, goodness, little towels. These are the moments that try towel souls. All right. None is like, I'll settle for stick figure drawings. All right, we are just 15 minutes out. All right. The waiting room is open, and we are 15 minutes out from the major TurtleBoy hearing related to hidden Kate Peter discovery and apparently Robert Cosgrove. I don't know how to put this. Let's see. Embodying the principle that legal ethics could be just suggestions, in my view. I mean, oh my God. I've never seen anything like it. And we are just 15 minutes out, little towels. So get ready. It is coming up. Will Cozy be upsettero today? Well, will Cozy. Kyle, I have not seen the Bettero memo. You got it for me? Do you got a PDF? Kyle, I need it. If we can read it, we got 13 minutes, my dear friend. I'll do a speed read. If you got it for me, I'll use a voice that's not the annoying lady voice. We just need that PDF. Let me see if I can check Kyle's Twitter. Sometimes, Kyle is a member of Team Docket Rocket Stars, and Kyle is someone who is Super Towel. Now, you're going to feel like you're on a rocket ship for the next 15 minutes because I apparently didn't get an iced coffee. I got a latte. I don't know what the fuck a latte is. What the fuck's a latte? I drink fucking Dunkin's iced coffee. I had a coupon. I wanted to get a cheeseburger. It said you got free Dunkin' Donuts, $10 off if you added it to the order. So I got a coffee. The coffee was $7, paid a $5 tip, got it for $2. I said large fucking, I don't know, latte. It's not a fucking coffee. This thing is like 17 shots of espresso in a large coffee cup. Oh my goodness, ladies and gentlemen. I found the document, Kyle, don't worry. It was the first thing that popped up on my Twitter feed. Thank you very much. We will read it now. But let me just warn you. Don't give me lattes. What the fuck is this? First of all, why does this exist? I don't think we need to have a large iced coffee cup from Dunkin's filled with espresso and coffee milk. It probably is not very good for my heart. I'm just saying. I mean, I think it's a wonderful, wonderful thing. You know what I'm saying? It's effective for our purposes, but it's getting me a little riled up here. So fair warning, lattes are not iced coffee. Now, I'm probably not telling you anything you don't already know, but I just want to give you fair warning again that lattes are not coffee. Now, I'm glad that we are all on the same page here. Yes, ladies and gentlemen, lattes are not coffee. Oh, dear God, this is outrageous. All right, how long is this memo? The dairy part is good, and it's with coffee milk, too. So I like that part of it. It has a very unique taste. You know, I kind of enjoy it. However, what I don't like in the least, ladies and gentlemen, is the espresso. It's way too much. All right, so I got the Bettero reply memo. Let's see. Let's just bring this up on the screen. How long is it? How long is it? 14 pages. Oh, come on. Well, it's only 7 pages. All right, hold on. Let's see if I can just fly through this. All right, ready? Everybody ready? You're going to get an actual towel read. No AI. You're getting an actual towel read. I know, this is a very rare moment. Here we go. Thank you to Kyle Sharkey for posting this. How are you doing, Kyle? We're almost ready for the Zoom to start at 2:15. This is horse racing announcer towel mode for those of you who remember it from the Karen Reed trial. Karen Reed and John O'Keefe trial. Here's the reply memo. The Commonwealth's untimely response is more noteworthy for what it fails to include rather than for what it does. I love it, Bettero, speaking to the blank space. Strikingly, Mr. Cosgrove ignored the elephant in the room. He and lead investigator Detective Lieutenant Brian Tully have been sued by witness Lindsay Gattani for intentionally harming her during their prosecution of Aidan Kearney. Without more, the court should refuse to consider Mr. Cosgrove's submission unless the court concludes that he shouldn't be disqualified due to his conflict of interest. The defense, footnote 2. The defense motion to dismiss was filed on September 17, 2025. This is footnote 1. The motion to disqualify was filed on October 3rd. The prosecution was first directed to file its response by October 27th. On October 24th, the Commonwealth emailed the defense a copy of the motion seeking an extension. Unknown to the defense, the court had already granted the motion and directed the Commonwealth to file the response by the 17th. The Commonwealth ignored this deadline and served the defense on the 25th. Wow, he got an extension and missed the deadline. Which essentially was the day before Thanksgiving. The response was accompanied by a motion seeking an extension, which was tantamount to the Commonwealth seeking forgiveness rather than permission. Yep. 2, the purpose of this reply memorandum is to clarify big picture issues for the court in advance of oral argument. Ooh, we're not going to get this oral argument today, but we're going to talk about when it's going to happen. The defense detailed our former special prosecutor Kenneth Mello impaired the integrity of the grand jury proceeding. One expects that the Commonwealth would oppose serious allegations of pervasive prosecutorial misconduct by including with its response a detailed sworn statement from Mr. Mello. Yet rather than submit any sworn explanation from him, the Commonwealth provided woefully inadequate, unsworn hearsay from Mr. Cosgrove designed to justify Mr. Mello's misconduct. Acutely aware that Mr. Mello's too many to count errors before the grand jury impaired its integrity, the Commonwealth mostly ignored addressing his misconduct or case law supporting the defense. Instead, it urges the court to avert its eyes from the flawed grand jury proceeding by concluding that the defense waived this argument. As detailed below, the Commonwealth's preference for form over substance sought to mislead the court by ignoring binding precedent contrary to its position and by relying upon inapplicable civil procedure rules. Argument, point 1. All right, before we read this, let me just make sure all the volume settings are correct. Everybody hold their towels. All right, everything looks good. The irony of the court should not consider the Commonwealth's response unless it determines that Cosgrove should not be disqualified. The irony of Mr. Cosgrove's snarky criticism of the defense motion should not be lost on the court, given his failure to address the blatant conflict resulting from his prosecution of a matter in which Ms. Gattani is both his accuser and a witness, and where her credibility will conflict with that of his co-defendant, Detective Lieutenant Tully. On October 8, 2025, in a related hearing regarding his ongoing effort to search Karen Reed's cell phones, Mr. Cosgrove acknowledged the problem of whether it was appropriate for him to respond to the disqualification motion. If Mr. Cosgrove realized that it was improper for him to respond to that motion, he must also recognize the same problem exists with the Commonwealth's response to the motion to dismiss. Good argument. Although Mr. Cosgrove avoided directly confronting his conflict, he eventually filed a supplemental memorandum. He unwittingly illustrated why he must be disqualified. He believes that Ms. Gattani is a witness who possesses information that is favorable to the case he is prosecuting against Mr. Kearney. Right. It's not that she's going to switch her position. It's that she has information favorable to Kearney. As Mr. Cosgrove wrote, discovery provided by the Commonwealth shows that Gattani was indeed a witness, interviewed by the police with specific attention to what she knew about Kearney's ongoing communication with Karen Reed. After that interview, she received a summons to testify before the grand jury. It is hard to fathom a conflict worse than one where a prosecutor, civil defendant, concedes that a witness plaintiff suing him possesses information helpful to the prosecution. It is worse. Ms. Gattani wasn't simply interviewed by the police. She was an important witness against Mr. Kearney, who was debriefed about the subject matter of the instant indictments by Detective Lieutenant Tully, who just happens to be Mr. Cosgrove's co-defendant in Ms. Gattani's lawsuit. Lest there be any doubt that Ms. Gattani was an important prosecution witness, D.L. Tully relied heavily on her information to establish probable cause to obtain a warrant to seize Ms. Reed's cell phones, which years later Mr. Cosgrove seeks to search. Heavily is a good word to use there. I approve. Mr. Mello instructed D.L. Tully to serve Ms. Gattani with a grand jury summons, the purpose and timing of which has led the defense to argue that the investigation of Mr. Kearney was conducted in bad faith. In his overly sarcastic eagerness to ridicule this theory, Mr. Cosgrove unintentionally confirmed his conflict by emphatically agreeing that Ms. Gattani is a relevant witness in regard to this matter. Mr. Cosgrove similarly ignored the significance of his accuser's allegations against his co-defendant. While flippantly mocking the defense conspiracy argument, Mr. Cosgrove highlighted the intertwined conflicts arising from Ms. Gattani's and D.L. Tully's dispute regarding whether any content was deleted from her phone before an extraction report was provided to the defense. Ms. Gattani has repeatedly accused Detective Lieutenant Tully of deleting evidence from her phone. D.L. Tully denies this. Mr. Cosgrove has effectively accused Ms. Gattani of lying by supporting D.L. Tully's claim that any missing data on the extraction report was removed from Miskatani's phone before he took custody of it. This conflict is further exacerbated by Mr. Cosgrove's support for D.L. Tully's position about his communications with Miskatani and the contents of her phone, and his assertion that cell phone expert D.L. Tully couldn't access his text communications with Miskatani from his iPhone. All of these examples establish that Mr. Cosgrove's conflict is suffocating. In addition to endorsing D.L. Tully and effectively discrediting Miskatani, he has made himself a witness in the inevitable sworn dispute from the witness stand between D.L. Tully and Miskatani over the contents of her cell phone. While it is admirable that Mr. Cosgrove desires to prosecute this contentious matter, he cannot close his eyes and wish away an obvious conflict where the interests of a witness who should be favorable to the Commonwealth are directly adverse to his personal interests, as well as those of the lead detective. For those reasons and those described in prior defense submissions, Mr. Cosgrove must be disqualified from the case, and the court should reject the Commonwealth's November 25th, 2025 filing. 2. The defense has not waived its right to argue that the Commonwealth impaired the integrity of the grand jury. To the extent that the court entertains the Commonwealth's response before addressing it, Mr. Cosgrove's conflict, it should summarily reject the Commonwealth's crafty argument that the defense has waived its right to argue for dismissal on the basis that the integrity of the grand jury proceeding was impaired. According to the Commonwealth, the defense has not satisfied all of the prerequisites of Superior Court Rule 9D before seeking dismissal of the indictments after a prior dismissal motion was granted in part and denied in part. The Commonwealth's emphasis that the defense has flouted all of the prerequisites implies that Rule 9D is binding on the court. This is profoundly misleading. The rule applies to civil cases. Styled applicable to all cases, all civil motions shall be governed where applicable by Superior Court Rule 9A through Rule 9E. In any event, it is well established that the court may consider the pending defense application even if it concludes that the pending motion includes grounds which could have been raised in a prior filing. Reconsideration of prior motion is not restricted to situations where the defense could not have known additional grounds prior to the first motion. Court's power to reconsider a prior decision during the pendency of the case is firmly rooted in the common law. If the court does not accept the Commonwealth's response, the prosecution, of course, may advance any good faith waiver. All right, we got to go into the Zoom. I'm going to go quiet.
Good afternoon. This is the Zoom for Norfolk Superior Court. This is Commonwealth versus Aidan Carney, 23 CR 313, 25 CR 88. We just ask people to remain on mute, and if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, Mr. Cosgrove.
Go ahead, Tim.
Mr. Bradley, you're muted.
Sorry, Your Honor. Hello, Tim Bradle for Mr. Carney, Your Honor.
Good afternoon, Mr. Bradle.
And Mark Betterow for Mr. Carney. Good afternoon, Your Honor.
Good afternoon, Mr. Betterow. Good afternoon, Mr. Kearney. Okay, folks, first time meeting, so let's have a brief before we get into the substance. I've noted from the docket on this case that there were already a couple of judges who recused themselves given past dealings. So I want to deal with that issue right up front and get that out of the way. I'll start with the parties first. I've never dealt with you, Ms. Betterow. This is the first time I'm meeting, so I don't think there's any reason for me to engage in any analysis under Rule 211 with regard to disabling prejudice. So I think we're clear on that issue.
We're good, Your Honor.
Excellent. I'm glad to hear that. With regard to Mr. Bradle, Mr. Bradle and I have known each other for more than 30 years. We tried cases against each other when he was with the Suffolk County District Attorney's Office, at least a couple, probably more. I don't remember, but there were at least one significant case against each other. During the time that he was a member of the defense bar and I was a member of the defense bar, we handled cases co-defendants, although cases went to trial. We certainly had a number of cases in which we represented co-defendants, at least through the motion stage. Outside court, we had a cordial, friendly, and cooperative relationship as members of the defense bar, but we did not socialize anywhere outside a legal setting. So given our dealings, I'm certainly satisfied that I don't suffer from any disabling prejudice with regard to Mr. Bradle. With regard to Mr. Cosgrove, when he was just Judge Cosgrove, I did appear in front of him a number of times. I really don't know how many times, but probably better than 25 or 30 times, I'd guess, as he sat in the various counties. I don't recall that he ever presided over trial that I did, but I know for certain that I did a number of motions to suppress and motions to dismiss with then Judge Cosgrove. There was nothing out of the ordinary relationship. It was purely a relationship between counsel and the judge at that time. We've never had any social contact except for in legal settings, and they're extremely minimal. Given that I took the seat that Judge Cosgrove, then Judge Cosgrove vacated, we were never colleagues on the Superior Court and never had any interaction on that level. And as I said earlier, we've never had any social interaction outside a few minimal contacts in legal settings. So I'm fairly comfortable in reaching the conclusion that I suffer from no disabling prejudice due to past appearances before, and certainly never did work with then Judge Cosgrove. With regard to the parties in the case, I've gone through the pleadings as much as I can. I've looked at the indictments. I've noted the names that seem to come up over and over. I'm familiar with none of these people. I've never met any of the civilians or interacted with them directly or indirectly who are involved in this case. As to members of law enforcement who are involved in the case, some of those names I have encountered, members of the state police, as well as members of the Boston police. I would add to that any dealings I had with them would have been as a criminal defense attorney, probably mostly seeking to undercut their credibility, but never had any personal dealings with them outside a courtroom. Certainly no social dealings with them. So I'm fairly comfortable in saying that I suffer from no disabling prejudice with regard to any of the parties who I've seen listed in the papers. The final issue, it is public knowledge that I grew up in Canton in the 60s and 70s and part of the 80s. I'm considerably older than all of the people involved in this case, so I didn't go to school with any of them, nor did any of the names, as I said, ring a bell for me. I lived in Canton, graduated from Canton High School in the early 80s, moved out for college, lived there intermittently through college and law school, and left there for the final time in, I want to say, 1990, to the best of my memory. May have used it as a mailing address after that as I cycled through some post-college apartments, but have not lived there full-time since the early 80s and have not lived there at all since no later than 1990. I don't have any contact with the town in particular, nor do I have a prejudice for it, for or against any issues that might happen in that town, nor special knowledge thereof. So I'm comfortable in finding that I have no disabling prejudice as to my past associations in the 60s and 70s and early 80s with the town of Canton. So that being said, I'll go around the table and see if anybody has any problem with that, beginning with the defense. Any issue at this point with regard to disabling prejudice under 211?
No, Your Honor, and I agree with everything you said, and I appreciate the comprehensive rundown of everything.
Attorney Cosgrove.
I thank Your Honor for your thorough summary. Your recollection of our personal associations exactly coincides with my own. Having listened to your explanation of your associations with Attorney Bradel and your knowledge or lack of knowledge of the witnesses that may be involved in this case, I have no objection to Your Honor sitting in this case.
Okay, excellent. All right, so obviously I'm in Brockton. You guys are at different places. I'll give you my schedule going forward. Going forward, I'm assigned to Suffolk Superior Court. The first 6 months of the year, I'll be sitting in room 1008, which is a civil session. The second 6 months of the year, I'll be in room 808, which is a criminal session. I think at least for now, we'll work this out as we go forward, have a greater clarity as to how we're going to handle it. At least for now, for the next set of motions, which we need to get to, what we'll do is we'll do those in person in Suffolk Superior Court. What room that's going to be in, I don't know yet. The way Suffolk runs things, their civil clerks don't sit on criminal matters. There are two separate clerks' offices in Suffolk. They're very distinct in what they do. So either I'll bring the matter into 808 where there is a criminal clerk, or will perhaps be specially assigned to another courtroom. Sometimes courtroom 1309 is used as overflows. I don't know where we're going to be yet, but I can tell you that the next set of hearings will be in person in Suffolk Superior Court. So let's move on down the agenda. I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now. So, assuming, well, let me just say this. If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion or allowed it in some modified form to set up a taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team, and then at that point, the Commonwealth would get the information as approved by the court to go through it, and assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate, well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this. As I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download of 2 phones, which is in the Commonwealth's possession and which has been turned over to the defense. And there are other electronic devices which were seized as a result of the search. And that's what is subject to the ongoing taint team here.
And there's no conspiracy charge between Reed and Kearney in this case, correct?
No.
So presumably any evidence we have with regard to Kearney is going to come off his own phone, I take it.
Well, that's the situation now. I can't speak to what might be discovered in the process of the search. The conspiracy that's alleged in the search warrant is conspiracy to intimidate a witness. The charges against Mr. Kearney here include intimidation of a witness. So it could be relevant, although obviously, no. If any conspiracy indictment resulted against Mr. Kearney, it could not be tried with the indictments here absent his consent.
Okay. So, Mr. Bradle, briefly, anything to add to that in terms of just what procedure we would have? I don't want to get into the substance of that issue. We can deal with it later if we need to. but procedurally, you sort of think that's the way it would go?
Judge, we are interested in dealing with the disqualification motion first. Attorney Better filed a very comprehensive motion to disqualify Mr. Cosgrove. He's being sued by.
I'm going to come to that, Mr. Brady.
Yeah.
I want to make sure we understand the impact of Judge Krupp's.
Sure.
Good. If I may, that, and I don't want to merge the motions, I understand what the court is doing, but that disqualification motion also includes the investigation involving Miss Reed's cell phones, because it is virtually the identical conduct and the identical facts that are from the 2023 indictments. And again, without merging too much of this now, there is a disqualification motion on the indictments before Your Honor now, as well as the investigation that Mr. Cosgrove is doing, because the same witness who is at issue in the disqualification was a primary or one of the primary sources that led to the warrant to go after Ms. Reed's phones. So they are kind of intertwined. And if Mr. Cosgrove is saying, as he seems to be suggesting, that he can't predict the future in the event that he were able to search the phones, but if evidence were to be discovered and lead to a conspiracy indictment against Mr. Carney, that implicates the disqualification issue. At this time, I'm unaware that Ms. Reed has joined that motion, so I don't want to speak for what her counsel would advise, but to the extent Mr. Carney is involved in anything to do with what we're calling the open investigation involving Miss Reed's cell phones, we think that the disqualification as it relates to Mr. Carney needs to be dealt with in the first instance.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did up until the point where...
I'll get to that. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come, and what Attorney Cosgrove choose to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later, and it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
All right. So how soon would we be ready to deal with the issue of disqualification?
Judge, I just wanted to throw out some dates if I could. January 12, 13, or 15 is what we're proposing.
Okay. Does that work for you, Attorney Cosgrove?
No, I'm out of the country on all of those dates.
Okay. How does now, Mr. Brady, you've got some other business that's going to happen up in Essex County. You're scheduled for trial up there?
That's February 9th, Your Honor. That's correct.
How soon before that are you going to?
Your Honor, I could, give me a moment.
Hold on, Attorney Cosgrove. Mr. Brady, how soon before you become unavailable due to that trial?
Judge, I'm pretty flexible. I really don't want to delay the disqualification too much. I mean, unless Attorney Betterow has a different view, I'm thinking, can we do it a little sooner then?
No, I want to wait till I get to Suffolk.
Okay. Oh, I understand. Maybe is it? Should we do maybe the third week in January?
Let's see what Attorney Cosgrove has to say. What's good for you, Attorney Cosgrove?
That's fine.
Let's pick a Friday, late January.
That's the 23rd.
Attorney Cosgrove?
I can do the 23rd.
Mr. Bradle?
Yes, thank you, Your Honor.
All right, so we're going to mark that up for January 23rd I'll be in touch with regard to time and place. I need to talk to Suffolk to see where they can accommodate me. I'll know that certainly by early January, what courtroom we're going to be in and what time. My inclination probably would be maybe a noon or a 2 o'clock hearing. I don't expect it's not going to be non-evidentiary, I take it, correct?
Correct.
Initially, at least, yes.
That's the way I read it. So we could probably get it in the afternoon. So it'll be either noon or 2 o'clock that will deal with that matter in Suffolk on, we'll call that 123 for now.
And I think, Your Honor, if I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's motion to dismiss the case.
That seems to be the right step to me as well. How does that sound to the parties?
Yes, we wanted to bifurcate the disqualification from that. Absolutely.
I think that's the right choice. Okay, so do we want to get that on the calendar now, or do we want to wait till the disqualification is done?
I think it makes sense to wait, but I'm at Your Honor's disposal.
We can wait because I'm pretty flexible when I schedule things in Suffolk. Okay, we'll wait on that issue. Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drabs without, as far as we can tell respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks, we're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove, in his motion seeking extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else. That would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control, and we haven't received that.
I don't know who you're talking about.
Jennifer McCabe.
Okay. Mr. Cosgrove?
I will look into that as to Mr. Bettero's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday, if the post office can be believed. Does include materials that I received from Mr. Bettero, notably a grand jury exhibit that they recently complained that they, I'm sorry, received from Mr. Mello, not from Mr. Bettero. Notably a grand jury exhibit that the defense complained that they had never received, that was not in my possession or in the possession of the state police. And I finally managed to get it from Mr. Mello, who had that particular exhibit. So they'll be receiving that and some other materials from Mr. Mello
Okay. All right. Well, if there are particular issues that need to be addressed by the court, let them know. We can get together quickly Zoom and deal with them.
Judge, I think there are, and respectfully to Mr. Cosgrove, Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything so we don't have to rely upon Mr. Mello to discover grand jury exhibits for 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I'm going to leave the details of how Attorney Cosgrove complies with Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible. Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradle, Ms. Bedroff?
It's a little premature for us, Judge. We're sort of baking the cake right now, and we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things because they are all the same folks, and it seems like this case, in terms of evidentiary, the acts themselves, I don't want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
it's a very fair characterization, Your Honor. There's a bit more to do on the newer indictment. We don't have grand jury minutes even yet, and
I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Carney?
It's Carney, Your Honor.
Carney, I apologize.
Okay.
So, look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done. Now, how long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be, on behalf of the Commonwealth, a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
Sound about right, Mr. Bradle?
I think so, Your Honor.
Okay. When do you folks think would be a good time to try it? I'm not going to hold you to this. I just want to start sketching out in my mind when and how we're going to do this.
Judge, on the 2-week thing, are you saying full days or half days?
I'll go full days.
Okay, that'd be fair.
Any thoughts on when we could do it? The only time let me just block this out. I'm supposed to do an asbestos trial in June. That's going to take just about a month. So June is going to be out completely for me. So, work in terms of our calendars, just sort of scratch that one off.
Judge, it's a tough call in light of how much stuff we still have to do. It's a tough call. I mean, I could see this not going until the fall, mid-fall. You know, there's just so many. This team stuff takes forever. We haven't even gotten any automatic discovery on the second case yet. We're still waiting for a grand jury minutes. There's a lot of extraordinary motion practice here. Disqualification, dismissal for extraordinary government misconduct. Discovery, as my brother said, is dribs and drabs. We have this prosecutor who's very ill, apparently, who's no longer on the case. He's been disqualified. Attorney Cosgrove's been disqualified from the 24 indictments, which have now been dismissed. There's just so much going on in this case. It's not your garden variety situation. And I think we really are realistically, if you want to put a cap on it, I think the cap has to be, mid to late fall, because we're just not going to get all this stuff done. It's been historically glacial pace.
I got you. And I don't have a problem with that. Mr. Cosgrove, how does that fit with your timeline and your availability?
Well, my availability is pretty open. As far as timeline goes, I don't associate myself with all of Mr. Bradle's comments. I agree with his bottom line. This is a complicated case in some respects with quite a bit yet to do and a lot of contingencies. And obviously, if Your Honor allows the motion to disqualify me, it won't be my problem, but that will certainly have an effect on the timing of any trial as well. I will say,
let me just slow you down for 1 second. The disqualification, as I can tell, is only on the 23 case. Is that accurate?
It is accurate, Your Honor, but if you disqualify me in the 23 case, it wouldn't make any sense, as far as I'm concerned, for me to try the one incident on the 25 case. I would respectfully ask the district attorney to relieve me of that responsibility.
Well, let's not go there yet. Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November, maybe November 9th, 16th, December 7th? Any of those?
I can pretty much make those dates work. And I checked with Suffolk, but we have flexibility here. Okay? So if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have access to that docket right now. But pencil yourself in for around that time. And we'll put this up once we get through the motion to disqualify, which will be on the 23rd. Okay? So, but let's try to work our way towards that date, and get this thing in front of a jury, and get it resolved, one way or the other. Okay. What else can we do?
Good, Your Honor. Thank you. I think that's everything on your agenda, Your Honor. I was following along on your scheduling order.
Mr. Cosgrove, anything else?
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to be paper copies. I'm not sure why he entered that order, but I do find sometimes that when we are close to a deadline, I am close to a deadline, that taking a special run over to Norfolk Superior Court to deliver a paper copy is a lot less convenient than being able to do it electronically. I
would read Judge Doolin's order to be a paper copy has to be filed. If you're up against a deadline and you have to email it in so we have it to prepare, that's fine, but a paper copy is going to have to be put in the file at some point. But if there's a deadline set.
If that's Your Honor's interpretation, I can certainly comply with that.
Attorney Bradel and Attorney Betterow and I have it.
That'd be a big help. I agree with it, Your Honor. Thank you.
But make sure a paper copy gets filed so that it, I'm not even sure that, Mr. Bradel, you can correct me because it's been a while since I sat in a criminal session in Suffolk. I don't think the Suffolk Clerk's Office takes electronic filings, do they?
No, they don't, Your Honor. Norfolk does, Suffolk doesn't.
All right. So right now this is a Norfolk docket. So you're going to continue to file there. But, if you file electronically to the parties circulating the documents that way, that's fine.
Appreciate it. Thank you.
If it's a day late, it's a day late. You don't need to drive to Norfolk to get the paper filed that day. As long as it's electronically filed, followed by a paper file, that's fine.
Thank you, Your Honor.
All right. Anything else we can do today?
Not for the Commonwealth. Thank you very much, Your Honor, for your time.
So let me ask you one more question before we go. Are all the papers that I need for the disqualification motion filed?
No, Your Honor. Just a couple of hours ago, Mr. Cosgrove, I think, filed a response that, frankly, we had anticipated earlier, but we filed something addressing that yesterday, which I don't know if the court has seen or not. And Mr. Cosgrove filed something today. We've perused it. I believe I'm going to want to file just a brief reply in the next 10 days or so.
Brief reply. We have lots of...
I'll do my best.
Lots of paper already in this.
I may have an additional filing as well, but it'll be well within the 10 days that Mr. Betterow speaks of.
I know that the civil rules have already been brought into play here in the pleadings here, that they don't apply, but there is that motion reply, sir reply, and that's it. All right. You can file what you need to file, but
yes,
it just doesn't. It's got to end at some point. All right. So file what you need to file. I want everything filed 10 days prior to the hearing. Okay. So no filings will be accepted on the disqualification issue unless there's new evidence after 113. Let's get this thing squared up and ready to be decided that day. Or argued that day, decided shortly thereafter.
Yes.
All right. Anything else we can do?
It's good, Your Honor. Thank you.
All right. I'll as soon as I get to Suffolk and I have a better idea where we're going to sit, I will give you folks notice as to the time and as to the actual time of the hearing and the courtroom in which we'll be. That'll be an in-person hearing.
Thank you, Your Honor.
Thank you.
Mr. Betterow, do you intend to be there in person?
I will, yes.
Excellent, because Zoom is a little difficult when some people are, hybrids are difficult. Let's put it that way. Okay, that's all we have today. Thank you very much. Margaret, you can close it up.
Thank you.
Thank you, Your Honor.
Thank you.
All right, folks. My name is Grant Smith Ellis. You heard it. I'll recap it. We'll watch the replay. Then we'll take it home, and then you'll see me live again at 7 o'clock, where I'll be talking with Social Change Warrior, and we'll digest those happenings, filings. There's a lot to talk about. All right, so my name is Grant Smith Ellis. Where are we going to begin? Let's begin by talking about what just happened. So we have a trial date in the Aiden TurtleBoy Kearney case. All right, I repeat, we have a trial date, ladies and gentlemen. That trial date is mid-February, ladies and gentlemen, mid-November of 2026, which is exactly after the Norfolk DA's election. now anticipate a few delays on that trial date into January of 2027. The new DA's in office. You can see Bradel and Betterow got exactly what they wanted. They weren't exactly jumping up and down to say it, but it was very clear, ladies and gentlemen, that the Kearney defense was very pleased with that initial setting of the trial date. It's because it's provisional, and the new DA will no doubt already have been selected by virtue of the primary and the general election. The primary's in August or September of 2026, the general's in November. So first Thursday or so. So there you go, folks. That was the big moment. I mean, it's a little bit hard to see it. You really had to have been watching it. But it was there. It was a big deal. I'll take you through it. And I'll tell you, I think the state is on the ropes. Did you hear Cosgrove say that if he is disqualified from the 2023 cases, they're just going to abandon the 2025 cases? My goodness. My goodness. And we didn't even get to touch on the actual discovery disputes. Not to mention the other big news, all future TurtleBoy cases will, going forward until probably trial, will be at Suffolk Superior Court in Boston, because the judge in this case is sitting there, so he's not going to drive down to Dedham. Judge is going to be assigned in Suffolk. He's specially assigned to this case. That's what they did. The justice system took this case out of Norfolk County. They didn't, I guess they, and then by specially assigning it to Judge Belzeos, by then putting Judge Belzeos in Suffolk County, they were able to just say, well, you know, why don't you have the hearings in Suffolk? It's a completely different atmosphere. Parking is incredibly expensive. It's difficult to get to. You can stand outside in the plaza, but it's like right in front of the SJC. Yes, it's more accessible for the media, so that's probably a positive for TurtleBoy, but it's a different environment. It's not like you stand outside, walk in through security, and you're in the courthouse. If you've never been to this area downtown, I mean, I can show you it on Google Maps. If you want to see the courthouse that Kearney is going to be in, let me just tell you right now, this is no regular district court. I don't know if a lot of the Turtle Riders have been down here before. Let me just pull up the Google Maps, and of course, I'll show it to you for the purposes of us being able to learn. So let me just show you what this is like, okay? I'm going to see if I can get the street view. No promises. So just the location of it. I mean, it is literally in the middle of downtown Boston. All right. Now, I don't know if we're going to be able to actually get a shot of it. Maybe they let you zoom in. Hold on. So let me just show you what this building is like, okay? Let me bring this up on the screen for you. 1 second. Oh, no. I closed the chat. I brought the chat back. All right, let me just show you what this is like. So this is the biggest news. I mean, this changes everything. I don't think anyone was expecting this. So take a look at this right here, okay? Take a look at where the building is located, all right? So it's right there. Just to scroll out here if you've never been to Boston. So that's coming over from Cambridge. It's going to take a while to load. That's coming over from Cambridge. That's coming from like BU and the Fenway area over here. That's the Common, all right? That's the middle of downtown. That's the State House. And then that's like literally like where City Hall is. And then if you zoom in, this is the building. There isn't any parking. There is some parking if you know the area. There are some places you can park, but there is not very much parking. It's going to be very interesting. It has like some pluses and some benefits for each side. The media much prefers this. I mean, not Fox 25, they're down in Dedham, but the rest of the media, they're all right here. I mean, they're not right here, but they're in this general area because they cover City Hall, this court, the other court over here, this SJC, they cover everything. So this is like the epicenter of news coverage, but like they don't really touch his case. Maybe they will now. But in terms of getting to it, I mean, you could take the T. That's pretty accessible. You could drive, but you're either going to pay like $80 for the day. Like you can't just go camp there. Or you can get maximum 2-hour parking on the ring here. And then also you can get 2-hour parking right here. You see this Bowdoin Street? I mean, just look at the double parking, though. To get parking on Bowdoin Street, first of all, you got to time it perfectly because you can only get 2 hours. Can you tell I know what I'm doing downtown? You can only park on like this street. Everything else is red in here. You can find some stuff over here, but by the time you're all the way over here, like doing the walk to get to the courthouse takes like 20 minutes, and then you have to like get in the elevator. You're going to get ticketed. You could potentially park here, but again, you can't do that for a long hearing. You got to know if you park there at 1, you got to know you're going to be back at 3, or you better leave that courthouse and park that car. You're getting banged for $75. Otherwise, you got to park in the parking garages, which are even worse around, especially around this area. So in that regard, it's like tactically designed. I mean, it's very hard to go. Not to mention, it's very hard to go, like, as a member of the news. Like, they have to really want to do it. But as a member of the public, it's hard to go for a little bit, and you can't do a full day. You can't, like, I guess you could, like, take the train in, but, like, for every hearing, it's a lot. It's, like, an experience. And it's not very welcoming. There are some shops in this ring here and whatnot, but I wouldn't exactly say like this space is welcoming. It's very intimidating. And anyway, all right, so there's that. I think as my analysis of it, I mean, it changes the dynamic completely. And the courthouse itself, let's see how much we can zoom in. The courthouse, we might be able to get a street view of it. Hold on. The courthouse itself is very interesting, okay, because I don't know if this is going to take us to what I want. I wanted the street view. Yeah, see, so like it's nestled. This is the back of the SJC. Then you go down here, okay, and then you go over here. I'm using this for educational purposes. And then what you do is like, so this is like a peace garden, a police officer memorial peace garden. Let me get you a better view. And then over here, you can park, as I just said, on Bowdoin, and then cut through a staircase here and like come over here. And then once you're over there, you can, like, it doesn't look like you can go up here. It's not very welcoming, but that's the entrance. You walk along this building. There's no parking at all. This is just for, like, the court staff and judges. And then you go over here, and it's this building. So the building itself, I just want you to understand, it is not a regular courthouse. It is what, like 17 or like 19 stories tall. It's very old. The courtrooms themselves are like 20 feet tall. You can't really tell, but each like courtroom is probably from one air conditioner to the next, and probably more. Like they're giant. Like some of them are like easily 20 or 30 feet tall up on the fifth floor. I don't remember. I go there sometimes for governmental, like regulatory, administrative, like procedure hearings that get up into the court. It's a very high-level court. I mean, both literally and figuratively. It's imposing. It's, like, different than most courts. But, yeah, and then there is a little area out front there where you can kind of stand around. And this wall, this sort of building exists. I think there was a truck attack in the 20s or something on the SJC. So they built this building as a facade to protect the courts. But, yeah, this is it. That's Suffolk Superior Court. That is it. It is a very intimidating building, and then right behind it, so this is Suffolk, right? Suffolk University, and then that's a state building. So like the State House is right behind this building. This used to be a reservoir, like behind that gap, like in there. But like on the block over. But this, like the treasurer's in this building, I'm pretty sure. Like every major state government office is in that building right there. And then this building is the creepy building. You want to talk about a creepy building? I don't know what the fuck goes on in this building, but every time I walk by that building, I'm like, I'm not fucking with that building. It gives off this aura like, don't fuck with me. I'm telling you, I didn't know it's possible that like a building could give off an aura. But so this is the Garden of Peace I was talking about. It's a memorial for victims of homicide. And if you go to this, so this is the juxtaposition. It's like this like peace garden. But then over here, I don't know, I have some idea of what's in here. But this thing, like whatever this is, don't fuck around with these people. I don't know exactly what they are, but I never ever want to fuck with them, whoever they are. It's some like high-level federal stuff, I'm pretty sure. Because, like, one, it's very nondescript. Like, when you walk by it, it just looks like a building. But then you, like, try to figure out what's in it, because it's easy to figure out what's in this building. All right, the state government building. But, like, this building is, like, one of those buildings you walk into, and then it's just a bunch of doors with, like, lawyers' names on them. And you're like, what are you doing? I've never been in there, but I'm saying this is an experience people have told me about. You walk in there, and you're like, is this X? And they're like, yeah. And then you get interviewed, and they're like, oh, yeah, so your clearance, background clearance, and yeah, oh, okay, it's the feds. So anyway, my point is, this is a police building, I think, is that's the designation. But whatever goes on in that building is very intense. Now, this whole area, let me just show you. You can't be parking around here, okay? This is all police parking only, okay? Even though the signs, there you go. It's all police parking only. From here, over here, up here, you can't park anywhere around here. This is all police parking because it's not for Suffolk. It's for this building. It's a little bit for that major state building, but it's this thing right here, whatever this is. This is like the epicenter of some serious shit. I mean, it's not the main federal building, I'm pretty sure. I think the JFK courthouse or building is right across, but this is like their supplementary building or something. Yeah, let's just say, I mean, there's interesting stuff to see, but this is not exactly like conducive to crowds. You really have to plan your whole day around it. It's like going to like a game. It's expensive to do it. And that's why, I mean, when I go down to, I don't really like brag about it. I'm not like filming myself, but I'm telling you, when I cover these court cases, a lot of stuff people aren't even that interested in. It's more like governmental regulatory affairs. Dude, I have to go down there. I have to have this whole like schematic plan about timing so I don't have to pay for the parking garage. I have to, like, I know how to camp on a spot. Like, so I sit and wait for someone to leave and then I pull in, and it's an adventure to get down there if you know how to do it. But it's definitely not like Dedham. Okay? It is not like Dedham. It is not right off the highway. Well, everything's right off the highway in Boston, but it is not right off a highway exit. It's tucked from one way. You have to get past MGH and the Storrow interchange down there. Like, you don't want to deal with this shit show. Let me just tell you, like, especially if the hearings get out at 4 p.m., let me tell you right now, you do not want to deal with this fucking road. People talk about driving in Boston, but from an actual local, let me just tell you, this fucking road, this is that road I was telling you about, that comes down here, Bowdoin Street. When you have to turn onto Bowdoin Street, first of all, you have to deal with this bike lane. Second of all, ostensibly, this is a right turn lane, but it only exists for 10 feet because of the fucking bike lane. So everybody trying to turn right stays back here, which means there's only one forward lane until like right here, then it merges off. Then you get to this clusterfuck of an intersection, which down there is the garden, okay? That like behind, like over to the right there is the Boston Garden, okay? This fucking intersection, okay, that's also some kind of important state building. This intersection is the worst fucking intersection in Boston. Because just when you think you're home free from that chaos back there, you then have to deal with going down this fucking road, and then you deal with this fucking shit, which is just light after fucking building and parking garage. And then you get into the fucking hospital district, not the one down in Longwood, but the MGH district. This is at a good fucking time of the day. Doing this at 5 p.m., you are lucky to do that section of the road in an hour at 5 p.m. Because then you got to deal with these assholes down here who think they're fucking like king of the walk, all the goddamn doctors. They all have to get to MGH. So this intersection is bad. Then, as if that's not bad enough, you got to deal with this Traveshamockery, which is a fucking T station in the middle of a rotary that isn't really a rotary. It's more like someone cut part of the sidewalk out to let people drive from Beacon Hill and have an easy access onto Storrow. Then you gotta deal with this fucking light at the hotel over here. Only then, by the grace of God, do you get to fucking Storrow. Now listen, if you're taking Storrow west to go out to the suburbs, that's one thing. But you want to talk about going 93 fucking north at 5 p.m. in the middle of the day? Oh, you're fucked. You are fucked worse than anything you can imagine. You want to drive this fucking shit? You know what you got to do at 5 p.m. to get to 93 North or Route 1 North? You got to go up to this fucking Travis-Mockery. And then look what you got to do. You can't even merge over to Route 1 because of the barrier. It takes you into this fucking thing. If you lived here, you'd be home now. Then look how chaotic it is. You got to go all the way down here, and only then can you merge onto 93. But no. You want to go 93 South. Good luck with that fucking shit show. You want to go 93 North. You then got to go around this fucking thing and go on some loop and deal with the 93 North traffic till you get past the split. It is by far the most ridiculous thing. And you want to know what's kind of cool? Obviously, you probably have never had this experience, but I drive this and have for almost 40 years, so I know it like the back of my hand. You can just if you know what you're doing, you can avoid some of this shit. But even the best Boston driver is not able to avoid all of it. So, for example, if you want to come down into the city, what you really want to be doing is, like, depending on the time of the day, you want to get down into this area, because then you don't really want to go over there unless you're parking for one of the courts. What you want to do is you want to come up like this, okay? Then you're kind of positioned, if you know what you're doing, to sneak down here, all right? Now we're coming down by the other court. This is what the Boston Municipal Court. That's kind of a cool building. It has this really cool, like, spiral facade. Anyway, the north end is going to be on your left over here, all right? And once you're over here, then you can kind of navigate to kind of look for parking. But the point is, it's only 2 hours, okay? And even once you're over in this area, you're competing for parking. There's no gimmies here. You need to know exactly what you're doing, where you're going at all times, and how you're going to get there. But anyway, you can kind of swing back around, and you'll see it looks a little bit disorientated, but we've basically come back around, and now we're on the other side. This is Boston City Hall of where we were before. So if we took those steps up, you see that building in the background there? That's that curved building, and on the other side of it is the court. Boston isn't a very big city. You just can't miss any fucking turns. You need to know exactly what you're doing, and you really shouldn't drive there unless you've driven there for a long time, which means if you haven't driven there before, don't fucking drive here. So anyway, if you actually wanted to drive up to the court, it would look like this. You'd come around this building, you'd come over here, and then you're kind of at this fucking chaotic intersection, and now we're right outside Boston City Hall. All right, I went a little bit too far and actually went off the road. Hold on, how do I get back to the road? I did not want to do that. The point is, and then we've now made our way in a full circle because this is that curved building, look at Boston City Hall, and on the other side of these walls is the court. Now, you might be saying to yourself, that's absolutely ridiculous, Grant. It is. And I actually want to complete the circle for you because a lot of you are probably going to be doing this at a certain point. I want to show you exactly what it looks like. And then I'll take you through the we didn't get a lot of substance today. We got a trial date, but the biggest news is the change of location. Changes the dynamics. Yeah, the commuter rail is accessible. It's a little expensive. It's like $12 coming out of the fucking boonies or whatever the fuck you want to call it. All right, so we got a few more minutes together, and one of the things I want to do is I just want to one more time look at that street view, and then I want to walk around to show you like the final loop. So hold on, I got to drag the little man. There's like a little man you can drop. All right, there we go. Now we're back to where we need to be. Can you please just put me on the road? I just want to be on the road. They are just refusing to let me go on the road. Please just put me on the road. All right, here we go. Now, let me show you. I'll show you this. I'll show you the last part. I did not say close that. All right, this is a Travis-Mockery. I'm done. All right, the point is, it's complex. All right, it's complex. It's difficult. It's something that I would highly recommend people learn ahead of time before they go. Like, doing it is not the easiest thing in the world. Oh, okay, I got it back up. Hold on, you got to bring your comments back up too. We only have like 20 more minutes together before we see each other again at 7. And I will talk about the substance as well. I think that is important, but there just wasn't a lot of substance. Most of that hearing, if you missed it, was kind of the judge introducing himself. So let me just show you. So bringing us back, now see behind there, that's City Hall where we were before. If you kept driving straight after doing that loop-de-loop, You'll come up here. All right, now you're really nestled in the city. If you kept going down there, it's really beautiful. I think we're on Tremont, and you can see the Common, and it'll take you down into Chinatown. But what you want to do is you want to turn here, okay? Now you're really nestled into like an insider's corner of the city, and you can find the back way to the court. You take these stairs, you take this little turn here, that's the SJC, you take a right, you take a left, you go past the SJC, you're at Suffolk Superior. But you really, and if you want to really complete the circle, you can drive down here. Okay, now if you wanted to go over to Bowdoin or the State House or Beacon Hill, you must take this left. Don't fucking like, oh, you can't even go down there, but yeah, you have to take this left. However, if you look down there, that's the hill we were on before with the Peace Garden on the left. It might even let us go down it. Oh yeah, well. So there you go. You see how we went in a full circle, and now we're back to where we started. Driving with towel. That was probably the first time that I've ever taken someone on a real life tour of the city of Boston. It's really interesting. After that long day, I guess we can talk a little about the city of Boston. It's a really nice area. You really got to know, now that I think about it though, like I do have, it's not very big, but it's just weird. Like it doesn't have any cohesion to it. So like when you come up over here, right, like that's the State House, that's the back of the State House, that used to be a reservoir. You can do that, right? And you can kind of like cut through down here. You can jump down here, right? Now we're in Beacon Hill, but the backside of Beacon Hill, all right? You jump up here, you jump over here. Now once you're up in here, it doesn't seem like it, but you can actually get anywhere you want in the city because this is where all the rich people live. So any of these side streets will take you right down to where you want to go. Now what's really nice is when you get to Beacon, I think this is this Beacon? I don't remember which one. Yeah, Beacon. When you get to Beacon here, oh, the world is your oyster. You can take a left here and take a right up at the corner and then go anywhere you want in the middle part of the city. Or if you want to head towards the Fens or Chinatown and you want to do it, I don't recommend doing it. You really have to know what time of day it is. But you can head down Beacon if you have the timing. And heading down Beacon will let you come up to this intersection at the base of the Common. Now, this is also a way to make the world your oyster. It seems like a bit of a weird intersection because people can like turn left this way and then they're coming from this way and they're going this way. You just proceed straight. All right. Now, if you proceed straight through this intersection, you're going to come down through the lower part of the back bay, the coming into the filled-in part, and you're going to have a great choice here. All right. At this intersection, you can go straight. You can take a right here to get to 93 North. You'll go back on Sturrow Drive eastbound, or you can go straight and stay in the line of cars, and the next right will take you to Sturrow Drive westbound. You cannot get on Sturrow Drive westbound by taking the first right. Don't do that. It's very bad. Only do that if you want to go Sturrow Drive east to 93 North or south, or Route 1 north or south. If you want to go out to the suburbs, you must stay straight and take the second right, which is another block down. But the reason I say it's nice is you can then come around this part, all right? And this will take you around the Common, might even be the public gardens, and you can get anywhere from over here. Once you're over here on Arlington, you can head this way back up towards the State House and enjoy that part of Boston. Or you can head, you can't take a right there, but you can head into here, and then at any point in time from here, you can go, this is really the crossroads. This is where that red bow is now. Doesn't seem like the crossroads, but it is. You can go to like West Roxbury, you can go to Dorchester, you can go to Fenway, you can go out to fucking Chestnut Hill and Newton, or if you go this way, Chinatown's over there to the right. Over there to the left is going to kind of take you back towards the Ritz and then the Boston Common. This is really like, it doesn't seem like it, but it's the closest thing possible to like the crossroads. Like you'd think it's the Common and stuff over there, but it's actually right here. And the reason for it is you have to understand a little bit about the geographic development of Boston as a city over time. And in short, this area right here where the Ritz is, so that's the Ritz-Carlton. And it has apartments and like diplomatic offices and shit. It's a very nice area. But the point is, this was like the center of Boston. The Ritz didn't always look like this. It used to be this like, there was a different apartment or like complex. It was like a big square building, and then they knocked it down and built this. And this area right here, and it's kind of sad that it went away, but if you go down the front facade of the Ritz, which is like this whole thing, This used to be, this specific park used to be the view of Boston. This thing right here, you see this statue? Forget exactly what it's called. Oh, it's gone. There used to be a statue there. Anyway, so this statue, because this building wasn't here, this used to be the Playboy Club over here to the left. They knocked it down, built this thing. But you used to be able to see all, if you had the top office in the Ritz, you used to, and I think this is blurred because it's the Israeli consulate or something, but anyway, you used to be able to see Cambridge over there to your left, all of the Boston city skyline, everything. Now, this Motormark garage here is actually original, so this was there before the Ritz. You can still see the point of the garage looking out upon what was basically the central hub of Boston in the 19th, maybe 20th century, leading up to this sort of industrial development, this building here, etc., etc. So really, this sort of square here, it's all like messed up now. They really screwed it up. But this is the geographic heart of Boston. Like, imagine this building not being there, this red building, this building not being there, and then the MDOT building, this whole this red monstrosity to the left not being there. All that building not there, this building not there. From this point, if you go up 20 stories, you can see panoramically all the way from Cambridge to your left to the harbor on your right, including the whole city skyline. So this area I love very much. But yeah, there you go. That's the Towel tour of Boston. I know a lot about the city of Boston. What can I say? All right, so we got 15 or 30 more minutes together. What should we do? Should I answer questions? We're going to be back together at 7. Remember, this is not the end of your towel day. I had an espresso. That was a lot. Let's rewatch the hearing. All right. If you missed it, let's rewatch it. If you've ever read a good book like Great Expectations, you know what I'm going to say. You always get more out of a second watch. Towel computer struggling, so I paused my camera with a very stern look. All right, so what I'm going to do is I'm going to find for you, if possible, my own stream, and then we're going to watch that stream from when the hearing played, because I had the record of it. If you missed it the first time, this will be a replay of today's Aiden TurtleBoy Kearney hearing. That'll take us home. It was a relatively quick hearing. I think we were wrapped up in, 20 or so minutes, but I'll be shutting off this stream and then coming back with you at 7 p.m. Eastern, where I'll be doing a dual stream with Social Change Warrior. Very excited to have that discussion, respectful discussion about the facts. Now, you might hear me talking twice here.
For senior women who keep going
No, it was an ad. All right, hold on. I'm letting the ad play. It's weird to have double towel stream playing, so I got to go back to the start of the TurtleBoy hearing. Give me 1 second. The perils of me leaving my ad block off for all YouTubers, including myself, is that my channel, I guess, is one of the ones that runs unskippable ads, which is a good thing. If you get selected for that, it's a really good sign. But I got an unskippable 46-second ad. So I'm supporting myself. Thank you to YouTube for providing this platform. But wow, I didn't even know I was capable of getting those. Normally you get like the 5-second skip option. Nope, I got a full 46-second ad, which I'm pleased with. All right, so let's go to, hold on, I got to go backwards in the stream now. Everybody pause. Everybody pause. We got to go back to the start of the TurtleBoy hearing. If you missed it, don't worry. You're going to catch a replay. You don't even have to go back on the DVR. Once this is done, we are done for the day. Excuse me, we're done for this stream, and then we're back at 7 p.m. Eastern. So if you have appointment viewing with Towel, 7 p.m. Eastern, ladies and gentlemen, you get very special Friday night Towel. All right, let me bring it up for you on the screen. 1 second. There we go. Hey, double towel. All right, so let me get rid of... You don't need double towel. I think just one towel is fine. Triple towel. One time we had triple towel and like 47 animals. People loved it, but then other people were like, Grant, I really like your stream, but triple, like the animals, that's a lot. And I was like, it is a lot of animals. You're right. All right, here we go. You might not see the cap. I'm just going to turn the captions off. You can turn your own captions on. All right. And then this is from earlier, so you'll see 2 timestamps. Don't worry about that. It's from earlier. I'm going to go quiet.
Good afternoon. This is the Zoom for Norfolk Superior Court. This is Commonwealth versus Aiden Carney, 23 CR 313, 25 CR 88. We just ask people to remain on mute, and if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, Mr. Cosgrove.
Go ahead, Tim.
Mr. Bradley, you're muted.
Sorry, Your Honor. Hello, Tim Bradle for Mr. Carney, Your Honor.
Good afternoon, Mr. Bradle.
And Mark Betterow for Mr. Carney. Good afternoon, Your Honor.
Good afternoon, Mr. Betterow. Good afternoon, Mr. Kenny. Okay, folks, first time meeting, so let's have a brief before we get into the substance. I've noted from the docket on this case that there were already a couple of judges who recused themselves given past dealings. So I want to deal with that issue right up front and get that out of the way. I'll start with the parties first. I've never dealt with you, Ms. Betterow. This is the first time I'm meeting, so I don't think there's any reason for me to engage in any analysis under Rule 211 with regard to disabling prejudice. So I think we're clear on that issue.
We're good, Your Honor.
All right, excellent. I'm glad to hear that. With regard to Mr. Bradle, Mr. Bradle and I have known each other for more than 30 years. We tried cases against each other when he was with the Suffolk County District Attorney's Office, at least a couple, probably more, I don't remember, but there were at least one significant case against each other. During the time that he was a member of the defense bar and I was a member of the defense bar, we handled cases co-defendants, although cases went to trial. We certainly had a number of cases in which we represented co-defendants, at least through the motion stage. Outside court, we had a cordial, friendly, and cooperative relationship as members of the defense bar, but we did not socialize anywhere outside a legal setting. So, given our dealings, I'm certainly satisfied that I don't suffer from any disabling prejudice with regard to Mr. Bradle. With regard to Mr. Cosgrove, when he was Judge Cosgrove, I did appear in front of him a number of times. I really don't know how many times, but probably better than 25 or 30 times, I guess, as he sat in the various counties. I don't recall that he ever presided over trial that I did, but I know for certain that I did a number of motions to suppress and motions to dismiss with then Judge Cosgrove. There was nothing out of the ordinary in our relationship. It was purely a relationship between counsel and the judge at that time. We've never had any social contact except for in legal settings, and they're extremely minimal. Given that I took the seat that then Judge Cosgrove vacated, we were never colleagues on the Superior Court and never had any interaction on that level. And as I said earlier, we've never had any social interaction outside a few minimal contacts in legal settings. So I'm fairly comfortable in reaching the conclusion that I suffer from no disabling prejudice due to past appearances before, and certainly never did work with then Judge Cosgrove. With regard to the parties in the case, I've gone through the pleadings as much as I can. I've looked at the indictments. I've noted the names that seem to come up over and over. I'm familiar with none of these people. I've never met any of the civilians or interacted with them directly or indirectly who are involved in this case. As to members of law enforcement who are involved in the case, some of those names I have encountered, members of the state police, as well as members of the Boston police. I would add to that any dealings I had with them would have been as a criminal defense attorney, probably mostly seeking to undercut their credibility, but never had any personal dealings with them outside a courtroom, certainly no social dealings with them anyway. So I'm fairly comfortable in saying that I suffer from no disabling prejudice with regard to any of the parties who I've seen listed in the papers. The final issue, it is public knowledge that I grew up in Canton in the 60s and 70s and part of the 80s. I'm considerably older than all of the people involved in this case, so I didn't go to school with any of them, nor did any of the names, as I said, ring a bell for me. I lived in Canton, graduated from Canton High School in the early 80s, moved out for college, lived there intermittently through college and law school, and left there for the final time in, I want to say, 1990, to the best of my memory. May have used it as a mailing address after that as I cycled through some post-college apartments, but have not lived there full-time since the early 80s and have not lived there at all since no later than 1990. I don't have any contact with the town in particular, nor do I have prejudice for it, for or against any issues that might happen in that town, nor special knowledge thereof. So I'm comfortable in finding that I have no disabling prejudice as to my past associations in the 60s and 70s and early 80s with the town of Canton. So that being said, I'll go around the table and see if anybody has any problem with that, beginning with the defense. Any issue at this point with regard to disabling prejudice under 211?
No, Your Honor, and I agree with everything you said, and I appreciate the comprehensive rundown of everything.
Attorney Cosgrove.
I thank Your Honor for your thorough summary. Your recollection of our personal associations exactly coincides with my own. Having listened to your explanation of your associations with Attorney Bradel and your knowledge or lack of knowledge of the witnesses that may be involved in this case, I have no objection to Your Honor sitting in this case.
Okay, excellent. All right, so obviously I'm in Brockton. You guys are at different places. I'll give you my schedule going forward. Going forward, I'm assigned to Suffolk Superior Court. The first 6 months of the year, I'll be sitting in room 1008, which is a civil session. The second 6 months of the year, I'll be in room 808, which is a criminal session. I think at least for now, we'll work this out as we go forward, have a greater clarity as to how we can handle it. At least for now, for the next set of motions, which we need to get to, what we'll do is we'll do those in person in Suffolk Superior Court. What room that's going to be in, I don't know yet. The way Suffolk runs things, their civil clerks don't sit on criminal matters. There are two separate clerk's offices in Suffolk. They're very distinct in what they do. So either I'll bring the matter into 808 where there is a criminal clerk, or will perhaps be specially assigned to another courtroom. Sometimes courtroom 1309 is used as overflows. I don't know where we're going to be yet, but I can tell you that the next set of hearings will be in person in Suffolk Superior Court. So let's move on down the agenda. I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now. So, assuming, well, let me just say this. If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion or allowed it in some modified form to set up a taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team, and then at that point, the Commonwealth would get the information as approved by the court to go through it, and assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate, well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this. As I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download of 2 phones, which is in the Commonwealth's possession and which has been turned over to the defense. And there are other electronic devices which were seized as a result of the search. And that's what is subject to the ongoing taint team here.
And there's no conspiracy charge between Reed and Kearney in this case, correct?
No.
So presumably any evidence we have with regard to Kearney is going to come off his own phone, I take it.
Well, that's the situation now. I can't speak to what might be discovered in the process of the search. The conspiracy that's alleged in the search warrant is conspiracy to intimidate a witness. The charges against Mr. Kearney here include intimidation of a witness. So it could be relevant, although obviously no, if any conspiracy indictment resulted against Mr. Kearney, it could not be tried with the indictments here absent his consent.
Okay. So, Mr. Bradle, briefly, anything to add to that in terms of just what procedurally would have? I don't want to get into the substance of that issue. We can deal with it if we need to. But procedurally, you sort of think that's the way it would go?
Judge, we are interested in dealing with the disqualification motion first. Attorney Betterow filed a very comprehensive motion to disqualify Mr. Cosgrove. He's being sued by...
I'm going to come to that, Mr. Bradle.
Yeah.
Just want to make sure we understand the impact of Judge Krupp's...
Sure. Good. If I may, that, and I don't want to merge the motions, I understand what the court is doing, but that disqualification motion also includes the investigation involving Miss Reed's cell phones, because it is virtually the identical conduct and the identical facts that are from the 2023 indictments. And again, without merging too much of this now, there is a disqualification motion on the indictments before Your Honor now, as well as the investigation that Mr. Cosgrove is doing, because the same witness who is at issue in the disqualification was a primary or one of the primary sources that led to the warrant to go after Ms. Reed's phones. So they are kind of intertwined. And if Mr. Cosgrove is saying, as he seems to be suggesting, that he can't predict the future in the event that he were able to search the phones, but if evidence were to be discovered and lead to a conspiracy indictment against Mr. Kearney, that implicates the disqualification issue. At this time, I'm unaware that Ms. Reed has joined that motion, so I don't want to speak for what her counsel would advise, but to the extent Mr. Kearney is involved in anything to do with what we're calling the open investigation involving Ms. Reed's cell phones, we think that the disqualification as it relates to Mr. Kearney needs to be dealt with in the first instance.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did up until the point where...
I'll get to that. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come. And what Attorney Cosgrove chooses to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later. And it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
All right. So how soon would we be ready to deal with the issue of disqualification?
Judge, I just wanted to throw out some dates if I could. January 12, 13, or 15 is what we're proposing.
Okay. Does that work for you, Attorney Cosgrove?
No, I'm out of the country on all of those dates.
Okay. How does now, Mr. Bradley, you've got some other business that's going to happen up in Essex County. You're scheduled for trial up there?
That's February 9th, Your Honor. That's correct.
Mm-hmm. How soon before that are you going to?
Your Honor, I could, give me a moment.
Hold on, Attorney Cosgrove. Mr. Bradley, how soon before you become unavailable due to that trial?
Judge, I'm pretty flexible. I really don't want to delay the disqualification too much. I mean, unless Attorney Betterow has a different view, I'm thinking, can we do it a little sooner then?
No, I want to wait till I get to Suffolk.
Okay. Oh, I understand. Maybe is it? Should we do maybe the third week in January?
Let's see what Attorney Cosgrove has to say. What's good for you, Attorney Cosgrove?
That's fine.
Let's pick a Friday, late January.
That's the 23rd.
Attorney Cosgrove?
I can do the 23rd.
Mr. Bradle?
Yes, thank you, Your Honor.
All right, so we're going to mark that up for January 23rd. I'll be in touch with regard to time and place. I need to talk to Suffolk to see where they can accommodate me. I'll know that certainly by early January, what courtroom we're going to be in and what time. My inclination probably would be maybe a noon or a 2 o'clock hearing. I don't expect it's not going to be non-evidentiary, I take it, correct?
Correct.
Initially, at least, yes.
That's the way I read it. So we could probably get it in the afternoon. So it'll be either noon or 2 o'clock that will deal with that matter in Suffolk on, we'll call that 123 for now.
And I think, Your Honor, if I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's motion to dismiss the case.
That seems to be the right step to me as well. How does that sound to the parties?
Yes, we wanted to bifurcate the disqualification from that. Absolutely.
I think that's the right choice. Okay, so do we want to get that on the calendar now, or do we want to wait till the disqualification is done?
I think it makes sense to wait, but I'm at Your Honor's disposal.
We can wait because I'm pretty flexible when I schedule things in Suffolk. Okay, we'll wait on that issue. Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drabs without, as far as we can tell respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks, we're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove in his motion seeking an extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else. That would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control, and we haven't received that.
I don't know who you're talking about.
Jennifer McCabe.
Okay. Mr. Cosgrove?
I will look into that as to Mr. Bettero's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday, if the post office can be believed. Does include materials that I received from Mr. Bettero, notably a grand jury exhibit that they recently complained that they, I'm sorry, received from Mr. Mello, not from Mr. Bettero. Notably a grand jury exhibit that the defense complained that they had never received, that was not in my possession or in the possession of the state police. And I finally managed to get it from Mr. Mello, who had that particular exhibit. So they'll be receiving that and some other materials from Mr. Mello.
Okay. All right. Well, if there are particular issues that need to be addressed by the court, let them know. We can get together quickly in Zoom and deal with them.
Judge, I think there are, and respectfully to Mr. Cosgrove, Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything, so we don't have to rely upon Mr. Mello to discover grand jury exhibits for 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I'm going to leave the details of how Attorney Cosgrove complies with Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible. Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradle, Mr. Bedroff?
It's a little premature for us, Judge. We're sort of baking the cake right now, and we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things because they are all the same folks, and it seems like this case, in terms of evidentiary, the acts themselves, I don't want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
it's a very fair characterization, Your Honor. there's a bit more to do on the newer indictment. We don't have grand jury minutes even yet. And
I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Carney?
No, it's Carney, Your Honor.
Carney, I apologize.
Okay.
So, look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done. Now, how long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be, on behalf of the Commonwealth, a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we've got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
Sound about right, Mr. Bradle?
I think so, Your Honor.
When do you folks think would be a good time to try it? I'm not going to hold you to this. I just want to start sketching out in my mind when and how we're going to do this.
Judge, on the 2-week thing, are you saying full days or half days?
I'll go full days.
Okay, that'd be fair.
Any thoughts on when we could do it? The only time let me just block this out. I'm supposed to do an asbestos trial in June. That's going to take just about a month. So June is going to be out completely for me. So, work in terms of our calendars, just sort of scratch that one off.
Judge, it's a tough call in light of how much stuff we still have to do. It's a tough call. I mean, I could see this not going until the fall, mid-fall. There's just so many. This taint team stuff takes forever. We haven't even gotten any automatic discovery on the second case yet. We're still waiting for a grand jury minutes. There's a lot of extraordinary motion practice here. Disqualification, dismissal for extraordinary government misconduct. Discovery, as my brother said, is dribs and drabs. We have this prosecutor who's very ill, apparently, who's no longer on the case. He's been disqualified. Attorney Cosgrove's been disqualified from the 24 indictments, which have now been dismissed. There's just so much going on in this case. It's not your garden variety situation. And I think we really are realistically, if you want to put a cap on it, I think the cap has to be, mid to late fall, because we're just not going to get all this stuff done. It's been historically glacial pace.
I got you. And I don't have a problem with that. Mr. Cosgrove, how does that fit with your timeline and your availability?
Well, my availability is pretty open. As far as timeline goes, I don't associate myself with all of Mr. Bradle's comments. I agree with his bottom line. This is a complicated case in some respects, with quite a bit yet to do and a lot of contingencies. And obviously, if Your Honor allows the motion to disqualify me, it won't be my problem, but that will certainly have an effect on the timing of any trial.
Well,
as well. I will say,
let me just slow you down for 1 second. The disqualification, as I can tell, is only on the 23 case. Is that accurate?
it is accurate, Your Honor, but if you disqualify me in the 23 case, it wouldn't make any sense, as far as I'm concerned, for me to try the one incident on the 25 case. I would respectfully ask the district attorney to relieve me of that responsibility.
Well, let's not go there yet. Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November, maybe November 9th, 16th, December 7th? Any of those?
I can pretty much make those dates work. And I've checked with Suffolk, but we have flexibility here. Okay? So if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have access to that docket right now. But pencil yourself in for around that time. And we'll pick this up once we get through the motion to disqualify, which will be on the 23rd. Okay? So, but let's try to work our way towards that date, and get this thing in front of a jury and get it resolved one way or the other. Okay? What else can we
do? Your Honor. Thank you. I think that's everything on your agenda, Your Honor. I was following along on your scheduling order.
Mr. Cosgrove, anything else?
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to...
All right, and then they just deal with digital filings. Okay, so my name's Grant Smith Ellis. Now, listen, we have 7. I have to go at 3:58, but here's the thing. If Social Change Warriors is still here, we're going to talk about this tonight. Now, Social Change Warriors, would you mind? I think we might. I don't want to dictate topics. I want you to talk about whatever you want. I want to be able to just discuss the topics and go on whatever we need to talk about. But I think, if you don't mind, we should do a section on, one, we have to distinguish between our moral judgment of an action and the law. And I'm not saying I like the law or I don't like the law. I just tell you, in my opinion, as a lay towel, not a lawyer, none of this is legal advice, what the law says. So you can't meet the Brandenburg test, okay, for it, inciting imminent lawless action unless you are encouraging violence, okay? If there's another way to meet it, by the way, if your group gets declared an unlawful assembly, and then what happens is the police come through the crowd and say it's an unlawful assembly, disperse. If you don't disperse, okay, then maybe you can get charged with rioting. You cannot, not legal advice, not a lawyer, you cannot riot by marching down the street and saying things, okay? Even if you are saying over the microphone, advocating violence. I'm telling you, that was Brandenburg. I don't love it. It's not my law. I didn't write it. It's the decision. You can march down the street saying very, very pushing the line things, even openly espousing certain things that most of society would say, what are you saying? As long as you do not meet that two-part test, the speech has to be directed at inciting or producing imminent lawless action based on violence, and the speech has to be likely to incite or produce such action. Okay? So there's a very high bar. If you don't meet that bar, we're not talking about rioting. Okay? You might be talking about an unlawful assembly but they didn't have that here. Based on the facts, they didn't get declared that. So we have a lot to talk about, and I would love to talk about a lot of it. And also, yes, we're dealing with state law as well. Now, my name is Grant Smith Ellis. I have exactly 4 minutes to do my closing, so let's do it. Very interesting day. I'll see you again around 7 p.m. Eastern for the discussion with Social Change Warriors. Thank you all very much for being with me today. My name is Grant Smith Ellis. I don't need to do a full closing. I'm going to see you again later today. But thank you for all your support, all the camaraderie, discussion, respectful debates in the chat means a lot to me. This is a public information service. We've been going for 8 hours. If you've learned something today, if you benefited from this stream, if you appreciated that this public information service provided the feed of the hearing in the TurtleBoy case plus the replay, you are able to donate and help Towel. Thank you to the people who sent over donations. I can't wait to read them all individually after I get off stream. For now, though, I'm off to the Towel doctor. It's virtual. That's why I have to do a hard stop so I can make my appointment. In any event, I also close the stream in the same way every day, which is I like to say if you learned something today, if you benefited from this public information service designed to educate, inform, and entertain the wider public, such as to use entertainment as a hook to ward off the usurpation of our representative forms of government worldwide by cogent public discourse, then there's a way that I think you can pay it forward. Subscribing to the channel is great. Being camaraderous is great, if that's a word. Showing camaraderie, being friendly with each other, making new connections, learning new things. But if you really want to pay it forward, you know what you can do? Look for reasons to do small acts of service, ladies and gentlemen, based on kindness. Look for reasons to donate to your local homeless veterans initiative. Not one veteran in this country should be homeless against their will. If we have one such person, we have failed. They want to live in the woods, we're not going to stop them. But none of our service members or veterans should be homeless against their will. All right? They helped us. We can help them. Now, what if you like animals, like Pete Bunny Towel? He's sleeping. Pete Bunny Towel says you can donate to animal shelters run by veterans or that help veterans. That's a good way to help animals and veterans. Or you could donate to animal shelters in general. Good way to help animals. Or, ladies and gentlemen, you could donate to The Big Issue if you live in the UK. That's a great way to help homeless populations in the UK. Now, you could also do something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while, or even donating to 100 tomato plants like Francis Furtrell did that one time and having them designated honorary towels forevermore. Yes, in that way, ladies and gentlemen, I truly believe it's possible that we can bring about are Towel Eudaimonia or Summum Bonum in the ancient Greek or the Latin, respectively, and therein change the current realpolitik from one centered on preserving, expanding, and demonstrating our power to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service based in unconditional love. And in that way, may those small acts of service and kindness ripple outwards and bring about a new digital epoch defined by Aquarius the water bearer standing tall and carrying a towel. I believe it's possible because of you all. Towel loves you all very much. I'm sorry we have to end on such a hard stop today, but Towel doctors take precedent. Towel friends on the X, all 9,000 of you today, thank you very much for watching. We'll be back on probably Wednesday. All right, I have a final. All right, it is on Tuesday. I am excited to take it. I'm going to pass it, and I'm going to do well. I just got confirmation taking my final. I'm very excited. Thrilled to have that opportunity. Now, my name is Grant Smith Ellis, Towel Friends on the X. I'll see you at 7 p.m. Eastern. Don't be late. Social Change Warriors and I will have a great discussion. Bring your questions, bring your towels, bring your smiles, bring your Friday night popcorn. I'm looking forward to it. All right, God bless you. Join us again probably mid next week. My name's Grant Smith Ellis. Until we see each other again, Towel loves you very much. Find me on social media, youtube.com/@Grant Smith Ellis, x.com/Grant Smith Ellis. Towel loves you all. Towel friends on the YouTube, I have to be very truncated. I have 1 minute and 15 seconds till my doctor. Towel loves you all very much. If you won't be live later, that's all right. We'll see you next week. God bless you. Thanks for being with me. Thanks for watching today. Towel loves you all dearly. Appreciate all the discussion. You all help me learn things. I hope I do the same for you. And so I don't arrive late for my doctor's appointment, I gotta go. My name's Grant Smith Ellis, and Towel loves you very much. God bless. Be well. Have a great Friday. See you in a few hours. 7 p.m. Eastern. Towel.